Good morning. Thank you all for being here today at the 2019 Wyoming Healthcare Compliance Bootcamp. I'm Brad Cave. I'm a partner of Holland and Hart here in the Cheyenne office. And again, I welcome you, and on behalf of all of us here in Cheyenne and across the firm, we thank you for your attendance today. I want to especially thank our sponsors today, Cheyenne Regional Medical Center, obviously supporting this event in a huge way. We can thank Cheyenne Regional not only for the space, but also for the refreshments and the lunch that we will enjoy later on. Leading Age Wyoming and Wyoming Hospital Association are also co-sponsors of our event today, and we thank the folks over there, obviously, for their 24/7, 365 support of Wyoming hospitals and long-term care facilities, and also for their support of this event, this second annual Wyoming Healthcare Compliance Bootcamp. I'm really proud to tell you a little bit about the speakers today. My partners, pardon me. My partners, Kim Stainer, Christy Kimball, and Rich Spildy will speak today along with me. You've got the agenda, so I won't go over the agenda in any kind of detail. Kim is from our Boise office, and many of you, I think, have listened to his healthcare podcasts or looked at his email columns, his blog postings and things like that. Kim is, I think, perhaps the best known healthcare lawyer in the Rocky Mountain West. If there was a kind of a rock group thing for healthcare lawyers, he'd be one of the traveling Wilburys, you know. And so he has that kind of profile around the West. He's been practicing in healthcare for more than 20 years. He represents health systems all around the nation, working on everything from provider contracts to regulatory compliance to Medicare, Medicaid issues. Christy Kimball is a partner in our Salt Lake City office. Christy went to law school after a 15-year career with Pfizer, and she actually would come to Cheyenne Regional on behalf of Pfizer. And so she brought that experience, went to law school, and has now practiced in Salt Lake City for, 10 years maybe, Christy? And is the newest addition at the partner level anyway to our healthcare team. Rich Spildy is a technology lawyer in our Boulder office who has an emphasis and experience in helping healthcare clients with EHR contracting, with cybersecurity, with breach response dilemmas, and he'll be here this afternoon to talk about cybersecurity issues in healthcare. For those of you who are out there in internet land, thank you very much for signing up and for joining the webinar. If you have questions during the course of our presentation, please send them to one of us by email. Our email addresses are on the last slide of every presentation. So feel free to send those questions to us. We'll respond to you. We won't respond in the course of the presentations, obviously, but we will respond to you and get back to you on your questions as we go along. If you have questions here in the room, please follow the traditional means, wave the hand, and we'll field your questions as we go here in the room. I want to thank some folks here at Cheyenne Regional for all the help in putting this on. Joanna Velos made this all possible for us, of course. Her assistant Avery Yak was instrumental in making sure everything happened today and all the details of this. And then from the IT support group or IT folks here at Cheyenne Regional, Greg Martin and Kevin Smith made sure we could speak to all the people around the state and outside the state who are participating by webinar. And just so you know, that's a big deal. There are maybe 30 of you here in the room. There are 90 people participating by webinar. So we really appreciate the support of Kevin and Greg and their team here at Cheyenne Regional. So with that, I'm going to sit down. I'm going to ask Kim Stainer to come up and kick us off today. Kim.
All right. Hopefully you can all hear me. Kevin says that we're good. Traveling Wilburys. I haven't heard that name for a long time. I'm not sure. I wish it was like maybe Adam Levine or somebody like that who's a little bit more cool, but you know, that's the life I live, I guess. All right. A little bit of background, a little bit of preliminary stuff. I think Brad may have mentioned it, but they are actually recording this webinar. So by all means, feel free to ask questions. Just don't disclose anything, you know, that you shouldn't be disclosing in here, right? Or you don't want it to be used against you. Let's talk first about the fraud and abuse laws. This is where I spend a good portion of my time on these fraud and abuse laws. For those of you who've been following such things, how long is the Medicare trust fund supposed to remain solvent? The latest estimate. Like 7 years. At least when I looked earlier this year, that was the estimate. So the bottom line is, look, the government spent a lot of money on health care, and they're going to run out of money. And therefore, to the extent they can, they want some of their money back. And so they're coming back after you guys with a vengeance in order to recoup any money. The latest statistics I got from last year, in 2018, they recovered $2.5 billion from healthcare fraud and abuse, those types of things. That's a lot of money. Now, granted, that's a very small fraction of the total amount that they spend. But this next statistic I thought was interesting. For every $1 the government spends on enforcement, the government recovered $4. What does that mean? It means it's a money-making deal for the government, right? They haven't got any incentive to go away from pursuing fraud and abuse actions anytime soon because it's profitable for them. They get some of that money back. Now, if that's not bad enough, the government has upped the ante on that. In the last couple of years, they've doubled, and in some cases tripled, the fines and the penalties that can be assessed against healthcare providers for violation. And what's really bad is you now must mark on yourself. In the wake of the Affordable Care Act, they removed all that and said, now, if you've received an overpayment, it's money you shouldn't have gotten, you've got this affirmative obligation to self-report. Not only that, but the Department of Justice, a couple of years ago, Sally Yates, you remember Sally Yates? She became famous because Trump fired her when she refused to enforce some of his immigration stuff. But before she was fired, on behalf of the DOJ, they had issued a memo, a famous memo called the Yates Memo, in which they said basically, look, fraud and abuse is very important to us, but we're concerned because corporate liability, people aren't taking corporate liability seriously enough. The CEOs, the administrators, those people who run the corporations, if the corporations are held liable, fine, the corporation has to pay money back, but that doesn't affect their bottom line, right? And so what they've said now is the DOJ has a focus on the individuals, not just the corporations, getting the money back from the corporations, but going after the people in the C-suite that are making those healthcare decisions. Now, they ratcheted it back a little bit that in the wake of Sally Yates' firing, but still there's this enforcement mandate so that you as individual healthcare entities, you as individuals who are making these kinds of decisions, you've got to be concerned also about your own personal liability. So hopefully that doesn't make you stay up at night. So these are the things we're going to talk about today, those primary fraud and abuse laws. Let's start with the False Claims Act. The False Claims Act is kind of like the fundamental vehicle for the government coming after you guys. The government, or the False Claims Act says that you cannot knowingly submit a false claim for payment to the federal government. And in the wake of the Affordable Care Act, you must report and repay any overpayment within 60 days after discovering it. So it's not only you can't submit it, but also if you submitted it not knowing that it was a false claim, not knowing that there was anything problematic with it, but you subsequently learn, you've now got this requirement that you've got to affirmatively report and repay. It's not finders keepers. Well, what are the penalties? Well, at the very least, you've got to repay the government plus interest. In addition, you can get set up with civil monetary penalties of approximately $11,000 to $22,000 per claim. Now, that's per claim. That's not per, mistake we made. That's per claim that was submitted to the government. I'll talk more about that in just a minute. In addition, you can get set up with treble damages, and you can be excluded from Medicare or Medicaid. You might think that's a good thing. But if you're excluded from Medicare or Medicaid, like we'll talk about later, that's kind of the death knell for working in the healthcare industry. In addition, you can be subject to key TAM litigation. Do we need to know what key TAM litigation is? Outside of Joanne? Yeah, what's key TAM litigation? That's right. That's when a private person, a key TAM relator, they sue on behalf of the federal government. And then if they win, they get a percentage of those fines and penalties. Think of them as kind of like Dog the Bounty Hunter, right? They're bounty hunters that they can come after you. And that could be disgruntled employees, that could be competitors, That can even be consultants that maybe you don't hire, or they come in and they find something. So there's this incentive. A lot of times, the big ticket items, they're not found by the government, they're found by these PTAM relators, and they'll bring those suits on behalf of the government. Case in point was the Tooney case out of South Carolina. This was a situation where the hospital decided to do some arrangements with some physician practices, and it was ultimately determined that they violated START. Well, under START, they had to repay, from the obligation to repay the amount. In addition, under the civil monetary penalties law, they get treble damages on top of that. So they had submitted $39 million in claims they were in a profit. Then you multiply that by the treble damages, that comes out to about $117 million. In addition, under the False Claims Act, because they submitted claims that violated, in violation of the law, so therefore they get False Claims Act penalties. That was back in the days of $5,500 per claim. You multiply that out, that's an additional $119 million. The bottom line was a $237 million judgment because they structured these contracts improperly. Now, the good news, I guess, for the hospital is they ultimately settled for $72 million, although most hospital administrators wouldn't necessarily think that that's good news, $72 million. The key TAM relator received $18 million out of that. So I guess if you want to fund your retirement and you know something's going on at your employer, then maybe that's the way that you do it. Now, none of you would knowingly submit claims to the government that are false, right? You guys are good people, you'd never do that. But it can arise in situations where you wouldn't normally expect a false claim. For example, it could be claims for services that were not provided or were differently claimed, failure to comply with the quality of care. Because when you're submitting that claim, Medicare only pays for claims that, medically necessary services. And if you're submitting a claim that didn't comply with the standard of care or that wasn't medically necessary, then that is a false claim because you certified that it satisfied the requirement. In addition, if you fail to comply with relevant regulations that materially impact reimbursement, when you're submitting that claim, you have this implied certification that this claim satisfies Medicare requirements. So if your claim doesn't satisfy those requirements, the regulations that are associated with that claim, then the government has said, well, that's implied certification. You submitted a false claim, and therefore we can go after you for that. That was upheld in the U.S. v. Escobar case a couple of years ago out of the Supreme Court, so that there is this implied certification theory. Now, the good news, though, is that, the Medicare regulations for this stuff is really small. Only 5 or 6 regulations, right? No, you've got claims manuals that are like a foot thick. So it really is potentially problematic. The bottom line is you have to be really careful. All right, now that's with the feds. The state, Wyoming, also has its own False Claims Act. It says that you cannot knowingly submit a false claim under the Medicaid program, so it's limited to government programs. You cannot benefit from the inadvertent submission of false claims after you discover it, so you've also got this report and repay obligation to Wyoming Medicaid. What are the penalties again? Repayment, treble damages, civil penalties of $1,000 to $10,000 per violation, the cost of litigation. If there are some provisions, at least under the Wyoming Medicaid Act, that they can cap that damages if you respond inappropriately. You have to not only be concerned about the Wyoming Medicaid regulations, you also have to be concerned about the Department of Health regulations. They've got additional requirements in there that they come after you for things like misrepresentations of coding and the like, and they've got broad authority, the Department of Health and Medicaid, to come after you to recover overpayments and impose other penalties. All right, that's the False Claims Act. Let's talk about the Anti-Kickback Statute. The Anti-Kickback Statute says you cannot knowingly, willfully offer, pay, solicit, or receive remuneration to induce referrals for items or services covered by a government program unless you structured that transaction to fit within regulatory safe harbor. What happens if you do that? Well, big penalties. The Anti-Kickback Statute is actually a felony, right? False Claims Act, you just have to repay a bunch of money. Under the Anti-Kickback Statute, you can actually go to jail. And they recently doubled the penalties for that. Now you can go to jail for up to 10 years. $100,000 criminal fine. In addition, you can get a $100,000 penalty. It's a false claim, so you can also get treble damages. And you can be excluded from, in fact, it's automatic exclusion from Medicare and Medicaid if you engage in anti-kickback. In addition, under the Affordable Care Act, they now say that the anti-kickback violation is also an automatic violation of the False Claims Act. What does that mean? Well, that means, anti-kickback statute. For those of you who watch the O.J. Simpson stuff, right, he got up on the criminal statute, but they got him on the civil statute, right? Why? Because the burden of proof is different, right? Under the criminal statute, what is it? Beyond a reasonable doubt. Under the civil statute, it's just preponderance of evidence. So the bottom line is it makes it easier for the government to go after you for violation of the anti-kickback statute. Then you can get hit up with all those false claims ads. Now, that's pretty scary stuff when it comes to the anti-kickback statute. But who does the anti-kickback statute apply to? Who does it apply to? Is it just physicians? It applies to anybody. Nobody can do this. It could be marketing people. It could be attorneys. It could be hospital CEOs. It could be anybody who's involved in any one of these kickback schemes. Now, does it only apply to the person who receives it? No. It applies to anybody who solicits, who requests it, who gets it, who gives it. It can apply to anyone. It's very, very broad. Now, there is some good news. It only applies to inducements to refer items or services that are payable by federal health care programs. Okay? That would be Medicare, Medicaid, those types of things. So if it's purely a private-based situation, then it may not implicate the anti-kickback statute, although you have to be careful about those for some reasons we'll talk about in a minute. Now, note that it only applies if you knowingly and willfully offer, pay, and solicit. Note that that's not that you knowingly and willfully violated the law. It doesn't matter anymore whether or not you knew that what you were doing was a violation. It just means that you did the act, right? Now, because it's intent-based, it's possible that you just don't have the proper intent and you didn't violate the statute. If you do structure, because it's so broad, the government has implemented certain regulatory safe harbors. So if you structure your bill to fit within these regulatory safe harbors, then you'll be fine. Now, if you don't fit within the safe harbor, it doesn't mean you necessarily violate the statute because, again, it's intent-based. But at that point, if you don't fit within the safe harbor, then the test becomes, is one purpose of doing your deal to generate these improper referrals or to induce referrals? So it still goes, it devolves this one purpose test. Now, the problem with that, of course, is it's kind of difficult to defeat that one purpose test. I mean, how do you prove that, gee whiz, I was paying this cardiologist, $1 million a year, but I was just doing it, not one purpose had to do with the fact that he was referring a bunch of stuff to our facility. It's kind of a hard standard to defend against. All right, so the bottom line is anytime you want to give or receive anything to induce or reward referrals or do any kind of a deal with a referral source, if they're going to be referring Medicare, Medicaid, and the government healthcare business to you, the alarms ought to go off, like Lost in Space, danger, Will Robinson, danger. You need to be thinking about the anti-kickback statute. It applies to any form of remuneration, anything about it. It's not just money. It could be money, it could be free or discounted items or services, it could be overpayments or underpayments. You contract with this particular person to provide the services, but you're paying them above fair market value. The government comes in there and says, well, that amount that you're paying above fair market value, that's for making the referrals. It could be payments for items or services that are not provided or for items or services that are not necessary. It could be professional courtesies, waivers or co-pays or deductibles, low interest loans or subsidies, business opportunities that are not commercially reasonable, any other freebies or discounted things that you might make, anything of value. It's incredibly broad. The government has, fortunately, given us these safe harbors. So if you structure your deal to fit within this particular requirements of these regulatory safe harbors, then you're safe, right? The problem is we don't have safe harbors for every potential transaction that's out there. In addition, it's kind of hard to satisfy a lot of the safe harbors. Now, the closer you come to satisfying the safe harbor, the safer you will be. But the only way that you can get protection is to structure the deal to fit within the regulatory safe harbors. So Christy, Brad, and I, we spend a lot of our time structuring deals in order to fit within those regulatory safe harbors. If you can't fit within a safe harbor, you can go to the government and you can ask them for an advisory opinion. We want to do this deal. We don't know whether it'll comply. Will you tell us whether you'll come after it if we do? And the government publishes those on the government's website. Now, those advisory opinions, they're only binding on the parties to the opinion, okay? So somebody else who's not part of that doesn't necessarily get a free pass. But if you structure your deal within an advisory opinion that's been approved in the past, chances are you're going to be okay. So if you're analyzing a deal, you can't fit within a safe harbor, the next best thing is to go to the government's website, look at the advisory opinions that have been published in the past on that type of a transaction, and see if you can structure your deal within the safe harbor. All right, that is the federal anti-kickback statute. Did you know that Wyoming, as of last year, right, Brad, 2019, Wyoming now has its own anti-kickback statute. It prohibits a whole bunch of different stuff. Most importantly for today, It says that the person shall not knowingly, in whole or in part, refer an individual to a provider for the provision of a service or supply for which payment may be made in whole or in part under Medicaid and solicit or accept anything of value in connection with the referral, i.e., can't get kickbacks, can't pay remuneration in order to get referrals for items or services that are payable by Medicaid. What happens if you do? Well, it's a felony, up to 5 years in prison, up to a $10,000 fine, and you can be excluded from the Medicaid program. Now, under the federal anti-kickback statute, you've got those safe harbors, right? What about under the Wyoming Medicaid Act? Do we have any safe harbors? Not yet. You may want to look at those and see whether or not you can get some safe harbors in there. I'm assuming that, you know, the Wyoming regulators, they're all reasonable people and they would never come after you for anything unreasonable. But be careful. Bottom line is you got to be aware of that too. All right, another new one. You know, that opioid epidemic out there, the government, it was real hot and the government, you know, passed this legislation dealing with opioids. Among other things, they passed the Eliminating Kickback in Recovery Act, okay, that goes along as part of that opioid legislation. That new statute says that you cannot solicit, receive, or pay or offer any remuneration in return for referring a patient to a laboratory, recovery home, or clinical treatment facility unless the arrangement fits within a regulatory exception. It's kind of like the anti-kickback statute, right? Only this applies to laboratories, recovery homes, or clinical treatment facilities. Now, most of you guys, you probably don't own those, except some of you may have labs. Now, I wanted to bring this up because remember that the anti-kickback statute and the Idaho Medicaid anti-kickback statute, those only apply to government programs, right? ECRA, what does it apply to? It applies to any program, including private pay programs. So the bottom line, for those of you who operate labs, don't go anywhere near offering any kind of kickbacks or incentives or marketing perks and those types of things to generate referrals for labs. If you do, you could violate ECRA. And the penalties under ECRA, $200,000 criminal fine and 10 years in prison. Okay? There are very, very limited exceptions. We don't have regulations yet implementing ECRA. This was one of those things that the government, you know, pushed through before we healthcare lawyers had a chance to see it or comment on it or, you know, raise the red flags like, you can't do that, you got to be careful. So now it's out there on the books, and the government can come after you with very few safe harbors. So be careful about that, especially if you're in a situation maybe where you're paying employees, you're paying them to make referrals to you or getting some kind of commission-based referral based on labs. Well, that may be okay under the anti-kickback statute, but it's not going to be okay under ECRA. All right, that brings us to the Stark Law. The Stark Law is actually the Ethics and Patient Referrals Act. It helps to understand a little bit of Stark because there's a lot of misunderstanding about that, which is good for me because that's how I put my kids through college. But Stark, it helps to understand kind of what the basis was. Back in the late 1980s, remember what was going on in healthcare? We switched to like prospective payment systems, and the government was reducing the income to the payments to physicians. Well, what did that cause physicians to do? They had to look for other sources of income, right, to supplement their regular practice. Well, the government started seeing that they were getting a whole lot more claims for like labs, for things like imaging services, and the government said, why are we getting so many more claims? They started looking into it, and they started seeing that these physicians have ownership interests in labs or in MRI centers and those types of things. And they said, the reason we're getting more claims is these physicians have an ownership interest. Now they have a financial incentive to make referrals over to those things, and that's why we're getting more claims. So Representative Pete Stark from California says, well, we can put a stop to that. So the Stark Law says that the physician or a member of the physician's family has a financial relationship with another entity. That physician can't make referrals to that other entity for certain designated health services that are payable by Medicare and Medicaid. And if he does make an improper referral, that other provider, like a hospital, can't submit claims to Medicare for those referrals that that physician made, for the services that were provided for those referrals. If they do, then you can get hit up with fines and penalties unless you're structured to deal with it within a regulatory safe harbor. Now, Stark doesn't prohibit the financial relationship. It just says if there is a financial relationship, physician, you can't make referrals to that entity, and entity, you can't bill the government for any of the services that were provided, unless you've structured the deal to fit within regulatory safe harbor. What happens if you do it? Well, civil penalty again. No payment for the services that were provided for an improper referral. In addition, you have to repay any payments that you did receive improperly within 60 days. If you fail to do it within 60 days, repay that within 60 days. Criminal or civil penalties of up to about $25,000 per claim submitted, or $164,000 per scheme if you're trying to get around Stark and do something squirrely. Okay, that's subject to a cost of living modifier, so it's going to continue to raise every year. In addition, if you've got a Stark violation, there's a good chance you've also got an anti-kickback violation, which probably means that you can go to jail. In addition, you're also going to have a False Claims Act violation, so you can get hit up with all of those other penalties, just like those unfortunate hospital CEO in the Toomey case found out when they had to pay $72 million. So, any financial relationship or item of value between a physician or a member of the physician's family and a provider of designated health services, you've got to make sure that you structure that deal to fit within Stark if there's going to be any kind of referrals from that physician. Now, remember the anti-kickback statute? Who does it apply to? It applies to anybody, right? Stark only applies to physicians, only applies to referrals from physicians or financial relationships with the physicians or members of the physician's family. Physicians are MDs, DOs, oral surgeons, dentists, podiatrists, optometrists, and chiropractors, family members, spouse, parent, child, sibling, step-parent, stepchild, step-sibling, grandparent, grandchild, or in-laws. Okay? Now, what does Stark do? Stark says, well, if you've got that financial relationship between the physician and the provider of designated health services, that physician can't make referrals. Well, what are referrals? Referrals are any kind of order for services. It's basically anything that that physician is ordering or referring or recommending. It is not services that the physician personally performs. If they personally perform the services, they're not referring, okay? So, for example, it's not a referral for a physician who has a contract with the hospital to provide the physician's own pro fees. It would be a referral, though, for all the facility fees or the tech fees that he would, or if he has like a mid-level performance service. Those types of things would be referred. All right, that Stark law also applies to any kind of financial relationship. It could be a direct financial relationship. It could be an indirect financial relationship. So, for example, if the physician has an ownership interest in this group, and that group has an ownership interest in this other entity, and that entity has the financial relationship with the hospital, that still may trigger Stark, direct or indirect. It could be ownership arrangements. It could be just compensation arrangements. Anything of value, again, anything of value between the hospital and that physician is going to implicate Stark. Now, it only applies to certain types of services. Remember the anti-kickback statute? It applies to any items or services that are payable by federal health care programs, right? Stark only applies to certain types of designated health services. Remember, those kinds of things that the government was concerned that physicians might have an ownership interest in. Okay, but it would include inpatient and outpatient hospital services. You who are with hospitals, that's the most important one. But it's also outpatient prescription drugs, clinical labs, PT and OT, speech therapy, home health services, radiology, and so on. Now, because Stark is very broad, the government also has come up with certain safe harbors. Certain safe harbors apply to both ownership and compensation arrangements, the most important of which is for you, those of you who are with physician groups. There are certain safe harbors that apply to referrals within the group. Okay? Would Stark even apply there? Yeah, you've got a physician who has a financial relationship with his group, right? So Stark would apply to the referrals even within the group. But if you structure your group properly to fit within Stark, qualify as a group practice under Stark, then those referrals within the group do not, is protected by a safe harbor. Other exceptions apply to ownership or investment interests. Okay? The most important of this is rural providers. If you are a healthcare provider in a physician in a rural area, then you can go ahead and have that ownership interest in the MRI or in the lab, and you can make referrals. The theory there was that in a lot of these rural areas, the physicians are the only ones who are going to invest in those things. If we prevent the physicians from making money from those investments, then they're never going to build them, and you're not going to have those services in this rural community. The ones that you will probably deal with most are the compensation arrangement exceptions. There are exceptions that apply to, for example, bona fide employment relationships, personal services contracts, space for equipment rental agreements, timeshare arrangements, recruitment arrangements, retention arrangements, fair market value, non-monetary compensation up to, the regulation actually says $300. That's if it's a cost of living modifier, so I think we're up to about $416 a year. So on and so forth. So what you want to do is, if you've got some kind of financial relationship, or you want to give something to another physician who's going to make referrals to you of designated health services, you need to make sure that you structure that deal to fit within one of these regulatory exceptions. If you don't, that physician can't make referrals to you. And if he does make a referral, you're going to have to report and repay that money back to the federal government and be prepared to pay it off on that. All right. There are proposed modifications out there to the Stark law that the most important of which is there would be new safe harbors that would allow you to enter into value-based purchasing arrangements with physicians. We don't know exactly when those regulations are going to be finalized. I think that there's a good chance that the government's really trying to push that because they want everybody to get to value-based care, right? And so we'll keep you apprised of those. In fact, I'm doing a webinar on those in a couple of weeks for those of you who might want to pay attention. So just be on the lookout for those new opportunities that may be available under these new Stark sections. If you have questions concerning Stark, like the anti-kickback statute, they will also do advisory opinions for you, but there's not as many advisory opinions out there on Stark as there are for the anti-kickback statute. But you can go to this website, look at that. There's FAQs concerning Stark. Remember, Stark only applies to certain designated health services. If you want to know whether or not a particular service is a designated health service, you can go to this website and you can look, there's a list of CPT codes that will identify those that may implicate Stark. All right, let's talk about the Civil Monetary Penalties Law. The Civil Monetary Penalties Law is kind of a catch-all law. It applies to a whole bunch of different items, okay? It generally prohibits certain type of specified conduct like violating Stark, the anti-kickback statute, those types of things. It has the penalties. But the things that I wanted to focus on today are certain penalties associated with offering inducements to program beneficiaries, offering inducements to physicians to limit services, and submitting claims for services ordered by or contracted with an excluded entity. Now, those penalties for a violation of the Civil Monetary Penalties Law can vary. They've just recently doubled those. They're anywhere now from $5,000 to a $100,000 fine, depending on the type of conduct that's involved. You can get hit up with treble damages, denial of payment, repayment of amounts improperly paid, and you could be excluded from the government. In addition, if you've got a CMPL violation, it's probably also an anti-kickback violation and a false claims act violation, so you can get hit up with all of that. So let's talk about the first one. The first one deals with inducements to government program patients. It says that you cannot offer or transfer remuneration to Medicare or state program beneficiaries if you know or should know that the remuneration is likely to influence the beneficiary to order or receive items or services available by federal or state programs from a particular provider. So it's kind of like the anti-kickback statute, right? They don't want you going out there and offering inducements to patients, Medicare patients, in order to get them to come to you for service. If they do, that jacks up the cost of the Medicare program, and the government doesn't like that, so they've got this statute in place. What happens if you violate that? Well, it could be penalties of $20,000 for each item or service, treble damages, repayment of amounts paid, exclusion from Medicare and Medicaid. It's also likely an anti-kickback statute, so there you go. You can also get trapped with a felony penalty. Now, the key here is it only applies to influence beneficiaries, Medicare beneficiaries, Medicaid beneficiaries, okay? Beneficiaries of federal health care programs, okay? It's not private pay patients. In addition, it applies to the offer or transfer of remuneration. What's remuneration? Again, it's anything of value. You're offering any kind of freebies, any kind of discounts, those types of things to Medicare, Medicaid beneficiaries. You have a danger of running afoul of the Civil Monetary Penalties Law. So it specifically defines remuneration as anything of value, including but not limited to items or services for free or less than fair market value, unless you satisfy certain conditions, and it also applies to waiver of copays or deductibles, unless you satisfy certain conditions. Well, think about that for a minute. Have any of you ever been tempted to waive copays or deductibles? We'll do insurance-only billing. Who cares about that? The insurance, the government's still paying. The waivers are, the copays and deductibles, that's your money, right? That's money you're supposed to get. Why does the government care if you're waiving copays or deductibles? That dang government, they're out there. Why does this government care if you're waiving copays or deductibles? That wasn't money going to the government anyway. Why do they prohibit you from waiving copays or deductibles? I feel like that teacher on Ferris Bueller. Anybody? Anybody? Exactly. You don't want the patients receiving services they wouldn't otherwise get. It's the copay or deductible that creates the disincentive from them getting services they don't really need. If they don't have to pay the copay or deductible, they may get up in the morning and say, yeah, I don't have anything better to do. I can go down and get a hysterectomy today or whatever it might be, right? And when the government fixes their actuary tables and everything like that, they build that into their calculations. So they want those copays or deductibles collected. If you're not doing that under this, it's a violation of the civil monetary penalties law specifically, and therefore the government could come after you. Now, the government has said in their definitions the remuneration does not include the following. So these are kind of exceptions to the civil monetary penalties law. Waivers are copays that are based on financial need after failed collection efforts if certain other conditions are satisfied. We'll talk more about that later. So if you can demonstrate a financial need, then you could waive the copay or reduce the copay or deductible if you have to satisfy certain conditions. Items or services, if there's, intended to promote delivery of preventative care if certain conditions are met. Payments meeting the anti-kickback safe harbor, certainly tailored coupons that don't really apply to you guys. And here's the catch-all. Any other remuneration that promotes access to care and imposes a low risk upon the patients in federal health care programs. We've got this catch-all. So if you can fit within those exceptions, then it's not remuneration, and you can go ahead and make that benefit available to the Medicare and Medicaid beneficiaries. All right, that's the civil monetary penalties law, the inducements to beneficiaries. That will catch you. We'll talk more in a little bit about marketing issues. But, healthcare is different than any other industry, right? Things that you can do in other industries, you can't do in healthcare. A lot of people, when you go out and you hire your marketing personnel to come in, they've been trained in all these marketing techniques at college, and they come in with all these great ideas and don't realize that, hey, you can't pay these inducements to patients, Medicare patients, in order to get them to come in, because it could be a violation of these laws. All right, next one that I wanted to cover. The civil monetary penalties law says that a hospital or critical access hospital cannot knowingly make a payment directly or indirectly to a physician as an inducement to reduce or limit medically necessary services provided to Medicare and Medicaid beneficiaries who are under the direct care of the physician. Background on that one. So this was passed shortly after the hospitals went to a prospective payment system. When the hospitals went to the PPS system, what does that mean? It means now the hospital's not getting paid for every item of service they render. Instead, they're getting a defined set of money for the DRG, right, based on the DRG. That created an incentive for the hospitals to provide care more efficiently. But the government was concerned that the hospital may say, well, let's go out and do a deal with our physicians. Physicians, don't order as much care, and we'll split the savings with you, right? So that's why they passed this law, that they don't want you to do these kinds of deals with physicians. Now stop and think for a minute. Think of the Affordable Care Act and like ACOs, the Medicare Shared Savings Program. That's exactly what the Medicare Shared Savings Program is trying to get you to do, right? To come together, to have cost savings, and we'll share the money with you. We'll share those savings. So there's exceptions under the civil monetary penalties law if you're structured to be able to fit within the Medicare Shared Savings Program. But other than that, you've got to be careful about splitting those cost savings, those gain sharing arrangements. Now, there have been certain circumstances where the government has approved certain gain sharing arrangements, particularly with regard to cardiologists and stuff. There's advisory opinions on that allow you to do it if you can put in place certain safeguards. But the bottom line is you've got to be careful about these. Now, it used to be, up until a couple of years ago, it used to say that you couldn't pay these inducements to reduce or limit services. A couple of years ago, they added the language medically necessary services. So this does give you a lot more flexibility now to structure these gain sharing arrangements or look for opportunities to do gain sharing arrangements with your physicians as long as you're not cutting out medically necessary services. So you could do something that arranges for cost savings for inefficient, medically unnecessary services and those things. So it makes it a little bit easier. In addition, under the new, they proposed anti-kickback safe harbors also that would also apply to the civil monetary penalties law that will allow you to engage in certain of those value-based purchasing arrangements. And that may give you some more flexibility to structure these types of insurance. Well, if you violate that, the penalties are $5,000 for each for each individual with respect to whom the payment was made, and you get it up with any other penalties out by law. Okay? All right, the next one I wanted to talk about is the excluded provider situation. This one basically says, hey, if the government has come in and determined that somebody's violated the law and they are excluded from participating in Medicare, we want to make sure no Medicare money gets to that person, not only for services that they perform, but also for services that they order. And in fact, we're going to go a step further. This isn't only going to apply to excluded providers. We're going to say, hey, no entity can even contract or hire somebody who's excluded if any Medicare money is used to pay for their salary. So that means you've got to also not only be concerned about the excluded entities, not just, with your physicians, with your medical staff members, but you as a hospital or you as a medical group, you need to be really careful about hiring anybody that is excluded if you're going to be participating in Medicare and Medicaid, because chances are their salary is going to include revenue from Medicare and Medicaid. And the government says you can't do that. And if you do it, guess what? We can exclude you for doing that. Okay? So it basically says, hey, once you're excluded, you've got the scarlet letter, I guess the scarlet letter E, not A. But that's going to follow you around for the rest of your life until you get out of that excluded list. And you're not, essentially, as a practical matter, you're really not going to be able to be involved in healthcare. I suppose you could be involved in healthcare as long as it's no federal money involved, but there's not many practices out there these days that don't have federal money involved. It's generally for, I think it's 4 years, but you have to apply to get off the list. It's not like you automatically come off the list. And the government's pretty picky about this. I had a situation where a client, they used a temp agency to hire a person. And so they were using this temp agency to help with HR stuff. And then after the temp stuff, the person did a good job for them, they hired them to continue on with them. Well, years later, they found out that she was excluded and she had never gotten off the list. And so the government went in and made the client repay a percentage of her salary based on their Medicare and Medicaid population. They had to repay about $250,000. Okay? That's a big penalty. Now note that this only applies to those people who you knew or should have known were excluded. Well, how do you know whether or not a person's excluded? That's exactly right. They published a list of excluded individuals and entities that you can go in there, and they update it, I think, on about a monthly basis at the OIG's website. So the government says in the regulations that before you hire or contract with these people, you're supposed to check them against the LEI. And you're supposed to run a search periodically thereafter. Now, they haven't said per se that you're supposed to do it monthly, but that's really about the only really safe thing to do is to check it monthly against your personnel. Sorry about that, guys. That was my phone. That was just to see if you were awake. All right. So you go in there and you check that LEIE. You could also get notice, for example, if the government finds out that you've submitted a claim and that's associated with an excluded provider, they'll notify you and then you put on notice for that. All right. That's another reason why you want to make sure that you condition your payer contracts on them not being excluded. You have some kind of representation warranty when you're doing provider contracts that require that part of their qualifications in order to provide the services, and they're not excluded, and they're going to notify you if they are excluded, and you can immediately terminate if they're excluded. With regard to the civil monetary penalties law, the government again publishes advisory opinions. You can go in there and look at those advisory opinions if you need guidance, instruction. All right. Yes, sir. Uh-huh. Mm-hmm. Onus is on you. It's going to help you get out of your contract, but it's not going to be a get out of jail free card from the government. The government has specifically said that before you contract with or enter into contracts or as part of your medical staff credentialing process, you're supposed to check the LEIE. And then Medicaid a few years ago I think it was about 2015 or so, CMS Medicaid said that they expected you to check for your contractors on a monthly basis. CMS Medicare did not say that. If you look at the OIG Supplemental Hospital Compliance Program guidance, which I'm sure you all have memorized, they said that you should check probably annually, and they also said you're supposed to check before that you hire them. So they didn't say that you have to check annually. But really, because it's a know or should have known, and they publish this list monthly, I think that the only really safe thing to do is to check monthly. You may be able to argue that you've got a little bit of window there if you really didn't know. But yeah, you really should check it periodically. I know some of my hospital clients, they just got it set up. There's a way that you can set it up so that you have like a spreadsheet that compares to what's in there, and they just run that on a monthly basis. All right. Those are the primary fraud and abuse laws. That is my life. That explains why I have no personality. This is where I spend my life. My wife didn't know that I did this before we got married. Afterwards, she may not have married me. So, any questions about those fraud and abuse laws before we move on and talk about what you do if you happen to discover a fraud? Okay. So, let's say that you're sitting here and you're thinking, oh my gosh, I didn't think about that. What do we do? What happens if you discover that there was a violation here? Well, again, if the provider has received an overpayment, the provider must return the overpayment to the federal agency, state agency, or intermediary or carrier and notify the entity of the reason for the overpayment. In the wake of the Affordable Care Act, you must report and repay within the later of 60 days after the overpayment is identified, or if you're paid on a cost report basis, 60 days after the cost report is due. Okay, what happens if you fail to do that? Again, it was part of the Affordable Care Act, it's part of the False Claims Act, and also the Civil Monetary Penalties Law. So you're going to have a False Claims Act violation. It may not have been a false claim when you submitted it because you didn't know that there was a problem, but if you subsequently learn about it, then you do know, okay? And it turns into a false claim, which means that you can be subject to those penalties of $11,000 to $22,000 per violation, treble damages, possible key 10 lawsuit. In addition, under the Civil Monetary Penalties Law, you can get hit up with additional penalties. These were just doubled. Now it's a $20,000 penalty, treble damages, and potential exclusion from Medicare and Medicaid. So you can't just sit on it and hope that it's going to go away. Well, what is an overpayment? Well, overpayment means funds a person receives or to which the person, after applicable reconciliation, is not entitled. It's things like payments for non-covered services, payments in excess of the allowable amount, errors in non-reimbursable expenses and cost reports, duplicate payments, receipt of Medicare payment when another payer is primary, and for purposes of today, the ones we deal with most are payments received in violation of STARC, the anti-kickback statute, or the exclusion statute. Because those statutes specifically say you can't submit claims that are in violation of these statutes. If you do, you've received an overpayment. Okay? You got to do the repayment. And when they came out with the report and repay regulations, they said that there's a 6-year look-back period. So you've got to go back 6 years. Now, that's not great, but it's better than the 10 years they originally suggested. Well, when does that 60-day time period begin to run? It begins to run once it's identified. Well, how do you identify the overpayment? A person has or should have, that means that the person has or should have, through the exercise of reasonable diligence, determined that they have received an overpayment, either by actual knowledge, either you knew that you got the overpayment, or reckless disregard. You should have known, right? There was enough there that you should have known about it, and you didn't do anything about it. If you're completely innocent, you had no idea that this physician was doing something squirrely and you had no reason to know, then you're okay until you actually know about it, right? But the point here is you can't just stick your head in the sand. The government says that you have a duty to investigate if you receive information concerning a potential overpayment. They give you some examples in the rules. Things like a significant and unexplained increase in Medicare revenue. Oh, good heavens, suddenly our Medicare revenue is triple what it was. Well, that's just fortuitous. Don't look at it. Review of bills shows that there are incorrect codes. You discover services were rendered by an unlicensed provider. That an internal or external audit discloses overpayments, or you discover that there's a STARC or an anti-kickback violation. The government has said that you've got an affirmative obligation to exercise reasonable diligence. If you don't exercise reasonable diligence, they'll treat it as if you did know anyway, right? And reasonable diligence, they've said, includes proactive monitoring. They expect you to do some kind of auditing or monitoring to make sure that you're compliant. And of course, any reactive investigation. If there's a red flag that comes up, you better track it down. You better find out whether it's out there. Otherwise, they'll have deemed that you found out about it. So that 60-day to report and repay begins to run when either the person completes a reasonably diligent investigation, which confirms that you received an overpayment, and the quantified amount of the overpayment. That's the important factor. Okay? We were afraid that that 60 days, you had 60 days not only to investigate and confirm whether or not it existed, but also to find out how much you owe back. And that can be problematic, especially if there's a transaction that's, some mistake that's been going on for years. You've been paying that physician without a contract for X number of years, and now you've got to go back and figure out all the claims that you've been paid from Medicare based on referrals from that. That can take a while to do, right? So we were afraid that you only had 60 days to do that. But the government came out and said, no, that's not the way that it works. The 60-day period begins to run once you've concluded your investigation, which identifies the receipts, and you've been able to quantify it. Okay? So both of those. If there was no investigation, if you simply hide your head in the sand, you don't do any investigation, then the 60 days runs when you should have done the investigation. You should have known. Okay? So you can't just hide your head in the sand. Reasonable diligence, they expect you to do a reasonable diligence job to try to determine this stuff. So you can't just hide your head in the sand, and you can't just drag your feet. They've said at most 6 months. Once you do the 6 months, that means that you have 6 months to complete the investigation to quantify it, and then your report and repay obligation begins. You've got to report and repay 60 days after that. So you've got about 8 months. They're giving you quite a bit of time in order to resolve it. Now, that deadline may be suspended, but if you get into this and you determine that there was a violation of like the CMPL or the anti-kickback statute, and instead of reporting back to the carrier, you want to go ahead and do a self-disclosure to the OIG or the DOJ, or in the case of Stark, to CMS, if you do the self-disclosure, that tolls the limitation, that 60-day period. And now you're going to be working with the feds, CMS or the OIG on those issues. Most of the time, though, we would rather deal with the carrier and do those types of repayments, because especially once you get the OIG involved, then who knows what they're going to look at. The OIG is really scary. The carrier just kind of wants their money back, and as long as you repay the money back, then they're usually okay with it. But once the OIG gets in there and starts looking around, then they can go anywhere they want to go. And they've also said in some of their commentary that if you're going to do a self-disclosure to the OIG, you better darn well make sure that you are candid and disclose everything, because if they get in and find out that you didn't disclose everything, then you lose the benefit of doing the self-disclosure. So you got to be really careful about getting them. So as I mentioned, if you put that overpayment, the government says that you can either use the Medicare contractor process, particularly if there is no violation of the law. If there is kind of an innocent mistake and you discover it, then you can just go back to the Medicare contractor. Alternatively, if you think that there's a violation of the law, then you may need to go to the OIG, if it's a violation of the anti-kickback statute or the civil monetary penalties law, or to CMS if it's a violation of the Stark law. Just because you do the repayment under the repayment rule to the carrier doesn't exempt you from the OIG or Department of Justice or CMS coming after you for a violation, right? If you do the repayment back to the carrier and they think that there's a violation of the law, like Stark or the anti-kickback statute, they can still turn you in, and the feds can come after you under those other statutes. So bottom line there, if you think you've got a pretty serious problem, you may want to talk to an attorney or somebody who has a good malpractice policy to make sure they're getting good advice on what's the best process for resolving that. If you want to consider other disclosure protocols that we're not going to talk about them today, but you can go on the government's website there, and they've got guidance for the self-disclosure protocols. OIG, not too fun to work with. Okay, they justify their existence because they come after you, right? They're the people who want to collect, spend $1 on enforcement and recover $4. CMS, my experience with CMS on the Stark self-disclosure protocols, They are really good to work with. The stuff that I've had to do, self-disclosures with clients, fortunately none of the contracts are things that I drafted, but the client comes to me afterwards. I've done several of those, and usually the government, unless it's something that's pretty nefarious, if it's just like a technical violation, the government will only require a repayment of maybe 2 or 3%, pennies on the dollars. Okay? So the CMS has been really pretty good. But you want to make sure that you're the one that goes to them first rather than them catching you. So if you think you have a problem, contact your compliance officer, consider contacting an attorney who knows about healthcare issues, and you're going to need to self-report. That's the law. It's not worth jeopardizing your life, your career, or going to jail by trying to hide this stuff. Of course, it's better to comply in the first place. So here's a few action items to take away. You ought to consider identifying any remuneration sources. If you go home today, think about, okay, are there any remuneration that we're paying to referrals? That could be to other providers, that could be to vendors, that could be to employed providers, whatever. The employment situation, your group compensation structure, you need to make sure if you're a physician group that is set up properly under START in order to comply. A lot of times those aren't. Because a lot of those group compensation structures are set up, eat what you kill. So physicians are paid not only based on what they personally perform, but based on the labs and other things that they're ordering. And if that involves payments for labs that are ordered to Medicare and Medicaid, that stuff, it's probably not going to fit within the safe harbor and they're going to have START concerns. Look at things like leases. Are you giving away free or discounted space to visiting specialists? In those situations, that could implicate START and the anti-kickback statute. Subsidies or loans. Are you subsidizing physician practice? Are you providing free services or free IT, those types of things? And if so, have they been structured to fit within the safe harbor? Have you got joint ventures or partnerships with other physician partners? And if so, are those structured properly to comply? Free or discounted items or services like use of space, equipment, personnel, marketing programs, we'll talk about that a little bit later, and financial policies, or the financial policies giving freebies to patients. Review your relationships for compliance with a statute or exception. When you look at those financial relationships, have they been structured to fit within the safe harbor, or is there a chance that they're going to be, induced referrals for certain items or services payable by Medicare or Medicaid? Are you complying with the contract? Maybe you set up the contract originally, but these things have a tendency to morph, right? People forget about it. Maybe they just don't get around to billing it, or they never pay. Well, if that's the case, then they're getting something for free, right? You're no longer complying with the regulations. So you've got to maintain ongoing compliance with those types of things. So periodically look at those. Are you paying fair market value? Is the compensation, is it based on the volume of value referrals or set up on some other point? Is the arrangement commercially reasonable? Does it serve a legitimate business? Those are all things that are generally required for compliance with the regulations. You should be proactive, right? That's what the government expects. You should implement a method to track and monitor those relationships with referral sources, whether it's other providers, whether it's patients, whatever it is. Maybe having a central repository for contracts or deals, or a method to track contract termination process for confirming compliance and the like. Periodically review and have approval by compliance officer, an attorney, or other qualified individual for all contracts with providers. Those should all go through your compliance officer. Joint transactions with referral sources, benefits or perks to referral sources, or marketing and advertising campaigns. I've seen this a lot where hospitals especially, they hire their PR person, they hire their marketing person, that marketing person runs, and nobody thought to check with the compliance officer to find out whether or not those benefits or the things that they're doing comply with the particular laws. Ensure your compliance policies address fraud and abuse laws. Train key personnel regarding compliance. Administration, marketing, all of those others. Make sure you document the training. If you think that you do have a problem, then make sure that you suspend payments to the claims to the government until you resolve the problem, right? It's one thing to submit a claim to the government when you didn't know that there was a problem. That's not a false claim. It's another thing to continue submitting it when you know that there's a problem, right? Those are false claims. Make sure that you implement appropriate corrective action because the government will go easier on you. If you think that there's a repayment due, report the repayment per the applicable law, and if necessary, use self-disclosure protocol. All right, that is my very brief review of federal fraud and abuse law. For additional resources, if you don't have anything else to do this week and want to sit down there and look at it, you can look at the OIG compliance guidance that they give on their website. There's a whole bunch of really good sources. It's got advisory opinions. It's got videos and things like that on the laws, so you could look there. In addition, on our website, because I have no life outside of doing this stuff, we've got a lot of published content, including client loads and the like. You can check with us on that. All right, I think I'm actually ahead of time. Can you believe that? Any questions about the things that we talked about? All right, at least no questions that people want to ask. I'll be around, so you can come up and you can talk to me. This is, free lawyerly advice. So feel free to come up and talk to me during the break or whatever. Otherwise, I turn it back to you, Brad.
All right, thank you, Kim. And Kim's right, we are ahead of schedule. I want to say that. I may say it again because it won't be that way the rest of the day, okay? So we've got a break on the schedule now for 15 minutes, so let's break, and we will resume at about 9:45 with the speaker. Thank you.
So we're going to go ahead and get started and just keep moving forward. It's so rare, especially with attorneys, that can be verbose, right, to actually be ahead of schedule. So this is probably a pleasant surprise for all of you. My name is Christy Kimball, and I'm going to be talking about elements of provider contracts to keep in mind. And there's a lot of content on these slides, and I'm not going to be going over all of those in detail, but hopefully these can just be used as a reference source in the future as you're kind of going through with your checklist, and at least being cognizant of things to be aware of as you're going through these various types of contracts. So certainly after the presentation, you're welcome to talk to me or Kim about any specific questions that you might have. But I just want to mention that because these are kind of very dense slides. Also, I am Tim's so great because he covers so much content in such a short amount of time. But again, I'm not going to go through everything in these slides, but we'll just kind of hit the highlights, and hopefully that will be helpful. So moving through this, I'm not going to go through also all of the different, various anti-kickback laws and relevant laws that you need to keep in mind because Kim's done such a good job of giving you that overview. But that really is such a big issue whenever you're putting together any kind of a contract with a provider or with a vendor, is keeping in mind, obviously, these various anti-kickback laws. But here's a checklist of just the things that you need to be kind of cognizant, right, of the anti-kickback law, start civil monetary penalties law, tax exempt status at play, and then there can be various state laws that apply. And sometimes I think my clients forget these various state laws that apply. We're all kind of thinking big picture. Sometimes these big entities that are contracting are thinking of the big picture, but they're forgetting that there could be relevant state laws, even down to state licensing laws for that particular type of provider. Like for example, in Utah, as a physician, our law talks that our licensing law says that if they're going to refer to any it actually enumerates specified kind of areas that they might refer to that they have a financial interest in, that they've got to disclose that in writing to the patient beforehand. So that's outside of, right, we've still got, Stark's still going to apply, anti-kickback still going to apply, state anti-kickback law rules are going to apply, but then still we've got this additional layer for that provider. Could this trigger a violation of their licensing laws? And so you've got to just be cognizant of everything that could be relevant. And then in terms of just overall looking, what type of agreement are we looking at? Is this an employment agreement, an independent contractor agreement, a recruiting agreement, leases and timeshares? And today we're just going to kind of talk about some of those common things that you should be issue spotting and hopefully putting in those agreements and being aware of as you navigate through this. So as Brad has already mentioned, Kim Stanger puts out so much content that we tease him like we don't know how he even gets any sleep at night because he works all day and then he's constantly putting out so much content online. But it's such a great resource, and I'll tell you guys, I'll embarrass him a little bit because I was recently at a national healthcare conference and I was coming down the escalator with a woman that I think worked at a hospital in New Hampshire. And she asked me what firm I was with, and I told her, fully expecting she would have no idea who Holland & Hart is because we're a big firm, but we're mostly located in the Mountain West. And she's like, oh, I know exactly who Holland Hart is. She said, I look at Kim Singer's information for everything. It's my first line resource for everything when I have a question about healthcare. And she said, and I love what he puts out, because most attorneys put something that's kind of just this very kind of vague overview of the law, and so it forces you, it's like a teaser, so you have to try and reach out to contact them to find out specifics. And she's like, Kim, the updates that he puts out are so specific, and he's got all the citations, and she said, you can really use that as a great resource, and most of the time kind of have your answer, and it's not one of those kind of, you know, bait and switch kind of things. So I mentioned that because we listed all these different things. There's so much content on our health law blog that Kim has put out relative to these issues. So utilize that as a great resource when you're navigating through these issues as a first line, and then when you have questions beyond that, contact me. Also, really helpful templates you know, that can be provided as well that you would find on our site as well. I know that Kim, for example, for business associate agreements, you know, has some really nice templates that you can find online too. So contracting is difficult no matter what, right? So it's tough. The first thing you always have to think about is, okay, well, you know, people will contact me and say, hey, can you just give me a template for this? You know, can you just give me a template? But a contract is all about really outlining the parties' agreement, right? And what they're trying to accomplish. And there's no, you know, certainly for certain clients, you can create a template that might be a good starting point, but that's never going to be a one-size-fits-all. So you have to really consider, okay, what are we trying to accomplish here? What are the key elements of this contract that we're trying to put into place? But then, once we know that, okay, what are the relevant applicable laws and regulations? And then, you know, what are the different objectives of the parties? We always have to think about that. And then, you know, this is often the case. It's hard for us as attorneys on the back because, you know, I have certain clients that I've started helping the last few years, but recently, for example, I have a client that, you know, we're now in litigation over a contract, and, you know, our firm is helping with the litigation, and I keep trying to absolve myself saying, I did not write this contract. Like, I just want everyone to know I'm not responsible for this contract. Because so much of this particular contract, I think that they just kind of threw something together themselves, thinking, well, this will suffice. And they thought, well, we understand what we're trying to accomplish here, but there were so many ambiguities or things that conflicted with each other. And now here we are in a dispute several years later because somebody stopped paying, and the contract really is not very helpful, and it's going to be interesting to see how that plays out. So, you know, you need to get really specific and really think for those nuances and make sure that you're accounting for those in very explicit ways. So in general today, because of the audience we're speaking to, of course, and that is, you know, institutions are mostly our clients, the comments and how I'm presented today is really geared towards being the employer, right, and the contracting party, whether that's with an independent contractor or with an employer. So keep that in mind today as well. So in looking at the type of agreement with providers, obviously in terms of them providing services, you're always going to be either they're an employee or they're an independent contractor. And I think most of you are, you know, very familiar with, you know, the differences between those two things. But this list just kind of goes over some of those things to keep in mind. If somebody's an employee, the one thing I want to point out is it's far easier to comply with Stark and anti-kickback when somebody is an employee. When somebody is an independent contractor, it gets a little bit tougher, you know, obviously to fit within those exceptions. But also you have to keep in mind that you know, a lot of people try and say that people are independent contractors just because they want to get out of paying, you know, the various employment taxes, but in reality, they're employees. And obviously there can be issues with the IRS later on, you know, if they look at this issue. And so there are tests for determining whether somebody is an employee versus whether somebody's an independent contractor. And a couple slides later, we'll look at that, but just keep that in mind. Ironically, I've had a couple of situations with clients in healthcare where they want to make somebody an employee versus an independent contractor because they're thinking, well, now I'll get into, this anti-kickback exception. This will be far easier. But really, they're not bona fide employees, but they're trying to find a way to basically make I would say, kind of a nefarious situation look a little bit better. So, in our area of law, like what Kim said, normally, I heard years ago at a health law conference, somebody say, in any other business, if something makes really great business sense, like we want to generate a lot of business, we're going to, give somebody little gift certificates for referring to, we're going to just blow up this business. But it makes good business sense in any other situation. When it comes to healthcare, it probably breaks the law. And to that same extent, sometimes you'll see people trying to make people an employee when, they're working 2 or 3 hours a week for this company, but they want to give them money basically for generating referrals. You'll see all sorts of crazy things. Things just get flipped on their head in healthcare law. But anyway, these are just some things to kind of think about as you're going through this. So to understand the designation between who is an independent contractor versus an employee, this is the IRS. You can look at the website in terms of how you classify and go through those objectives. So be sure to, if you have a question, there's so many good resources that the government puts out. This is one of those to determine. But here's going through just the factors between an employee and a contractor. Really, it's so much of it comes over, do you have the right to control, that individual? Are they generally, just working for you and nobody else? So look at those kind of things to decide whether or not you really have the right of control over that person to make sure you're properly classifying them and you've got the right type of agreement in place. So in looking at the applicable laws to your contracts, you've got these healthcare specific laws. Again, Kim's done a really great job going over those. And I apologize, I didn't catch these. Those last two I see, that's Idaho law. We're going to put out on the updated link for this presentation, the presentations today. Those will be off, but just know that there could be obviously applicable state laws that you've got to think about as well. But in terms of general employment laws, you've got to just go through, as you guys all know, those various labor and employment laws. You've got to make sure that you're not violating. You guys should be very well aware of those, sure. In terms of Stark for physicians, when it's an employment contract, the compensation has got to be consistent with fair market value for those services. Can't take into the account the volume or value of referrals for designated health services. And it doesn't apply to things that the physician is personally performing, but this just gets to be a little bit nuanced because you've got to really look and see how your employment, your compensation is structured and make sure for these certain designated health services, which the government has, a long list explaining what those are, that you're not, taking into account the referrals that they're making for those services. But it's got to be commercially reasonable, regardless of referrals made. Under the anti-kickback statute, compensation paid to bona fide employees for furnishing items or services payable by Medicare, Medicaid, and that safe harbor may not apply to excess payments for referrals instead of furnishing items or services. Anyway, so as you're going through this, these can just be really nuanced. And I've had a lot of situations, and I'm sure Kim has as well, especially where physicians think that they've structured their employment, their compensation arrangements in a way that doesn't violate. And they're basically kind of throwing everything into a pool and everybody gets to share with these things. But they don't understand that there are these nuances, even with a group practice, that you can't, throw everything into the pool. And so we have to go back and correct that and fix that for them. So just be cognizant that obviously there are a lot of things you've got to jump through there. In terms of independent contractors, so if you have physicians that are independent contractors, under Stark, again, for physicians, you've got to have, writing that specifies what the compensation is. The compensation has to be set in advance, consistent with fair market value. and does not take into account the value or volume of services, other business generated by the physician. So in terms of, what they're personally doing versus what they're generating, other business generated, those are treated differently. But the arrangement always has to be commercially reasonable. The compensation may not be changed within 1 year. So I think you guys, I'm sure you're all very familiar with that, right? You always see with independent contractors, all this is kind of set out in advance, and it will say, this is for term is for 1 year. If this contract is terminated prior to 1 year, you can't go back and revise it, and then put it back in place. It's got to be set in advance for that year time. Under the anti-kickback statute, there's got to be some type of writing signed by the parties. The aggregate compensation has to be set in advance, consistent with fair market value, does not take into account the volume or value of referrals for federal program business. And the aggregate services do not exceed reasonably necessary to accomplish the commercially, again, it has to be commercially reasonable. So those are kind of the general outlines for independent contractors. Again, in general, it's just got to be set on at events, in writing, consistent with fair market value, and always has to be commercially reasonable. Group practices. Under START, group practices can compensate physicians differently than hospitals can. The groups can pay a share of profits subject to certain limits. And the groups can pay physicians for services performed incident to the physician's services. But like I said, there are nuances to this. It's not just carte blanche. You can't just throw everything into this group practice compensation model. There are certain things that have to be carved out that, again, oftentimes don't get evaluated for. The contracts between the hospitals and the group may create additional issues, particularly for the group. So again, these kind of get nuanced, but just kind of giving you a general overview of things to look out for. So in terms of contract terms for the services, and then here are just things that you want to kind of a broad brushstroke. How should I be, like a checklist to be going through? And I would just basically use this presentation if there's ever a question or you've got to create some kind of, and most of you I'm sure have really great templates that you're already utilizing. But let's say that you've got kind of a unique situation. I would just utilize these next few slides as a template, as a checklist to go through and make sure you're thinking through all the relevant issues. So is it a person or entity providing the services? Is it going to be an employment or an independent contractor agreement? What's the commencement date? And then you want to be very specific about what services are you going to be performing under this agreement. Most people, I see agreements, they're just far too vague, and you really want to be specific about what you're expecting them to do. And that becomes easier for you, especially, and I always tell my clients, it's so much easier when you've been very specific and you've got a really, really good contract with an employee or an independent contractor. But when there's a problem, it's not personal. You don't have to sit down and say, you're not doing this, this, and this, and this. We're really upset about this and this. Sometimes it's so much easier when you can say, let's pull out the agreement, that we both agreed to. Let's pull out the contract. And provision, 2.8 is you agreed to do the following. And it becomes a lot less personal, and I think makes those discussions, the hard conversations, a lot easier when you can point to, wording in a document versus, you kind of pointing the finger directly. I don't know if any of you have found that helpful, but it's certainly a tactic I like to be able to utilize. So what's the schedule going to be? I'd be clear about that. I hear a lot of the time from my clients, they're calling me up saying, well, I expect that, they're taking way too much time off. They're not coming in when they're supposed to. And I'm like, well, was that clear in your initial agreement? And they're like, well, no, we just said that there would be and again, you guys are coming from hospitals. I know you're a lot more sophisticated, but I just see this a lot, even with physicians, big employer groups sometimes where they're just not being specific. And then there are these problems that they have nothing to fall back on to say, no, these were the expectations. This is what you agreed to. So you've got to be really clear about that. And then what are their qualifications? And we'll go through that in a little bit more detail in a moment. So looking at that, you know, you always want to have that provision where you're saying, these are the pre-qualifications that you have to have. Obviously, you know, passing the pre-employment screenings, licensure without restriction, DEA and State Board of Pharmacy authorization, able to participate in Medicare, Medicaid, and other payer programs, medical staff membership and privileges without restriction, insurable under hospital policies, board certification or board eligible, able to perform services. So you want to have that long list of all the things that are required as qualifications for them to qualify to actually perform the services. In terms of performance standards, and this is another place where I think you need to be explicit, and this is the better place to throw in the bathtub, so to speak, because this is where you often have issues in terms of performance standards. And again, it's so much easier to point to a provision and say, this, you know, doctor, this is what you agreed to. These are the standards that you agreed to abide by, and you have not been following those standards. It just becomes a lot less personal. But here would be, you know, that they're going to comply with all of relevant laws and regulations, the standard of care, hospital bylaws and policies, pay requirements, third-party contracts. They're going to act, and this is so critical, right? You're going to act in a professional, cooperative, and non-disruptive manner. Timely complete records for hospital policy, support the service line, support quality assurance, compliance, and other programs, attend required meetings and participate in assigned committees, immediately notify hospitals circumstances giving rise to potential claims, adhere to other performance standards as reasonably established. And don't forget that last, that catch-all, because in a hospital, policies are always changing, right? So you always want to have a catch-all so that if things change, that they're automatically required to adapt to those hospital policies. But again, I'd be here as explicit as possible to try and hold them accountable when things don't go well. One of these issues that obviously you often see is, you know, exclusivity versus non-exclusive. So you've got to make sure that you're being cognizant of that. If contract is intended to be exclusive, make sure that you're really careful about how you're defining that. Allow for exceptions as needed. Obviously, this is critical for all of you, but conditions, contracts, and privileges on continuance of exclusive arrangements. And terminate the contract and privilege if the provider is no longer a part of the group that has exclusive management. So oftentimes, I dealt with this here and there on the periphery. Probably a third of my work is hospital work. I do local council work for about 10 hospitals in Utah, 8 of them being, you know, a very large national holding company. But of course, they have their new standard provisions that if something happens and either that contract, that exclusive contract is terminated, let's say for your ED physicians, right? Do all of you have exclusive contracts, I'm assuming, for your ED physicians? I mean, normally, right, you have certain groups that they get the contract to provide, let's say, ED services in your hospital. That's the exclusive contract. If that should change, you know, you've got to have a provision that everybody that's part of that group, obviously, their privileges terminate if that exclusive contract, you know, terminates, and vice versa. And sometimes that can create an issue if those aren't explicitly put in those agreements. Outside activities, you need to think about, what am I going to allow as a hospital? What are you going to allow these physicians to do outside of the agreement during the term without the employer's consent? And it's really important to really drill down and think about that. There's several reasons for that, but one, you know, being like liability. So, you know, sometimes if these physicians are engaged in doing certain things, you know, usually if let's say that they're doing like charitable work, that's great. But you want to specify and be very clear. If you're going to be doing charitable work within the scope of your practice, you know, on your own free time, normally you'll see that the hospital will say, you know, our insurance policy will cover you for that. Sometimes, though, there will be certain things outside the scope of what you want them to be doing. And you want them, if they're going to be doing any of those things, to have to come to you and get written authorization before you'll allow your insurance to be covering them. You want to be really clear about where those lines are in terms of what am I going to allow you to do, what are we not? And for those things that we're going to allow you to do, Normally, if they're going to be an employee and you expect them to be doing, working exclusively for you, you know, usually most of those things that you're allowing them to do, if they're going to be getting compensation, let's say for, you know, speaking, you know, expert testimony, normally there's going to be that assignment where that money is flowing to you first so that you can evaluate and see what's happening and then being pushed to the positions appropriate. So I'm just trying to, and most of these we kind of already covered, but, and you just want to make sure too that when you're looking at what you're going to allow them to do and not allow them to do, that it's not going to ever interfere with the non-compete, and make clear that they're not going to be doing that. Usually most hospitals have a conflict of interest policy that your physicians are signing, but they're not going to do things that create a conflict of interest. And you've got to kind of coordinate and line these things up as well. And sometimes you can refer to that conflict of interest policy, saying that they agree in no way are they going to be engaging in activities that would violate the non-compete or the conflict of interest policy. And if there's even a question that would happen, that they're going to come to you and get permission beforehand before they engage in any of those activities. So looking at compensation, there's so many ways, obviously, this can be structured, but here are just a few of most common: a set salary, time-based, per hour, shift, day or month, productivity-based, RVUs, net charges, net collections, net income, or value-based. And more, obviously, given the various changes that are happening with Medicare reimbursement, federal payer reimbursement, we're seeing this shift over time to at least having part of that compensation, a portion of it, based on value-based, to try and line up the incentives for the physicians with what you're trying to do as an organization, right? So if you're trying to move to make sure that your outcomes are doing well, that readmissions are lowered, how do you line up your physician compensation to motivate your physicians for the institution's overall goals? And so you need to be thinking about how you're doing that. Compensation, so when you're doing base salaries per hour, per day, per month, per shift, per service, be very clear. I referenced this before, but be very clear about what is it you're paying for. Is it clinical versus administrative services, adjustment for partial shifts, partial years, et cetera? For example, I've reviewed several employment contracts for some big employers in Utah where somebody's being brought in and they're going to be providing medical services, but a certain percentage of the time they're also going to be doing like clinical research, right? Or they're being brought in kind of these dual roles. And you've got to be very careful about how you structure those type of agreements to be clear about how many hours per week do we expect you to be in clinical practice? How many hours a week are we expecting you to be engaged in your various research or administrative roles? How are we compensating you for this portion, and how are we compensating you for this portion? And otherwise, there can be some serious confusion and problems later on down the road when those expectations aren't met. So the one thing I'd point out here, I think it's really nice. It's good to point out, and again, I assume you guys are all far more sophisticated than some of my clients I get to deal with here and there, unfortunately. But sometimes it's not really spelled out and made clear in terms of billings versus collections. If we're talking about, let's say, some kind of net revenue, let's define what net revenue is. What are our net collections? Being very specific about, well, what does that mean? Because so much of the time, the physician may be under one understanding what that means, and you may be under an entirely different understanding what that means. You need to get very clear about these terms, about what's going to be included if you're paying, off of some kind of proportion of these revenues, that you're being clear about what constitutes those revenues. And then I always like an example of what that will look like. So calculating an example so that we're avoiding any misunderstanding. Again, it's so much easier when the doctor's like, I thought I was going to be paid on this, this, and this, and this. so much easier to say, oh, I apologize if there's been a misunderstanding. Let's go back to the contract. This is what was specified, and we gave an example to make sure that if there was any ambiguity that we were all clear. And then we said this is how this would work. So consider that example as a way to really clarify. So just giving you an example of some problems that can kind of trip you up when I was talking about how you compensate and what you throw into that mix in terms of paying. There was this USV Halifax hospital. The hospital had an arrangement where they were giving 15% of the operating margin for the oncology program itself as part of this incentive tool, this bonus compensation. And there was a key town suit that was brought, and it was a Stark violation. The hospital paid $85 million. And if you read kind of at the bottom there, you can see a little bit more about that. But basically, they had executed these contracts with 6 oncologists that provided an incentive bonus, and it included the value of like prescriptions and orders, that were being made to the hospital with the oncology program, right? And so you can't do that. And if you think about that, the whole goal of these anti-fraud and abuse laws is to make sure that physicians and people aren't incentivized to order care and generate services that really aren't in the best interest of the patient, but are lining pockets. And so when you kind of think through how you're doing these things, think about, in this case, that was the case exactly, right? If I'm paid a bonus based upon how many orders and how many prescriptions, that I'm doing, of course, I'm going to be motivated to write as many prescriptions and as many orders, as I can. Compensation. Again, we just kind of talked about that value-based compensation. Nothing in Stark bars, a hospital or anyone from doing this value-based compensation. And so people are really starting to look at, as far as the, let's say like 10% of their compensation or some kind of bonus being conditioned upon outcomes and reaching certain kind of value-based objectives. So something that you can think about. And what does that look like? Patient management compensation, oftentimes, again, it's like 5 to 20% of the compensation based upon achieving these quality metrics. So clinical quality, patient safety outcomes, patient satisfaction, access to care, efficiency, use of health IT, citizenship, participating in meetings. And then on the right in this blue box, you can just see that in terms of, if you guys are thinking about doing that, those are some of the existing metrics that, you can utilize to try and at least set that carrot towards the goal that's value-based. So additional compensation, and things to think about. Normally physicians have got to properly supervise, right, certain individuals, right? Whether, let's say that may be, residents, it may be, mid-level practitioners, maybe certified nurse midwives, right? They're just involved in supervision. But there are things that physicians can get paid additional compensation for: assigning those bonus, retention bonus, relocation assistance, student loan repayment, deferred compensation, health insurance coming from the prior employer. But you need to overall look at all of this and make sure that you're thinking about, is this fair market value? And is this lining up with what would be normal and in line with fair market value standards? Normally when you're doing this, of course, you want to tie, if you're going to be giving, let's say, a signing bonus or paying moving expenses, paying back student loans, a certain amount on their behalf every month. Of course, you want to tie that to them remaining for a certain period, or else they've got to pay back. Normally that's prorated, so if they terminate, right, if there's some kind of termination on either side for certain breaches, they've got to pay back, and you want to be very clear about how that payback is going to occur and how that calculation is going to be done, because I see that in the back end a lot, where physicians, for whatever reason, there's been some breach of this, and they think that they don't understand how that was going to be calculated. You want to be very, very clear and make sure that there's no ambiguity about how that payback is going to occur. In terms of, normally the big institutions, you're going to have a promissory note that's executed as part of this, so that if they do breach, that you've got this promissory note and can more easily execute upon, getting those monies back. Obviously, every contract for employees, you need to, go over the retirement and think about, over their benefits and how you're going to be handling those. Often just saying that they'll be given the existing, they'll be able to participate in the existing employee benefit plans allows you to not have to go over explicitly stating all of those things, but make sure you're referencing whatever the existing employee benefit plan is. Make sure that you always have that catch-all too, that can be changed, whatever, that this agreement is subject to those changes, whatever those changes are. Okay. So again, this just kind of goes to what two slides back, but just make sure when you're going over, and sometimes there are all these different things that, physicians are like kind of nickel and diming. Well, I want to be paid for this, and I'm gonna really hustle through the rest of us. Sometimes physicians are trying to nickel and dime you, like, well, I'm not going to supervise anyone unless I get paid. I'm not going to do this unless I get paid for it. And they're kind of demanding all these little things. And you need to really look at overall, if we're adding on all these different things, you need to make sure that that, again, is fair market value. And if they're being compensated for working 40 hours a week, and then they've got all these additional things that they're being paid for, but really those are done within their 40 hours a week, that's not going to be acceptable. So if they're being paid above and beyond the 40 hours a week for these certain additional things, there needs to be really good documentation that they're meeting those requirements. Call coverage, you guys are all aware that the OIG has said that paying for call coverage is acceptable in certain scenarios. But again, I always have to think about fair market value. Is it commercially reasonable? So I'm going to, there's a lot of content in here. I'm trying to think about what else in my 5 minutes we should cover. Call coverage, you guys also pretty comfortable with call coverage requirements? Okay. Again, I would just use this as a guide when you're going through and doing your physician contracting. Go through these slides and just make sure you've got your little checklist. But most of these, I think, are pretty standard. Referrals. This is something I think it's important to point out because it can kind of trip people up. So under Stark, you can condition compensation on referrals to provider. If it's a bona fide employment or personal services arrangement, compensation is set out in advance for the term of the arrangement. The requirement is in writing, signed by the parties, but there are exceptions to whether or not, to when they refer, right? So that they can make sure that they're referring patients to the proper people when they feel like it's proper. If the insurance isn't covered by a patient prefers another provider, that would be these carve-outs. So just make sure that you're kind of aware of that. I think that sometimes surprises people that you can do that, but there have to be these proper exceptions that fulfill what the OIG has said is acceptable. Make sure your termination provisions are really locked tight. You want to make sure, we already talked about this, but termination, there are different ways that you guys can structure your termination, but normally you've got termination without cause on 90 days, then you've got a termination for cause. You want to be very specific about all the different reasons that you can terminate for cause. Normally, my big institutions, they don't even have a provision that allows the physician to terminate for cause. It's only the employer that can terminate for cause. And the terminate for cause, you want to have, again, that's another place to really put in as much as you possibly can, and have some more ambiguous catch-all in terms of violating any hospital policies and procedures, any malfeasance, any acts that you determine in your reasonable discretion could affect the reputation of the hospital. That's when you put all that catch-all language in there so that if you, in your discretion, feel like there's been something that could harm you, that you're allowed to terminate. The one thing I would mention here too, that on the 90 days above here where it says terminate without cause. So normally I would say both parties get to terminate for cause, or sorry, without cause for 90 days. The one thing that you want to, I would put explicitly therein, is if the physician terminates on 90 days, let's say, or however many days you give them, you want to put a provision in there that says that you have the right to terminate them immediately. You can pay them the compensation for that period. But if somebody's unhappy and they're terminating, you don't want to feel like you're obligated now. If you've terminated, you're leaving, you're not vested, and you have to sit there for the next 3 months and hang out with each other. That's not comfortable. So if the physician terminates, give yourself the ability to immediately terminate and pay them out what you would owe them over that. I think these are pretty standard, your post-termination obligations. So make sure you just follow those key things. Non-competes, just want to mention that in Wyoming, there is nothing, there's no, some states like California in the healthcare space say that those by statute, you can't have a non-compete in the healthcare space for public policy reasons. So some states have that, Wyoming doesn't have anything, but if you're going to have a non-compete, you want to make sure the contract's fair, it's reasonable, it's duration and scope, and it's necessary to protect the legitimate business interest of the employer. I don't think that, I asked Brad, but there's really no case law in Wyoming where a non-compete has been struck down in the medical space, but be aware that it could be. And sometimes with my employers, even though in Utah we don't have anything explicit where a court has struck down a non-compete in the medical space, a lot of that is because in Utah we have a lot of mandatory arbitration. And so we don't have court cases that we can look to see, okay, the court actually struck down this arbitration, or this provision, because those are all private. But for example, I think we should be sensitive to the fact that there might be public policy reasons where you shouldn't do this, and especially in rural areas where people don't have providers. There's not a lot of providers that people can go to, right? So for example, one of my providers was a really specialized oncologist, and her employer had put in this non-compete that if she ended up leaving them, it really made it so she couldn't practice in Utah as an oncologist. So you're thinking, here are people that are terminally ill, and they're coming to you, and then all of a sudden you're terminated, and you're literally saying that these patients can't go to their oncologist. And some of those reasons, and in these kind of cases, if the physician were to dispute that, it's going to go before an arbitrator, and there may be plenty of times in Utah where an arbitrator has said, no, we're not enforcing that. That violates public policy, but we don't have any case law to depend on. But I try and be cognizant of that and make sure that it's reasonable, and for public policy reasons in the healthcare space, if you feel like this is a situation, just make sure that it's reasonable, because there could always be a chance that the court could strike it down. So I'm going to kind of just really quickly, I think that these slides go through the employment side and the independent contract sides pretty carefully. I'm going to scroll through a bunch of the slides on the other areas so you're just kind of aware of what resources we're giving you. But keep in mind for HIPAA, oftentimes we'll get questions about like an independent contractor who's in the medical space, and they're saying, hey, do I need to have them sign a BAA? And it's like, no, if they're part of your workforce, even if they're an independent contractor, that's not going to be required. Okay, so I'm going to just go through here. So just mentioning recruitment and retention agreements. Obviously, you can have these. You've got to make sure that there are a lot of requirements on those agreements to make sure that they fall within the federal guidelines and meet the exceptions under Stark and anti-kickback. But if you guys are doing recruiting agreements, especially in these rural areas where you're trying to get physicians to come out and you're lacking specialties, we can absolutely do those. You've just got to be very careful about how we do it. Lease use or space of equipment. This is another area where you see a lot of hospitals get tripped up, especially when I think in these rural hospitals where you'll have a physician, like people that want to kind of like timeshare and like, well, I want to use this a few hours. Can I use your machine or this space for this many hours, a month? Some of those get really tricky, and the government doesn't love that when you're doing these little kind of short-term spaces. leases. So you got to be really careful when you're doing leases, and especially if they are just kind of these part-time leases. I'm out of time, and Brad's going to come tackle me, and he's a really big guy, and I fear that. Let me just go through these and just make sure. This is what I was talking about, these timeshares. These can be really, really tricky. So just make sure if you're doing those and you've got like these small blocks of time and you're leasing space or equipment to physicians, you really need to make sure that you get good counsel and those agreements are airtight. Also, obviously, leasing office space to physicians. I had a situation recently where even though it was a very big national hospital, client, a lease had basically there had been a problem where the lease was non-compliant under Stark for a period of time, and I had to help them go through. We had to figure out, look at every physician that was part of that group, and this was a physician group that's all over Utah, but this was a hospital kind of in a more rural area. But we had to look at, okay, here's the time period where the lease was non-compliant. And we've got to look at every physician that had any ownership in that group. And that was tough because this was a big group where ownership was changing, weekly because people are coming and going. But we had to look through that period, see who had any ownership, see who had made any referrals to that hospital to figure out whether or not there were paybacks. So that really triggers issues if you have non-compliant leases. So, make sure that you're being very cognizant of that. So just make sure that you're going through, again, these slides, because we go through and show you additional resources that you can utilize, especially with the federal government. There really are some great resources. Sometimes people just don't know where they're located, but these slides will help you locate those resources, be cognizant of that. And then if you guys have specific questions, burning questions about certain contracts that you've got right now that you're questioning or concerned about, please go back and I'll answer any questions you've got. So thank you for your time.
All right, thanks, Chrissy. Okay, we're going to move on and talk about some of the marketing traps. This section, we're going to apply some of those things we talked about earlier in the broadness use stuff. And we're going to go through some of the common issues that I see, some of the questions that come up from hospitals or physician practices about what you can and can't do on the marketing side. Just remember that, as we've said a couple of times, marketing strategies that are okay in other industries aren't okay in the healthcare industry because of those laws that we've talked about. Let's start out by talking about giving freebies or discounted issues to patients. Patients, Medicare beneficiaries, they're referral sources, right? They can refer themselves. So if you're offering inducements in order to get them to come to you, then that potentially implicates the anti-kickback statute and the civil monetary penalties law. Some of the programs that you may see out there are just gifts. You're getting like a gift basket. I was talking to one of my clients years ago, and they mentioned something, well, as you're going into town, on the big billboard, they've got, deliver here at our facility, and you'll get 3 diapers for a year. Okay, well, why are they doing that? That's a violation, right? So sometimes you just don't think about those types of things. But if you're giving freebies, that potentially is a problem. It could be refer a friend incentives. Okay? Are you giving something in order to get referrals? Heck yes, that's the whole purpose for that, right? Free or discounted services like free screening programs. Come to us for this screening. Oh, you've got this condition? Then go over here and see our specialists. Take care of them. Are you giving them something for free? Yeah, you're doing the free screening. Why are you doing it? To get those referrals for those other services. That potentially implicates the regulations. Free meals, free transportation. You send out your bus to all the nursing homes around about to pick up the people to bring them in there to get services. Are you giving them something of value? Yeah. So it could potentially implicate this stuff. Waivers of copay deductibles, write-offs, paying patients' premiums, anything else of value that does not reflect fair market value could potentially implicate those statutes. Let's talk about some of those specific rules there. So when it comes to government beneficiaries, we're talking about Medicare and Medicaid. If it's private pay, you don't have the same requirements under the Civil Monetary Penalties Law and the anti-kickback statute. Under ECRA, you would. You gotta, remember that one dealing with labs. But under just general patients, Medicare, Medicaid patients, you've got problems. If it's private pay, you probably don't have the same situation. But for government beneficiaries, you generally can offer free or discounted items if it does not constitute remuneration under the Civil Monetary Penalties Law. That means, well, we'll get to that in just a second. Because those statutes prohibit you from offering incentives to induce referrals, if you know that that's going to likely induce them to use a particular provider, if it doesn't induce that, then you're okay. So if there's no way that whatever you're giving them is going to induce them to come back, you're probably going to be okay. Yeah. Mm-hmm. Okay, well, let's ask about it. Well, let's talk about it. Why are you giving them the basket? Is it done to induce or reward referrals for additional services or for services? If they're leaving and you're never going to see them again, yeah, probably you're okay. But you're not going to fit within the anti-kickback safe harbor. So the standard is going to be is one purpose of giving that basket in order to induce referrals. And if you're doing it because you want them there the next time they're delivered, or if you want them there to remember that so they're going to come back for the well baby checks or those types of things, then yeah, then it could potentially be a violation unless you're structuring it within one of the regulatory safe harbors. So the second item, the government has said, okay, this is under the Civil Monetary Penalties Law, they created this exception that says you can give gifts to patients as long as each gift is no more than $15, and they're not monetary. You're not just giving cash or a credit card or something like that. It has to be a non-monetary item of a value of up to $15 per gift, or up to $75 per patient per year. Okay, so you can give them, a series of, I guess, 5 gifts of they're worth $15 up to a year. So they said, as long as you do that, then that will be considered nominal value, and we're not going to look at it. Now, that's an exception that they've identified under the Civil Monetary Penalties Law. That doesn't necessarily transfer over into the anti-kickback statute, but because under the anti-kickback statute, the OIG enforces both, and they're the ones who said this, I think you're probably okay doing this if you want to give these gifts to your patients. Yeah. Hypothetically, some hospital or facility out there may do this. I heard, yeah.
So I heard
okay. So those of you. Mm-hmm. So the question is, what about if somebody, a patient is disgruntled and you're just trying to resolve the situation and smooth the issue? Could you send them like a gift card or something like that to do that? Well, it's not going to fit within a safe harbor unless the gift card is less than $15, right? You could do that and fit within the safe harbor. Alternatively, if you don't fit within that safe harbor, you ask, okay, well, what's the purpose for doing it? If you're doing it in order to resolve a settlement dispute, then you could argue, no, it's not done to induce further referrals. It's done as part of a settlement to resolve. So you may be okay. There's actually an advisory opinion out there on that will go through and talk about some of the other considerations. And there are other things that you would maybe want to consider along with that. If that's your process, you would want to have like a documented grievance situation that you can document that this is why we are doing it, and that you're not out there advertising it or something like that to promote people coming in. As long as you stay under the dollar amounts, you're going to be fine. All right, next exception. You don't fit within those. What about if the patient just simply hasn't got money? Well, then the government says, yeah, you can go ahead and write off copays, discounts, not charge the patient, as long as you can show that there's a demonstrated financial need, there's a good faith determination that the beneficiary has financial need, or you tried to collect and you can't get blood from attorney. You can't offer that as part of an advertisement or solicitation. So you don't use that write-off or those copays or the waivers and copays and deductibles as, you know, some reason to get people to come in. Hey, come in here and you'll do insurance-only billing. You know, it's kind of like those auto repair glass places, right? Come in here, we won't bill your insurance company, and we'll also give you a free dinner at the Hacienda or whatever the local Mexican food restaurant is. So you can't use it as a marketing gimmick. It can't be tied to the provision of any other federal program or business, and there has to be a reasonable connection between the item of service and the medical care of the beneficiary. If you satisfy those criteria, then you can write off their bill and fit within the safe harbor. There's also, you can provide gifts or freebies to patients if they are intended to promote the delivery of preventative care as determined by HHS. HHS has identified certain types of preventative care we want people to give. So you could do this for free. Things like mammograms. I think that there's certain well baby visits, but there's certain preventative care services that are identified in the regulations that would allow you to do it, but they're really limited, like mammograms and well baby visits afterwards. If the payment is structured to be with another anti-kickback safe harbor, you can do it. Or here's the one that's kind of the catch-all. Any other remuneration that promotes access to care and poses a low risk of harm to patients in federal health care programs. So if the benefit that you're giving promotes access to care and does not poses a low risk of harm to patients in federal health care programs, you're doing it and it benefits the program by providing, you know, preventative care, so it saves the program money in the long run. In those types of situations, you may be able to structure those and offer those types of benefits. We haven't got a whole lot of guidance on this, though. So if you're doing that, you know, make sure you look at it carefully. You may want to crack the commentary that accompanies the regulations and see whether or not your structure fits within that. That gives you some flexibility, but be careful, okay? Yeah. Like offering a free screening, we're going to come to free screening programs in just a minute, and we'll talk about that more. Yeah, that is, this one? I'm not sure which one's the, oh, there it is. There. That one is that. It's the task force. It's been identified as the preventative for the task force. Right. All right. Speaking of free screenings, okay? The OIG, there is no per se exception that applies to free screening programs. It may fit within the one that we just talked about, promoting access to care and poses a low risk of harm. But the problem is a lot of those free screening programs that you're doing isn't really to promote access to care. It's to use as a loss leader in order to identify people who need like diabetes services and things like that. They're trying to get people in order to induce more referrals, or at least that's the concern. Now the government has, though, in an advisory opinion, this is an advisory opinion related to a situation where the hospital would offer free blood pressure checks. The patients would show up to get the free blood pressure check, and if it came back high, then they would get some educational materials and some suggestions about what they needed to get for urgent care. In this situation, the government said that free screening test was okay if it's because it was not conditioned on the use of any items or services from any particular provider. The patient, it was not directed to any particular provider. The patient was not offered any special discounts on follow-up services. And if the test showed that there were abnormal test results, the visitor is advised to see his or her own healthcare professional. So it wasn't set up that, okay, you come back positive on diabetes or high blood pressure check, let me take you over to our cardiology clinic or over to, you know, some other situation. Instead, it came back positive and they were advised, you know, here's a list of providers that you can go check with, or you'd have to follow up with your own primary care. So it wasn't necessarily used as a feeder just into your service. As I mentioned, those advisory opinions, those are not binding on anybody other than the parties. But because we have a favorable advisory opinion, chances are if you structured your free screening program to satisfy these types of criteria, then you're probably going to be okay, even if you can't otherwise satisfy the other safe harbor. Yes, ma'am. What you would want to know the facts, and you'd want to be careful, right? what you may want to do is provide, not necessarily refer them over to your specialty, but refer them back to their primary care provider for further services. But just simply saying, oh, by the way, you came in, you got a specialist, maybe a dermatologist. You see it sometimes with dermatologists. Maybe they're the only dermatologist in there. We're going to offer free screenings to see whether or not you're mold. Oh, you came back positive, then here, we'll follow up with you on that. That is potentially dangerous. You might not get within the parameters here. You may be okay under this one if any other organization that promotes access to care and poses a low risk of fraud and abuse, but the government will take a hard look at it. Because really, why are you doing this? Are you really doing it out of the goodness of your heart to promote access to care, or are you doing it in order to get patients for your practice? If you're doing it to get patients for your practice, you need to be very careful. Remember, the test for anti-kickback statute, if you don't fit within the safe harbor, is one purpose to generate a reward in referrals. So you have to be careful. Okay. Let's talk about free transportation programs. Can you do that? Well, it's a transportation program, but is it remuneration? Is it a value? Yeah. So you need to be concerned about the anti-kickback statute and civil monetary penalties law. If you're sending it out and it's not likely to induce services, then it's not a problem, right? But probably is. So you might see whether does it promote access to care and pose a low risk of fraud and abuse. If you can satisfy yourself, yes, then you're probably going to be okay under the exception to remuneration under the civil monetary penalties law. But don't just assume that you can do that, because the government has issued safe harbors that apply to transportation programs. Now, what does that mean? That means that if they thought it was important enough that they had to issue safe harbors, that unless you fit within the safe harbor, the assumption is essentially that it is valuable, okay, and it may not apply. So another alternative then is you can go ahead and crack the books in the anti-kickback statute. There's the safe harbor for either shuttle services or a routine shuttle schedule, but you need to make sure that you structure your transaction to fit within one of those safe harbors. Or finally, if the transportation service is only worth less than $15 per pickup, you only pick them up 5 times a year, I guess, then you might be able to fit within the $15.75 exception. Yes, ma'am. So the question is, does it apply if the patient already has an appointment and the patient can't get there? Okay, let's go through the analysis. Are you giving that patient something of value? Yes, you are. So that means it's presumptively a violation of the and are you doing that in order to get patient services? It's one purpose in order to get the patient there so that they can get service. Probably, right? That's probably, you may be really altruistic, but it's going to result in benefit to you. So it's presumptively a violation. So you would need to make sure that you could justify it. So can you fit with any of these exceptions? If the patient already has an appointment, you could argue that, well, it's not really inducing additional services because she already had the appointment. But I think that it's risky. You would probably want to set it up to try to fit within one of these other exceptions, and you would want to analyze, for example, does it promote access to care with a low risk of fraud and abuse? All right, waiving copays and deductibles. We already talked about this. The government has said you can waive copays or deductibles so long as there's a demonstrated financial need or failed collection efforts, you don't use it as part of your advertising process, and you otherwise satisfy the criteria that's up there. That's for federal programs. What about private payers? Do private payers care if you waive copays or deductibles? Hell yes, they do. They care even more than the government, probably. In fact, if you're out there waiving copays and deductibles, you might receive a letter like some of the clients in Idaho received from Blue Cross lately, which said, quit it, because that's engaging in insurance fraud and it's violating our contract with you. So be very careful about waiving copays and deductibles. What about prompt pay discounts? Can you do prompt pay discounts? Well, if that prompt pay is for copays or deductibles, well, you've got a problem under the civil monetary penalties law unless you can fit within the exception for financial need. Okay? The government has identified in an advisory opinion, they allowed a prompt pay discount if you satisfy the following criteria. The amount of the discount relates to or avoided collection costs. It's offered to all patients for all services without regard to the patient's reason for admission, length of stay, or DRG. It's not advertised with the business. So you're not using it kind of as a marketing gimmick out there. Hey, come to us if you pay us, within X days, then we're going to go ahead and we'll give you a discount on the amount that we're charging you off your co-pays or deductibles. Okay? You can't use it like that. So the person's already incurred the service of it. And the costs are not passed to Medicare, Medicaid, or other payers. And to the extent that there are private payers involved, we notify private payers of the program, presumably, so that they can step in and say, well, if we pay properly, then we want the discount also. Again, this is an advisory opinion. It's only binding on the parties, but if you structure a prompt pay program around these requirements, you're probably going to be okay. What about self-pay discounts? This is a hot item right now. Can you offer your self-pay patients a discount? Some people have this thought. Have you ever heard this? You got to charge all your patients the same rate. There's this assumption out there that you always have to charge all your patients the same rate. Do you charge all your patients the same? Hell no, you don't. Go back to Blue Cross next time and say, oh, I got to charge all my patients the same. I got to charge you the same rate I charge you. No, you negotiate all the time. So can you negotiate self-pay patients? Generally, yes, you can, unless, okay, there are some limitations on your ability to do that. Some states limit the ability to charge different rates. They've got a statute out there. I'm not aware of anything in Wyoming that does that. Let me know if that's the case. But when I checked, I can't find anything in Wyoming that addresses this. There is some old commentary from way back when. For those facilities that are paid on a cost report, there's some old commentary from the government that suggests that if you're paid on the cost report, that your charge master has to be applied uniformly. Now, that was from years ago, and I have not seen anything recently come out on that. So that's just a little bit of an asterisk, so be careful. You may want to check with the person who prepares your cost report to see if there's a limitation on that. That may be a limitation, but as a practical matter, you don't charge everybody the same rate. If you're an FQHC, there actually is guidance, more recent guidance from 2018, which said that the charges must be uniform for all patients for FQHC. In some states, some states will allow insurers to put in their provision that what are called most favored nation clauses. It says that you've got to give us the best rates you give anybody else. So if you're going to offer self-pay discounts, then that may become effectively your best rate, and it may affect your other contracts. Now, most states don't allow most favored nation clauses, but in those states that do, you may have to watch for your insurance contracts. Okay? There is a potential problem too with the Medicare substantially in excess clause. You guys know what that means? Medicare substantially in excess clause says that you can't charge Medicare substantially in excess of essentially your usual and customary charges for everybody else. Stated another way, the most you can charge Medicare is the Medicare rate or your uniform, your usual and customary rate. So if you're offering a large amount of self-pay discounts, that may effectively become your usual and customary rate for those types of services. Now, for most of us, self-pay discounts are a tiny fraction of your total patient income. And so it's probably never going to implicate the substantially in excess rule. The way that it works is the test is whether the provider charges more than half of its non-Medicare or Medicaid patients a rate that is lower than the rate it charges Medicare. It doesn't come up very often, but just beware that if there are isolated circumstances, an isolated CPT code that you're charging less than the Medicare rate because they're a separate patient, you may have to drop your Medicare rate to that. Can you allow the patients to pay cash instead of billing the insurance? Maybe the patient has a high deductible or a high copay. Can you tell them, hey, we'll give you a discount if you pay cash instead of billing the insurance company? Can you do that? Well, generally not, because contracts require you to bill the insurer, and Medicare generally requires you to bill the insurer. However, we now have the HIPAA. There's a HIPAA exception out there. There's a HIPAA provision. Remember, as part of the omnibus rule, HIPAA came out with this new rule that said if the patient pays for their episode of care on their own, and they instruct you not to bill the insurer, then you can't disclose that information to the insurer. And the government said, because this is a federal regulation, it trumps contract provisions. So just because even though the private payer says, no, you got to bill us, under HIPAA, you can't. HIPAA trumps the private contract terms. Well, what about Medicare? Medicare has an exception, but they require you to get the patient's consent to bill Medicare. And if the patient withholds that consent, you don't have to bill Medicare for it. What about Medicaid? It depends on the state law. It depends on whether Wyoming Medicaid requires you to bill Wyoming Medicaid. If they don't, then HIPAA would trump that. So you could have a provision, you could do an agreement where you say, okay, patients, we will allow you to pay cash. We won't bill the insurance. We'll give you a discount. And under HIPAA, you would be able to do that. Now, be careful about doing that because it comes with unintended consequences. If you do that, what does that mean? That means you've got to segregate that data with regard to that episode of care so that the payers never get to that other information. I mean, that's the HIPAA side of it. And that can create logistical nightmares. I just wanted to point that out because a lot of people are considering cash pay discounts or cash billing prices. There is a way to do it now, but there are unintended consequences for it. What about drawing for a prize? Could you have a, yeah, question? So is there a problem if the patient then goes ahead and claims, files a claim with Medicare or their insurance company on their own? Yeah, there is. You would want some kind of an agreement with the patient that they're not going to bill. Okay? And if they violate it, it's probably not your problem. You'll be okay. What about drawing for a prize? Do you ever have this situation? You see it at the dentist's office, right? They use this as a marketing gimmick. But for all of our patients, we'll draw a prize. Well, are you offering something of value? Yeah, a chance to win a prize. If the chance to win a prize is valued at less than $15, then you're probably going to be okay. But if it's higher, then you may come into problems. You also have to be careful of other laws dealing with sweepstakes, raffles, lotteries, and those kinds of things. Those kind of cover the main things that we talk about in providing freebies to individuals. What about freebies offered to other providers? Does that implicate starting any kickback statute? Yeah, if it's offered to other physicians, then you've got to be concerned about START, and you would want to structure the arrangement if they're within regulatory safe harbors. One thing that comes up is at hospitals where you are, if you want to do joint marketing, maybe you're at a hospital and a local physician wants you to come to them and subsidize their marketing practice or to market their practice on behalf. Well, you're providing something of value to that physician? Yes. If you're doing it, then you're going to want to structure the bill within a regulatory safe harbor. For example, the START compensation, it's the non-monetary compensation exception or something like that. Well, what about the joint marketing efforts? Maybe you want to market a new service line, and you've got an independent contractor specialist in the community that provides these services. The hospital wants to partner with them. Can you do a joint marketing campaign? Generally, yes, but if you're going to do that, you want to make sure that that specialist is paying his fair share, based on the relative degree. To the extent that you are marketing their practice, it's a benefit and they need to pay for that. Otherwise, it's going to be a START violation. What about paying independent contractors based on a commission? So, for example, maybe you contract with an advertising company or something like that you're going to pay them X dollars for every referral that they generate. Well, the government has said that could violate START because you are paying based on referrals. It could violate the anti-kickback statute. Okay? If you can do it for employees, the OIG commentary suggests you can do it for employees, but if you're going to pay a commission-based compensation arrangement for some other entity in order to generate referrals so that they're getting paid based on referrals, then you're not going to fit within the anti-kickback safe harbor, and it's going to create your potential problems. All right, that is a brief summary of some of those freebies. There are some other issues that we didn't get a chance to talk about, some things like telemarketing and that, but that's all in the materials. If you have any questions about that, by all means, let me know. I'll be around during the break and you can talk about it, or you can just shoot me an email. Otherwise, I turn the time over to Brad.
Thanks, Kim. As always, interesting. We're going to go on now and talk about telehealth. Switch presentations here. Oh, there we go. Great. We're going to cover this topic in about 30 minutes. So what we're going to do is bounce along the top of some of the issues that you need to think about as you engage in various telehealth arrangements, either as a originating site or as the actual location for the patient or as a provider site. The law in this area is primarily regulatory at this point. Various agencies, including CMS, have adopted regulations to address different aspects of the provision of services by telehealth or telemedicine. There's very little case law out there that covers these areas that we're going to talk about. So when you contemplate a telehealth arrangement, you're really going to be looking at how do regulations affect our plans in a variety of different areas that touch on healthcare generally. How does telemedicine fit into the way that healthcare business is conducted in a variety of areas? So that's kind of how we'll spend our time today. Just so we're all on the same page, definitionally, telemedicine, the provision of clinical services to patients by physicians and practitioners from a distance via electronic communications. There's a few different subcategories of that: simultaneous, synchronous, or real time. That's the stuff you can get paid for. Audio and video, real time communications. Remote monitoring is also can be reimbursable. Non-simultaneous, asynchronous store and forward work it is not really being treated as telemedicine per se by CMS. You can't really bill for that service at this point in time as a telehealth or telemedicine service. But those are all grouped together under the big rubric of telehealth. A couple of additional definitions. There's an originating site or a spoke site. That's where the patient is. And then you have a distant or hub site where the practitioner is. And those concepts are pretty well separated in about every source. Interestingly, you kind of have to go back to whatever regulation you're looking at. Wyoming has a board of pharmacy regulation that's called telepharmacy, but it really has nothing to do with the practice of telemedicine as defined by CMS. It involves the location of a pharmacy in a rural area that doesn't have a retail pharmacy, and how prescriptions can be filled in a rural area more than 10 miles from a retail pharmacy. So it's a strange sort of different aspect of telemedicine or telehealth. So you really have to go to each set of regulations that you're thinking about, and we'll touch on most of the pertinent ones today and read what their definitions say and how they apply the rules. When you think about telemedicine or telehealth, you're going to need to think about licensure and credentialing of your providers. Where are they licensed? Where do they need to be licensed? What standard of care applies depending on the location of the patient? How do you give informed consent? How do you get informed consent, I should say, in that sort of a setting? And then reimbursement, of course, you want to get paid for the services you're providing. Every state licenses their healthcare professionals independently. And we all know this, and so Wyoming, of course, has its own healthcare licensing, both for doctors under the Doctors and PAs under the Medical Practice Act, and then the Nursing Practice Act covers, from CNAs all the way through advanced practice nurses. Pharmacists, of course, the Board of Pharmacy and the Pharmacy Practice Act, and you can go on with some of the other healthcare providers. But one of the basic rules that applies across the board with telehealth is that the healthcare provider has to be licensed in the location where the patient is, as well as the location where the provider is. So you have to have that dual licensure in order to provide telehealth services. There's a limited exception to this for consultations. So a Wyoming physician can consult with an out-of-state physician on a very limited basis, and that out-of-state physician, as long as they do not consult more than 12 days every year in Wyoming, they can consult without being licensed in Wyoming, as long as they're consulting in association with a licensed Wyoming physician. So you've got some very strict rules about practicing medicine from outside of Wyoming. Yes. So let me get this. So the patient is treating with a Wyoming provider in Wyoming. The patient then goes out of town, and are you?
Yeah,
Well, if you're just calling, it's not telemedicine.
no,
Yeah, that's a great question. And you're planning to return to Wyoming, and you're just there on vacation or something like that. What do you think, Kim?
Sorry for those guys who are offsite. The Board of Medicine is the one that's enforcing this stuff, right? So most of the time, for an isolated situation like that, most of the boards will say that's okay. They're concerned about the more established type practices. But the isolated situation, my experience with the licensing boards has been they don't get bent out of shape for that type of a situation. What they are concerned about is where you've got this ongoing process where they're reaching out and providing services on kind of an ongoing basis. But just taking care of a one-time patient you've already got a relationship with, most boards don't care. Now, it's possible that that board in that other state might get bent out of shape, but usually I've never seen them go after a physician for those situations. Brad, I'm not sure whether you've seen it differently, but that's...
I have not. I haven't seen that happen. Of course, you can quickly see the situation where the provider really wants to work out of his house at Steamboat. So, yeah, that could pose a longer term problem. Anyway, thank you, Kim. Appreciate you coming in on that. Other sorts of licensure exceptions that really don't play in uniquely to telehealth, but that are out there. The VA, the Public Health Service, military providers all can practice within their organization across state lines. The Nurse Licensure Compact allows for some multi-state licensing. And then the one that's probably most pertinent and most helpful is the Interstate Medical License Compact. And Wyoming's a member of this compact, one of the first members, maybe even the first state to adopt the right legislation. Was it the first? And that allows for expedited physician licensing from state to state under the limitations that are established under the compact itself and the board regulations. So that's a very helpful compact in establishing telehealth relationships, because you can do so rather promptly. I have not helped somebody through that expedited licensing process, but for those of you that have, is it truly expedited? Okay. So and then I think it's there's some post-licensing requirements that you have to follow. But the compact is growing all the time. Most of our surrounding states are part of it. In fact, all of them are. I think Utah maybe is part of it as well now. So that's a useful tool. The conditions of participation obviously require that the providers be licensed, all professionals be licensed and authorized to practice in the state where the hospital is located, as well as when using telehealth, the practitioner providing the patient service must be licensed and or meet other applicable standards required by the state or local laws in both the state where the practitioner is located and the state where the patient is located. So they leave very little room for doing these things on an ad hoc basis. You really have to plan ahead to provide telehealth services and know who your providers are in advance so you can comply with these requirements. Most states, the Medicaid rules require licensure in the state of where the patient is, and the guidelines, obviously, we're quoting the telemed guidelines from Medicaid here, and requiring that you're complying with your State Practice Act in the state where the patient is located as well. There's really no room for negotiation there. The distant site practitioner and the originating site should ensure that they're licensed and otherwise authorized wherever the patient is, as well as where the physician is. Some interesting Board of Pharmacy regulations, and again, Board of Pharmacy hasn't really jumped into telepharmacy in the same way that the Board of Medicine has addressed telehealth. But one thing the Board of Pharmacy has said is that if you're prescribing through what they call an Internet Practitioner Consultation Questionnaire, you are violating Wyoming law. You are not authorized to use a Internet questionnaire that does not involve an actual consultation with a licensed provider. So this is, embarrassing to say. I mean, this is the little purple pill questionnaire that companies were using to prescribe via the internet a variety of those kinds of drugs without having any sort of provider directly involved with the patient. Non-resident pharmacy has to obtain a Wyoming non-resident pharmacy license and comply with Wyoming law and counsel Wyoming patients verbally or in writing in order to fill prescriptions into the state of Wyoming. There are some good resources out there. The Federation of State Medical Boards have model policies for the appropriate use of telemedicine on the provider side. They cover a lot of the things you would expect a Board of Medicine to be concerned about, and also, really help in making sure that the playing field is subject to some consistency. The AMA has issued ethical practice guidelines for telemedicine, which again are also a helpful resource. State boards are not necessarily adopting these things verbatim, but they certainly are. They certainly do reflect common themes among the state boards when it comes to how to regulate telemedicine from the provider side. Credentialing raises some interesting issues. The conditions of participation address the requirements for the hospital when it comes to credentialing distant providers. The hospital governing board has to address, what are we going to do about credentialing distant providers? Are we going to rely on the credentialing process that the hospital where the provider is already credentialed uses? If we're going to do that as a governing board, we have to have a written authorization. We have to have a contract with that facility that specifies the required components of their credentialing and peer review process, and their commitment to maintain those things, their commitment to share credentialing information with the originating site, and there are some other criteria that must be in that written agreement as well. The board of the facility has to amend the bylaws, and including the medical staff and the board have to amend the bylaws to address the credentials of remote healthcare providers under a telemedicine arrangement. So there are some very specific steps that have to occur under the conditions of participation before you can implement this sort of an arrangement. Liability issues are something to consider as well. There are a variety of state-by-state requirements that govern everything you do in the healthcare field. Those vary significantly by state, and when you think about if you're going to be providing services across state lines, it's going to be really important that you consider where your patients will be located and how you will comply with, or at least manage your risk associated with, the laws and requirements in those other states. And by saying managing risk, I'm not suggesting you would make a decision not to comply. I'm suggesting that what you need to think about is the malpractice environment there different than here? Are there regulatory things that change our risk profile when we treat patients who are located in this other state, even assuming everybody's fully licensed like they're supposed to be? Are there other implications that we need to think about? Your liability insurance company will expect you to raise this idea with them in advance, because insurance may well not cover activities in another state if you don't purchase your policy with that being disclosed and covered expressly. Different procedures for enforcement or for liability issues in other states, these obviously don't affect the care necessarily at the time the care is being given, but they may affect how anomalies are evaluated under the legal system of the other states. So when you have an exception, a situation that doesn't go as planned, how are your rights and responsibilities and your patient's rights and responsibilities, how will those be evaluated? What are the rules? What's the playing field look like? Well, these things need to be understood in advance so that you can protect against anything that's different than how you would normally do it in your state. And there may be some differences. There may be some quirks that require you to set up your telemedicine programming and your internal policies to address some unique characteristics of another state. Practitioner-patient relationship. This again is kind of in a state of change, I would say. In a traditional telehealth, I'm not sure there is such a thing as traditional telehealth, but in most of the regulatory frameworks suggest that this is going to be a face-to-face, not in person, but you're going to have audio and visual connectivity with the patient in a telehealth setting. That may not be the case in all situations. So you need to think about when does the practitioner-patient relationship come into being? Does there have to be direct contact? And it's kind of one of those questions that I think can change from situation to situation. Would a reasonable patient believe that they have a patient-physician relationship? That those factors could be direct contact, obviously. If the patient is communicating with a provider, that provider may, or that patient may believe that's my doctor. Is there a contract or an agreement to provide care to that patient? Does the provider or the provider's organization bill for services? I think about some of these, when you have a group healthcare plan, you can sometimes have an adjacent wellness program that's operated by a remote provider, right? Or a health advocacy program. We have something like that where I can talk to a nurse about a healthcare problem by phone. Well, I don't know where that nurse is. I don't know if they're licensed in Wyoming or not. And if I'm a normal patient, I'm not even going to think about that. I'm going to pick up the phone and say, my kid's got 103-degree fever. It's 2 in the morning. What should I do? And I'm going to expect this nurse to give me medical advice, right? Well, do I have a provider relationship with that nurse? Do I have a provider relationship with that nurse's, whoever contracts with or pays that nurse? So those are all interesting questions that this remote patient care model that's developing raises. And so then, you've got to ask yourself, what am I providing as an entity, and what does that mean for the provider-patient relationship in whatever state might contact me? If you're offering this service in a multi-state region, or, like your question about being out of town, is that going to be covered? Am I going to have a new relationship that's going to come up if somebody's son or daughter calls me because their parent had a relationship with our hospital? These are all, questions that need to be sorted out in advance to getting into this sort of area. Malpractice liability, I touched on really briefly. When you look at the case law for malpractice, it speaks in terms of the standard of care for the specialty in the area or in the community where the care was provided. That's kind of the standard for judging whether the practitioner or the institution provided negligent care. The community part of that standard is sort of slowly being weakened, if you will, by courts who are saying, now we have national, there's a national standard of care for healthcare. It's not a community standard. That's not uniform by any means, but it's important, I think, if we're going to extend a service, a telehealth service into another state, what is our standard of care? Is it measured by what would happen in Cheyenne? Is that measured by what would happen in the other state? And you can't answer that question. You're not going to be able to answer that question in any sort of definitive way on the front end, but I think it's helpful to think about whether that makes a difference in how we provide care through this medium, or maybe not at all. But it's something to contemplate. Then you, of course, have patient-by-patient considerations about whether telehealth is appropriate for that patient. Those are probably some parameters you can develop on the front end about we're not going to provide telehealth services under these circumstances or with these conditions, et cetera. But that all needs to be worked into your thought process before you go out and do this in a broad way. Informed consent getting informed consent is important. The Wyoming State Manual has an informed consent form for telehealth patients, and they require that, and they require that at least for some scope of care. I really couldn't figure out from some of the ambiguous language, or at least I thought it was ambiguous, whether it's required for all of the potential telehealth services. But it's certainly not a bad practice to use it across the board. Is there differences that you need to discuss in getting informed consent? Sure there are. I think there are differences in the conversation that a provider will have with a patient in person about getting informed consent and what that means and how that would be different through a telehealth medium. Those things need to be considered in advance, and the providers need to be prepared to cover those things in their informed consent process, so that you are covering the various risks associated with telehealth that are different than the risks that might be associated with a person in your clinic or in your ER. Privacy and security of data communications is obviously a HIPAA-related issue, but all the HIPAA security rules apply to that transmission of voice and audio in a telehealth medium. So you have to really, obviously that is a entirely different HIPAA challenge than just your EHR system or something like that. So you need to think about it, and you need to have technical people involved in making sure that's covered appropriately under HIPAA. Liability insurance, your policies, I think it's a fair guess, are specific to your state of operation. They are, the underwriters look at, you're going to practice medicine in Wyoming. Wyoming has this tort law profile, and we're underwriting your risk based on this tort law profile. If you're going to go practice in Idaho or Utah or Colorado, that insurance company has different underwriting considerations for each of those states. If you establish a telehealth presence in various states and do not upgrade your insurance for that, your insurance company may well have a reason to deny your coverage in the event your remote patient has a claim or asserts a claim. It's very important that you involve your insurance company in this process before you dive in. Reimbursement. This is a growing area. We're seeing more movement on reimbursement in the circumstances when telemedicine is reimbursable. I don't know. I haven't really compared what private payers are saying about this. I think, judging by how the menu of services is being expanded in telehealth, my guess is the private payers are probably encouraging some degree of that, because it's going to be a lower overhead, less costly means of delivering service for private payers in the long run. CMS pays for telehealth if the conditions of payment are under Part A. Conditions of payment are satisfied. Part B, telehealth is paid for if you're using interactive audio and video telecommunications, providing real-time telecommunication practitioners, connecting them with the patient at the originating site. Part B does not pay for asynchronous, I have not been able to say asynchronous, thank you, store and forward technology, except in a very small place. Patients have to be present and participating. Another physician or a telepresenter is not required unless medically necessary, as determined by the distant physician. Variety of valid originating sites. Again, originating is where the patient is. So if you're in a healthcare provider an area with inadequate healthcare providers, or a county outside of a metropolitan statistical area, then you're in one of these proper types of facilities. The patient home is limited to certain kinds of care from the patient's home, coupled with in-person care. The practitioner has to be one of these categories of licensed professionals, and licensed in the state in both locations, obviously. The services include a variety of services. One thing that is expressly excluded is group psychotherapy. You can't have a big Zoom meeting and do group psychotherapy. It's got to be done. It's got to be done in person for group psychotherapy. But otherwise, a variety of services that are specifically spelled out in the conditions. There's another list. I'm not going to go through those in detail. No facility fee can be charged by the originating site. The provider, the distant provider, is the only provider that can bill for the service, and you know, and so that's where you get paid on that. Wyoming Medicaid, the manual talks about, obviously requires Wyoming licensing rules, compliance. It defines telehealth as, you know, very similar to how the federal regulations do. And then, of course, each site bills for their own service. The originating site can bill a site fee, and then the hub site where the provider is. Telehealth consent form required in the patient, even if it's in the patient's home. The patient can revoke the consent to telehealth at any time, and then all of the other requirements for reimbursement apply. One very consistent theme across the regulations is that nobody's paying for your equipment. All the equipment is at the hospital's own cost, all the transmission costs, et cetera. So all that upfront investment is yours. And there are a variety of good resources out there. This is an area that is changing, you know, frequently and rapidly, and so it's these organizations do a good job of keeping up with those changes and talking about the cutting edge things that are going on in the world. All right. Any questions? Christy. Here. Wait a second.
I think it's just important to mention this because sometimes, like right on the border of these states, like Evanston, these doctors kind of going back and forth. In Utah, this happens a lot where our providers are kind of headed back and forth. A few years ago, I dealt with this for one of my hospital systems, and if a physician is doing telemedicine, let's say they're a Utah provider, they're providing telemedicine in Wyoming, not only do they have to be licensed in Wyoming, but they need to have a DEA registration in Wyoming. And that gets forgotten about quite a bit. So you have to, and I verified that with the DEA field office, that yes, you have to have a separate registration in the state where you're doing telemedicine.
Thank you much. Tala.
All right, gang. We scheduled this just before lunch, so for if any of you are with physician groups and you don't particularly care about IMTALA, then feel free to get up and take a longer lunch. For the rest of you who stick around, or for you who are providing call coverage from physician groups, you may want to stick around to listen to stuff about IMTALA. All right, this is probably the most important slide. When it comes to EMTALA stuff, and I deal a lot with EMTALA cases, when in doubt, do what you need to do to keep the staff and the patients safe. As long as you do that and you document it, you're probably going to be okay from the regulatory standpoint. You may have to do a plan of correction, you may have to respond to an investigation, but generally the government's not going to come down on you. I know I've talked to some of the OCR officers who's in charge of interpreting EMTALA, and one of my favorite quotes is, look, as long as you're doing what's in the best interest of the patient, then you're not going to have a problem with that. And I truly believe that. The problem is, in almost 90% of the cases that I deal with on EMTALA, they did the right thing, they just didn't document it. So it's really important to document. Why do you have to pay attention? Well, for civil penalties, you can get hit up with penalties under EMTALA. They just upped this, by the way. It used to be $50,000 for physicians. Now it's up to $106,000, about $107,000 for personal liability of physicians who fail to show up or improperly transfer patients out. Hospitals, the fines depend on the size of the hospital. If it's less than 100 beds, it's about $54,000 per violation. If it's 100 plus beds, then it's $107,000 per violation. In addition, hospitals can actually be sued under EMTALA. There's a private cause of action. So patients could sue, or other facilities who receive improper transfers could sue the hospital for their EMTALA violation. Most often, though, God, as long as I've been doing this, I think I've only had 1 or 2 cases where the government was actually seeking penalties and we were able to get those knocked off. Most of the time, it's just they're going to come after you in your provider agreement. They can terminate your provider agreement if you're violating EMTALA. In general, the basic EMTALA rules are that if you are a participating hospital, so you participate in Medicare, and you have a dedicated emergency department, then you've got to provide your emergency medical screening exam. If that screening exam reveals an emergency medical condition, you've got to provide stabilizing treatment or an appropriate transfer to another facility. If you are a participating hospital and you don't have a dedicated emergency department, but you do have specialized capabilities, like you are a physician hospital, an orthopedic clinic, orthopedic hospital, specialty hospital, if they're participating in Medicare and they have specialized capabilities, then they are obligated to receive a transfer of an emergency patient from another facility unless that hospital is on diversionary status. And you cannot delay exam or treatment to inquire about payment. Let's talk, yeah. Mm-hmm. Okay, the question was, a hospital's been told by the ED doctors that they have to provide both the screening exam and stabilizing treatment before the patient's transferred. That's not the case. They can either have to provide stabilizing treatment or an appropriate transfer. Now, as part of the requirements for an appropriate transfer, they have to provide stabilizing treatment to the extent they can, but they can still transfer, and we'll get to the transfer requirements in a moment. So, here's how EMTALA works. This is my quick and dirty summary of EMTALA. EMTALA applies if a patient comes to the hospital. They've got to come to the hospital before EMTALA is triggered. If, for example, the patient just calls in, they're in a private car, say, hey, I'm heading into your facility, my wife's getting ready to deliver the baby, you can send them out. You don't have to accept that person, or you don't have to talk to them or anything like that. EMTALA is not triggered until they arrive on hospital property. Now, the key then is defining what is hospital property. Hospital property includes the main campus and the area 250 yards around the hospital that's owned by the hospital, owned and controlled by the hospital. If it's a separate physician office within that area, that physician office is not part of the hospital, then EMTALA would not apply if there's an emergency that exists there in that separate facility. It only applies to the facilities that are owned by that hospital within 250 yards of the main campus. In addition, it applies to an off-campus facility that's billed as a provider-based department of the hospital, so it's part of the hospital for Medicare purposes, like, for example, an urgent care center, if that off-campus facility has a dedicated emergency department. The guidance is from the OCRs basically said, we think that in order to be a dedicated emergency department, you have to satisfy 4 criteria. One is you're licensed as a emergency department. 2, you hold yourself out as a place where people can show up to get care without a pre-scheduled appointment. They say, that's the trick. That usually applies to most urgent care centers. So if you as a hospital are operating an urgent care center and you're billing it as a provider-based department of the hospital, then EMTALA is going to apply to patients who show up at that particular facility. Finally, the third area is if the patient is in a hospital-owned ambulance, then that patient is deemed to have come to the hospital, and you would have to jump through EMTALA hoops before you could transfer them to another facility, unless there's certain limitations if they're operated under a community-wide protocol, and that protocol determines that they go someplace else. But generally, if they're in a hospital-owned ambulance, they are considered to have come to the hospital, and they are your patient. When it comes to diverting inbound ambulances, the rules differ somewhat depending on whether or not it's a hospital-owned ambulance. If it's a hospital-owned ambulance, they are your patient, and you can't divert them unless you jump through the EMTALA hoops for an appropriate transfer to another facility. On the other hand, if it's not a hospital-owned ambulance, just the county ambulance service or whatever, then you, if they're not inbound, you don't have to accept them, right? But on the other hand, if they are inbound, there's several cases from around the nation that have said if they're inbound, you can't divert that inbound ambulance unless you're on diversionary status. Now, if you're on diversionary status, you would want to be able to document that in the records, show that you're on diversionary status, then you explain it to them. Now, I get this question quite a bit. A lot of times, especially because we represent a lot of rural facilities, you guys have got a lot of rural facilities in Wyoming. County ambulance service picks up somebody from a motor vehicle accident. They require trauma services that this local critical access hospital, this COT simply doesn't have. And that COT says, no, don't bring that patient here, send them someplace else. Now, they can tell that if that patient is inbound to that critical access hospital, if that critical access hospital is not on diversion, they can't divert it. What they can do is say, this patient needs care that we can't provide. I am not diverting you. I'm not on diversionary status. I'm not diverting you, but I'm telling you that that patient really needs to go someplace else. If that patient, we bring that patient here anyway, we're going to fulfill our obligations under EMTALA. We're going to provide as much care as we can, but I'm telling you what we're going to have to do is we're going to have to provide care, and then we're going to have to transfer that patient anyway, and it's better that that patient goes directly to that other facility. I am not diverting you, okay? I am not on diversionary status. I'm not diverting you, but I'm telling you that's the way that it's going. That's how you handle those situations, okay? You understand the difference between diversion and simply recommending where they go. The ambulance company won't hear that. You need to make sure it's very clear that they understand you're not diverting them, you're not on diversionary status, that you're recommending they go someplace, but you make it clear that you'll take care of the patient if you bring it in. All right, so patient ends up at the hospital. Your obligation is to provide a medical screening examination. Now, in order for it to be a proper medical screening examination, it has to satisfy three criteria. First, it has to be performed by a qualified medical person. Who is a qualified medical person as defined in EMTALA? Who can be a qualified medical personnel? What do they have to do in order to be qualified medical personnel in EMTALA? Anybody? Can it be physicians? Sure. Can it be advanced practice professionals? Could it be a nurse for labor and delivery? Yes, if they're identified in documents that are approved by the governing board. The governing board determines who a QNP is, okay? And that has to be in a document that's approved by the governing board. You can't willy-nilly just identify who it is. And even if it's somebody who's eminently qualified, if they're not in a document that's approved by the governing board, they are not a QNP, and I've seen hospitals get cited for that. So go back and look. For example, it may be that you want your L&D nurses to be QNPs for certain types of services, to be able to, for example, certify that the person's in false labor. Well, that would be fine. They can do that as long as they're acting within the scope of their licensure and they've been identified or designated by a governing board, the governing board, that they can do that type of stuff. Okay? So first thing, it has to be done by a qualified medical person. Second, it has to be done within the hospital's capability. That means that if you've got, whatever specialized capabilities that are necessary for that screening exam, you've got to use that, those capabilities, and you don't discriminate based on the payer's source. Third, it has to be sufficient to determine if the patient has an emergency medical condition, which is generally defined as a condition that If you don't provide necessary care, that it could seriously result in adverse consequences to the patient, or in the case of a pregnant mother, that the baby's delivered the child in the placenta. Okay? So, patient comes, you give them a medical screening exam. If that medical screening exam shows that the person does not have an emergency medical condition, EMTALA ends. You don't have any further EMTALA obligations. Okay? You may have malpractice liability if you did it wrong, but as long as you gave an appropriate screening exam, EMTALA ends. You just want to document that. On the other hand, if you determine that the patient does have an emergency medical condition, then you've got to provide either stabilizing treatment or an appropriate transfer. Oh, I should go back up. If you do that screening exam and you determine that you admit the patient as an inpatient, once the patient is admitted as an inpatient, it ends EMTALA obligations, okay? You could admit them. Later on, you can transfer them without jumping through the EMTALA hoops. They do say that you can't just admit them so that you can discharge them, right? You have to admit them in good faith to provide inpatient care. But once you admit them as an inpatient, EMTALA ends. It cuts off. Because EMTALA was designed not to protect inpatients. It was designed for the situations where patients show up and they're not already a patient. If they're already a patient, you've got malpractice liability, right? They're already protected. If they're an inpatient, there's conditions of participation that protect them. EMTALA was designed for those people who show up before they're admitted, okay? But once you admit them, EMTALA ends. Now that's important, especially for your rural facilities, because once that patient's admitted, that terminates your EMTALA obligations, not only for you, but also for those receiving facilities that would otherwise be obligated to accept that patient. So if you know that you're going to transfer that patient to another entity, especially if it's like a psych facility or others, that they're not interested to receive that patient, don't admit that patient. Because once you admit them, they're not going to, that other facility is not going to be obligated under EMTALA to accept that patient. So be careful about admitting the patient if you know you're going to be transferred. All right, so you've done the MSC, you concluded that the person has an emergency medical condition, then you've got to provide either stabilizing treatment or an appropriate transfer. What is stabilizing treatment? What is treatment within the capability and capacity of the hospital, including on-call physicians and the like, that's necessary in order to stabilize the individual. What does stabilize mean? Well, if you look at the regulations, it means that the person can be transferred without suffering an adverse consequence, without a decline in their health. When you look at the interpretive guidelines, they have actually a different standard. The standard under the interpretive guidelines is that the emergency medical condition has been resolved, even though the underlying condition is still there. So the person may be suffering from a heart attack, right? You stabilize them by putting them in a stent. The person still has cardiac problems. It's not resolved, but you could stabilize them by putting them in a stent. Now, a person could either be stable for transfer to another facility or stable for discharge. Under the interpretive guidelines, the definition for transferring to another facility is, again, that you've resolved the emergency medical condition, even though the underlying medical condition is still existing. But they can be transferred from point A to point B, you resolve that issue, okay? That's stable for transfer to another facility. What about stable for discharge home? Anytime you're transferring the patient outside of your facility, that is a transfer for purposes of EMTALA, even though we might call it a discharge, transfer home, whatever. As long as you're transferring that patient outside the facility and the patient's not going A&A, that is a transfer. You need to make sure that you satisfy the criteria, okay? You can discharge them, you can transfer them out. The standard for discharge is that that patient could later receive appropriate follow-up care either as an inpatient or an outpatient without a material decline in their condition, and you give them appropriate a follow-up plan. If you do that, then you can go ahead and transfer them out. You can discharge them. Again, the patient is stable and EMTALA ends once the patient's stabilized. They have malpractice problems if there's an issue, but EMTALA ends. What are you going to want to document? You're going to want to document that the patient's stable. Use that language, patient stable. Okay? Once the patient's stable, EMTALA ends, and there is no further obligations. Once the patient's stable, you can transfer them, you can send them home, you can do whatever you want to. EMTALA ends once that person's stabilized. Now, on the other hand, if they're not stable and you can't stabilize them, you've got to do an appropriate transfer. In order for it to be an appropriate transfer, you've got to have one of two things. You can transfer the patient. If the patient's not stabilized, the hospital may not transfer the patient or discharge the patient unless you have one of two things, okay? Either, the first one, you've got to either have the patient or the patient's representative requests the transfer. Remember, EMTALA doesn't trump patient consent, right? Patient can always refuse to get care at your facility or request the transfer. So you either have to have patient consent for the transfer, or you've got to have physician certification that the benefits of the transfer outweigh the risks, okay? Now, can an APP provide that certification? You guys know what an APP is, right? Okay. Used to be known as mid-levels, but they get offended now if you don't call them advanced practice professionals. Can an APP or another QMP, a nurse, can they give that certification? No, it has to be a physician certification. If there is no physician available, that APP can consult, or that other person can consult with the physician and sign, but the physician has to countersign. It has to be the certification that the benefits outweigh the risks always has to be done by a physician, okay? So you have to have either patient consent or physician certification. Usually you want to have both to protect yourself, right? But either patient request or consent or physician certification. In addition, when you're transferring them, the transfer has to be appropriate when you're transferring to another facility. In order for it to be a transfer, an appropriate transfer under EMTALA, that appropriate transfer has to satisfy certain criteria. That means that you have to provide treatment that's within the capability to minimize the risk during the transport. You have to contact the receiving facility, and the facility has to agree to accept the transport. Now, does that have to be physician-to-physician contact? No, it doesn't. You just have, the regulations just say you have to contact that other facility. Now, if you're the receiving facility, you might want to be really careful about how these are done. You might want to have a protocol about who can accept the transfer, because sometimes physicians in local area will call specialists in other areas agrees to accept the transfer without ever notifying the hospital. And the hospital has no idea that this person's coming. And they may be on diversion, or it may be something else. They may not have the resources. So you may want to work with your referring hospitals to make sure that there's this process. They know who they're supposed to call in order to accept the transfer. Okay, so in addition, the transferring hospital has to send the relevant medical records. To the extent that there are other medical records that they generate afterwards, they've got to send those as soon as possible. And the transfer has to be effected through qualified personnel with proper equipment, including life support measures if it's appropriate. Now, among the other things that the transferring hospital has to send, if the transferring hospital is sending that patient, and the transferring hospital had called an on-call physician who refused to come in, one of the things that hospital has to do is tell this other facility the name of that on-call physician who failed to come in, because that on-call physician could then potentially be liable for $107,000 at least, because they violated EMTALA if they failed to respond to their on-call obligations. Okay? As far as transferring the patients through qualified means, can you ever transfer a patient by private car and satisfy EMTALA? Do you ever have patients who want to be transferred by private car? And in that case, we just refuse. We say no. We throw them in the ambulance, strap them down, and make them go, right? No. The patient, of course, always has consent. EMTALA does not trump consent. If the patient has sufficient capacity to make decisions, they can decide what they do. But you, as the transferring hospital, if you're going to let that patient go by private car, you better darn well cover yourself, okay? So my recommendation is, yeah, it may be appropriate for certain circumstances. There's actually a couple of cases around the nation where they did allow the transfer by, the court affirmed the transfer by private car. But there's things that you need to do to protect yourself. Always offer the ambulance. No matter what, I would offer the ambulance. Okay? Explain the risks and benefits and document it. Explain your EMTALA obligations. Make sure that transfer by private car, you do whatever you can in order to minimize your risk. Make sure that somebody's riding with the patient, that they know that they're supposed to go directly to the other facility. You know, don't stop and pick up lunch on the way. You know, make sure that you give them instructions for if anything happens during the transfer, make sure you call and let us know. You know, we're available to assist. Do those kinds of things to document that it was the patient's decision. They made the decision to go by private car, and we offered all of this other stuff. That's the way you protect yourself on those issues. All right. Any questions about the EMTALA process. Yes, ma'am. Okay, so the question is, what do you do if you've got transfers between a VA hospital, okay? So is the question receiving it from the VA or is the question sending it to the VA? Okay, from the receiving, you don't have an option, right? If you're a hospital with specialized capabilities and you participate in Medicare, you can't refuse to accept a patient. Now, you can refuse to accept the patient if the patient is an inpatient at the other facility. So if they've been admitted as an inpatient at the VA facility, then you could say, no, they're an inpatient. They are not. Oddly enough, inpatients are, you're not obligated to accept patients the way it's defined in EMTALA. So in that situation, you could probably decline to accept them under EMTALA. Now, if they send the patient over anyway, once they're there at your facility, they're your patient. Okay? Now, as far as sending them to the VA, well, VA, I don't think probably participates in Medicare. They're VA. They're a VA hospital. I doubt that they participate in Medicare, so they're not going to be covered on EMTALA to require to receive it. Probably so. Question or comment? Okay, I'm going to stop you right there just for a second, just for our folks who are off-site, right? So, patient goes in, the patient does not appear to have an emergency condition. Is that what you're saying? Okay. And so a lot of that happens, okay. So okay. So that, normally in that situation, if they're an ESI 4 or 5, the appropriate response would be to discharge them with appropriate follow-up. Okay, so then the pushback then the pushback from the hospitals is out of an abundance of caution because hospitals are afraid of EMTALA. They'll do like a full-blown workup, charge the patient a whole bunch of money, and then send them out, and the patient gets a big bill for there because they're afraid of EMTALA. Well, it's a risk management issue for the hospital. Under a medical screening exam, the EMTALA regulations are very clear that you only have to do a screening exam that's appropriate for the presenting symptoms. So if the presenting symptoms are limited, then you'd only have to do a limited exam or an exam sufficient to rule out an emergency medical condition. And they give the example of a patient who shows up and complains about some minor thing, and they say if a nurse is a QMT and they can give you a quick set of questions and rule out an emergency medical condition, then you could rule out an emergency medical condition and you could go ahead and discharge them because EMTALA doesn't apply. So the hospital doesn't have to do more than is necessary, but you're right. I mean, any provider wants to make sure that they're protected, and so it's really a policy or a practice for the hospital, what they're going to do, their comfort level from a risk management point of view. Do you want to play it safe? Make sure that you jump through all those hoops because, malpractice lawyers are pretty good at attacking you if you didn't do everything they think that you might. Remember, EMTALA is not malpractice, right? They're two separate standards. You could comply with EMTALA and still commit malpractice. You could violate EMTALA and still do everything right under the standard of care. They're two different standards. All right. Biggest point here through all this process, again, document. I have not yet had an EMTALA case that went anywhere when the people documented appropriately. The fact is they don't document. That's the problem. So you need to train your people to document. Document that you did the appropriate exam by a qualified medical person. Document that there was no emergency medical condition as a result of that. Document that the patient was stabilized. Document that the patient refused care, that they went AMA. Document that the certification of the benefits of the transfer outweigh the risk and that you engage in appropriate transfer if you did. You need to do the documentation. If you do that, chances are you're going to be fine. You can't delay under EMTALA, you can't delay the exam or treatment. It's an anti-discrimination statute. That's really what EMTALA was designed for. They don't want patients showing up and you refuse to treat them because they haven't got money. That was the basis of it. So you cannot, under EMTALA, delay an exam or treatment to inquire about payment. Among other things, you cannot seek pre-authorization from an insurer until after you have conducted an exam and initiated stabilizing treatment. Along with that, the commentary suggests, look, you shouldn't be ushering the patient out the door. You shouldn't be making suggestions like, well, you can really get this service cheaper over at the RHC, or if you come back, make an appointment and come back, then you can get it cheaper. They don't want to see you kind of ushering the people out the door. Can you answer honest questions? Absolutely. You just want to make sure the person's answering the question understands what their obligations are here. Now, so long as it does not delay or discourage the exam or treatment, the hospital may do the following, according to the interpretive guidelines. You could follow reasonable registration processes, including obtaining demographics, obtaining insurance information or card, or identifying emergency contacts. Just make sure that they understand that you're not conditioning treatment on this stuff. But you can go ahead and get that stuff and start the process. And you can contact the primary physician or health plan to obtain their health history, but don't seek pre-authorization. If the patient refuses care, which happens a lot, right? They go AMA, they don't want to stick around, document. And there's certain things that EMTALA requires you to document if the patient goes AMA or refuses care or transport. You've got to document that you offered the exam, treatment, or transport. You're supposed to document what you offered, not only that you offered it, but describe the services that you offered. Document that the risks and benefits were explained to the patient. Document the basis or refusal for the transfer. Take reasonable steps to secure the written informed refusal from the patient to try to get them to sign the document. If they refuse, then document their refusal. Document, document, document. Again, the recipient hospitals, they've got an obligation to, if they're participating in Medicare and they have specialized capabilities, they've got an obligation to receive transfers. Sometimes they'll refuse. They'll say, no, we don't want it. And then you say, okay, let me get the name of the person I'm talking to because we're going to turn you in and you're going to have to pay $106,000 plus any additional damages that we may suffer because you're not accepting the transfer. They do not have to accept the transfer if they don't have specialized capabilities. It may be that they're on diversion for that, or that you can provide the same level of care. If they don't have specialized capabilities and you can provide the same level of care you can, then they're not obligated to accept it. They're not obligated to accept the transfer if the patient has been admitted as an inpatient at your facility until it cuts not only you off, but it cuts off, cuts them off. If you receive an improper transfer, you've got an affirmative obligation to NARC on that other facility. You've got to do that within 72 hours or else you could be liable for an EMTALA violation. Hopefully, though, you've got a good enough relationship, you'll call up and really find the facts to make sure that there truly was an EMTALA violation before you do that report. Just finally, an on-call physician. EMTALA says that in the interpretive guidelines, they don't prescribe what you must do for on-call. But they do say that if you're providing services and advertising services at your facility, you generally ought, not must, ought to have call coverage for those services. So if you're holding yourself out as providing orthopedic services, you should provide some kind of call coverage for those orthopedic services. Okay? You're not absolutely required to, but that's what they expect. You need to make sure that that on-call physician is listed on your on-call list. They need to be able to come in. It's not sufficient to name a group for on-call. You've got to identify specific on-call physicians, and you've got to maintain that on-call list. If the on-call physician fails to respond, then they may be on the hook, and you're going to have to NARC on them. If you then have to send that patient to somebody else, you've got to send their name to somebody else. Again, to summarize everything, when in doubt, simply do what's in the patient's best interest, document what you did, and almost always you're going to be on EMTALA. That is it on EMTALA. I think it's lunchtime, right?
Okay. Hopefully everybody is feeling refreshed after their lunch. So we're going to jump in and start again talking about HIPAA privacy, security, and breach notification rule. Again, just pointing out that there are so many resources, and on this slide, we're just pointing out some resources that you can utilize at a later point in time, so be sure to look at that. So in terms of obviously talking about HIPAA, we've got the privacy rule, security rule, and the breach notification rule. And the High-Tech Act modified HIPAA. We just always want you to think about that HIPAA is going to preempt less restrictive laws. So let's say your state has a law regarding some kind of breach notification. If it is less restrictive, then HIPAA is going to trump that, right? HIPAA is always going to be at the top. In that situation. But if you have a state law and it's more restrictive, then that's going to trump. So whatever is the more restrictive law, HIPAA versus your state law, you have to comply with the more restrictive law. So we're constantly looking at this in different states that we're interacting with, and there's a scenario and trying to figure out, okay, we've got to comply with HIPAA, but then do we have state laws that are more restrictive that require us to put, tweak different things like your notice of patient privacy practices. In Utah, we have a little clause that's got to come into those notices that isn't going to be required in other states. So you kind of constantly be thinking about how HIPAA interacts with your state laws. So HIPAA enforcement. It applies if employees or other individuals obtain or disclose protected health information in the covered entity without authorization. And these are the various penalties that apply. Recently, these were increased for inflation on the civil side, the civil penalties. So if you did not know and you should have known of a violation, you've got the penalty of $114,000 to $57,000 per violation. And we've got a little typo there. Up to, it's supposed to be, over $1 million per type per year. No penalty if correct within 30 days. An OCR may waive or reduce the penalty. So this just goes through these different things and talks about what is in place based upon the type of violation and what you're doing. All the way to the bottom, I would just point out willful neglect, and you do not correct within 30 days. Then you've got the $57,000 per violation. The penalties are mandatory. So you go all the way from, hey, look, you didn't know, you should have known, you correct, to, oh, we willfully neglected, we didn't even try, and we didn't correct. So likely you can avoid HIPAA civil penalties. Well, let me just back up a little bit. When people talk about, like, I have different tech clients that I represent, and sometimes in that space, you'll see some of these tech clients, they've got some kind of PHI, that they're dealing with some kind of products in the medical industry, and we'll be putting on their site like we're HIPAA compliant. I'm like, what does that mean? There's no certification body that says you now are HIPAA compliant. That's not how this works. And I would argue that no one is 100%. And I can say this safely with healthcare laws. No one is ever 100% compliant. That would be impossible. Sadly enough, what we're trying to do is get enough processes and policies in place, make you as compliant as possible, and to get procedures and policies in place so we can catch as many, possible uncompliant, non-compliant things that are going on, so we can self-correct, right? So we just need things that are in place to help you catch when you're coming out of compliance and correct. The same would be true. The same is true when it comes to HIPAA. It's not a matter of whether or not it's not if, but when. There are different breaches that happen with HIPAA, right? There are going to be certain violations of HIPAA within your institution, but it's a matter of having those good practices in place and those policies in place that are your guardrails to make sure you can identify those and then, self-correct. So in terms of, what's going to happen, in terms of avoiding the civil penalties, when there is a problem, more than likely you can avoid those if you have the required policies and safeguards in place. You execute business associate agreements, train personnel and document training, and respond immediately to mitigate and correct any violations. You timely report breaches if required. It's really about showing that you put forth those good faith efforts, right, to try and be compliant and to self-correct. Enforcement. So several years back, the state attorney generals now can go after HIPAA violations and bring lawsuits in relationship to HIPAA violations. I was going to see it. Camera. Do you know of any state attorney generals, though, that have kind of taken this up? Okay. Okay, so here and there. I know I get phone calls all the time, just unsolicited, from people saying, my HIPAA rights have been breached. They just find me on the internet and call me, and I'll have to explain there's no private right of action for HIPAA breach. If you want to call the Office of Civil Rights and report that, they can investigate. You can also call your state attorney general. But I've never heard of the state attorney general, unless it's some massive, breach. I don't think many state attorney generals care when they get that call. I think they actually brush it off most of the time. So, but they can do it. But there's a $25,000 fine per violation plus fees and costs. In the future, individuals may recover a percentage of penalties, but that's not in place right now. You really need to sanction employees who violate HIPAA. You must self-report breaches of unsecured protected health info to those affected as individuals, to HHS, and to media if the breach involves more than 500 persons. So I think you guys know that, right? That according to how many people are affected, that determines what you have to do in response to that. And once you go over 500, you have to report to the media so that they can push that out and notify the public. When we talk about no private cause of action or HIPAA, the one thing that I want to mention, though, is that even though there's no private right of action, that doesn't mean that you can't get sued by patients for negligence. So when I fielded those questions in regard to patients, if there's highly sensitive PHI and somehow that is leaked or breached and that causes damage to the individual, that doesn't mean they can't sue you just under a common law theory. All right, so I just want to make that clear. And there have been courts around the nation that will use HIPAA as kind of the benchmark for whether or not the covered entity was negligent. So entities subject to HIPAA, you guys know, covered entities and the business associates of covered entities. Well, who are the covered entities? Healthcare providers who engage in certain electronic transactions. Health plans, including employee group health plans, if it's 50 or more participants, and administered by a third party, and healthcare clearinghouses. So obviously, you guys are all keenly aware, I think everybody that's here probably is associated with a covered entity, but really anybody that provides healthcare is certainly a covered entity. And then, like I mentioned before, of course, business associates of covered entities. So any entity with whom you share PHI to perform services on your behalf, meaning contracted services, agencies, software providers, anybody that's going to have access to your PHI as a covered entity and helping you perform your business as a covered entity, they're business associates. And you need to have business associate agreements in place with all of those downward stream covered entities. So what is protected health information? It's individually identifiable health information that could be used to identify the individual. Can concern the physical or mental health, healthcare or payment, created or received by the covered entity in its capacity as a healthcare provider, maintained in any form, oral, paper, electronic images, that it really is pretty broad. I mean, there are all these things that we know can be utilized, right, to identify somebody, their social security number, date of birth, but sometimes even a description of a patient, right? So you hear these cases of people, some residents or an intern, and they're on their social media and they kind of describe a patient. With enough description of a patient, that could be utilized to identify who that individual is. So what's not covered by HIPAA? So once a person has been dead for 50 years, info maintained in capacity other than as a provider, for example, as an employer, right? As an employer, there are times where you have obviously information related to somebody's health in a way, right? If they tell you they've got a disability, different things like that. There's information you have about that, but that does not constitute PHI covered by HIPAA in that capacity. De-identified information does not constitute PHI. So obviously PHI can come in, and if it's de-identified, it would no longer constitute protected health information. So names, dates, birth, admission, discharge date, death, telephone, fax, and email, social security, medical record number, account numbers, biometric identifiers, full face photos. Anyway, anything that's a unique, identifier. So you've got to go through and de-identify that. And that would not be considered, that would be considered to be de-identified once you've done that. Prohibited actions, unauthorized disclosure outside of the covered entity, right? So this is, somehow this is released outside of your organization, right? So obviously you don't get to do that outside of certain exceptions, but unauthorized use within a covered entity. Many of you may remember several years back, I think that one of the funner examples of a HIPAA breach was a hospital in LA where a lot of celebrities would go, and there were employees that were logging in right to the computers because they were nosy and like, oh my gosh, I'm not saying it was Brad Pitt, but for example, if Brad Pitt was there, what's he in for? These things like, and they were able to identify that the hospital, didn't have good policies and didn't have a way to secure and track who was accessing information. And people within your organization who only need to have access to that information should be allowed to access that information, and there should be tracking, right, of who's logging in to the systems and looking at data. You want to protect it within the organization as well and make sure that there's no unauthorized use within the organization. And unauthorized access from within or outside the covered entity. So use and disclosures. Basically, kind of the 3 rules of thumb. Don't access if you don't need to know. Don't disclose unless an exception specifically applies or you've got authorization from the patient. Implement reasonable safeguards. So one of the most common exceptions, right, that you can disclose patient information without the patient's authorization is for treatment, payment, or healthcare operations purposes. And so we often refer to that as the TPO exception. So in that case, you can disclose to another covered entity for the other entity's treatment, payment, or certain healthcare operations if both of you have a relationship with the patient. You have to go through and meet the criteria. In the government, these laws specifically outline, what do these things mean? And they flesh this out a little bit better. There are exceptions to that, like, for example, psychotherapy notes. That requires specific authorization for use by or disclosures to others, right? It has to be separate from the main disclosure, right? So you guys normally have your, consent for the release of protected health information. You can't just have in there, psychotherapy notes. There has to be separate written authorization for that. Those have got to be even more protected than the other data. So if you agree with the patient to limit the use or disclosure for treatment, payment, or healthcare operations, you must abide by that agreement except in an emergency. So what we're getting at with this is you want to be really careful about if you're going to really inform patients, let's say that you're not going to, whatever you tell the patients you're going to do, whatever you put in writing, you need to make sure that you're doing it. And the problem here is that if you are saying that you are going to, if you ask them, for example, if you put things in writing about agreeing to limit the disclosures for treatment, payment, or operations, sometimes you're creating these inferences when you put these things in writing, that there won't be any other reason that you would do this. And there might be certain reasons that are allowed under the law that you can disclose. And you just want to make sure that how you're putting this in your disclosures isn't creating unintended consequences, if that makes sense. So persons involved in the care. So obviously you can use or disclose PHI to family or others involved in the patient's care or payment for care. If the patient is present, you may disclose if the patient agrees to disclose or has a chance to object and does not object to it, or it's reasonable to infer agreement from the circumstances. If the patient is unable to agree, you may disclose if the patient has not objected and you determine it is in the best interest of the patient. But you should limit the disclosure to the scope of the person's involvement. And this applies to disclosures after the patient is deceased as well, unless that person, you know, is the personal representative for that estate. So obviously there are nuances to this, and you guys have to deal with this all the time. But if there's a family member, obviously, that's accompanying the patient, right, to, whether it's to the hospital or to their appointments, you know, there's really that inferred understanding, right, that they're there, they're accompanying them. Clearly, they don't seem to have an issue with this. But you need to kind of follow these guidelines for determining whether or not there really is this implied or inferred consent for you to be discussing that patient's PHI in front of those other people. So what about like the facility directory at the hospital? You may disclose limited PHI for the facility directory if gave patient notice and patient does not object, and the requester asks for the person by name. If patient is unable to agree or object, you may use or disclose limited PHI for directory if it's consistent with the person's prior decisions, if you know those, and determine that is in the patient's best interest. But again, the disclosure should be limited to the name, location and facility, general condition, and religion if disclosure to minister. So when you're thinking about all those things, just think about limiting it to what's necessary. So exceptions for public health or government functions. So there obviously are state laws that require certain disclosures, right? Those can, under HIPAA, there are certain disclosures that are allowed or permitted. And under state law, there are certain disclosures that are permitted and sometimes that are required, right? So you have to keep in mind, you know, what can we disclose in these situations? So aside from, again, looking at those, let's say a state law that says you've got to disclose, like for example, obviously mandatory reporting of suspected or confirmed child abuse, right? Those are situations, you know, normally under every state law, you've got to report. Elder abuse, you know, in certain cases. So you've got to know that your state law is mandatory reporting, and you've got to know when you're supposed to step up and report those. But disclosures should prevent serious and imminent harm for certain public health activities, right? Certain diseases, right, that are being spread, you guys have to report those. Health oversight activities, judicial or administrative proceedings, court orders or warrants, subpoenas, law enforcement, workers' compensation. Two things, just overall rubric to keep in mind. Keep in mind, and I get these calls from my hospital all the time, that under HIPAA, there are certain scenarios where you may disclose, but you're not required to. And sometimes in their mind, they kind of get that confused, right? So there's certain scenarios where, let's say somebody is, you know, a fugitive from police, and maybe on the local police side it says that, you know, they're wanted, right? They're a fugitive, they're wanted. That's a scenario where you may disclose, but HIPAA doesn't say you have to. And so sometimes you have to just use, you know, common sense and determine, okay, you always have to make sure that there is a permissive exclusion that you can disclose, but that doesn't mean that you have to. It means that you may. And sometimes I think there's some really good public policy reasons to decide whether or not, should we disclose it? Should we not? And I have sometimes some very overly aggressive, in my opinion, let's say security guards or people involved in security that moonlight as security at the hospital, but they also act in some law enforcement capacity outside of acting as security. And sometimes I think that they don't have a good understanding, and the hospital needs to be better about explaining, when you're here as security, you are not here as law enforcement. And these two things are very different. And sometimes I feel like, somebody comes in and let's say, they have a drug overdose and they're found with, some kind of drugs on them. And it's like, sometimes these people are like, we're going to bust them. And it's like, no, this is not the same thing. And HIPAA, for example, allows for an exception if there's an active crime on the premises, right, of the hospital, right, then you can report to law enforcement. But as a matter of public policy, if people end up having, let's say, some kind of contraband or illegal substance on them, and you're going to all of a sudden call the authorities and tell them, is that an active crime? And are we going to, as a matter of public policy, discourage people that need medical help from coming to the hospital? And sometimes, just having those discussions, you can kind of ferret that out and make sure that these policies you have in place of when you may disclose to law enforcement, that you're not encouraging or doing things that are going to keep people from seeking help that really need your help. That's my little one. Uh-huh. Oh, sure. Yeah, and so we have some great resources on our website where it goes through in terms of, we have one that's specifically for responding to law enforcement, and what you should be saying in those regards, but it actually is a little bit nuanced. But I would say in regards to subpoenas and warrants, I get this call at least 2 or 3 times a month from one of my major hospitals. Like, some cop shows up and he's like, I've got a warrant. I'm going to go upstairs. You got to do this. And I'm like, whoa. And they'll call me and I'll say, I want to see the warrant. What does it say? I got one last week, and the hospital called and they said they're saying that they get the warrant. They've got to go and interview this patient in the psych ward, and they're going to get a blood sample. Blah blah blah. And I said, send me the warrant. But the warrant had nothing to do with an investigation and talking to the patient. It allowed them to get a swab from the patient. And I'm like, you give them exactly what that says and no more and no less. So sometimes cops will come in and overstep their bounds a little bit, and you have to kind of push back and say, let's work through this. But go to, on the blog, Kim put out something that's specifically in regard to responding to law enforcement, and it has some really good things on there. Yes. So written disclosures from patients. So you must provide PHI in a designated record set to a third party if it's requested by the patient. And again, that's got to be done in a proper authorization, right, that meets the requirements under HIPAA. It's got to clearly identify the designated recipient and where to send the PHI, and it's got to be signed by the patient. Additionally, part of the individual's right of access, you've got to respond within 30 days, and you can only charge a reasonable cost-based fee. The authorization must obtain a valid written authorization to use or disclose protected PHI for psychotherapy notes, if you're going to utilize that data for marketing, if you're going to sell the PHI, if it's for research, and for all other uses or disclosures, unless a regulatory exception applies. So if you've got under HIPAA an exception and a reason that you're allowed to disclose, great. If you're not, including these things that are listed here, you have to have a separate authorization that says, yes, I'm going to allow my PHI to be utilized in this manner. And for these purposes, the authorization cannot be combined with any other authorization. So it can't be kind of, the whole purpose is they don't want to like snuck in part of something else. In terms of employment physicals, drug tests, HIPAA generally applies to employment physicals, drug tests, schools or physicals, independent medical exams. And this just goes through and kind of talks about what's required in that scenario in these little nuanced situations. You have to definitely, if I hope this isn't coming up too much for you guys, so I'm not going to go over a great deal, but again, when there's an employer, and let's say there's some kind of an employer health plan, and you've got information, right, as the employer, but also there's an employee health plan, those things get a little bit tricky, and there kind of has to be some clear delineation. Those things can't be utilized, kind of cross-used without violating HIPAA. Marketing generally need authorization if communication is about a product or service that encourages the recipient to purchase or use product or service, except to describe a product or service provided by the covered entity for treatment of the patient or for case management, care coordination, direct or recommend alternative treatment therapies, providers, or settings. Except that you can't do that if the covered entity is receiving financial remuneration from the third party for making the communication. So you can, do it for marketing in a very, very limited exception. I'll give you an example. I had a client that for their certain, I can't remember what type of patient, let's just say it was for diabetic patients, and there was kind of a new treatment that this physician felt would really help these patients and reduce their chances of having some kind of certain complication. He sent out a letter, saying, hello, patient X, you're a diagnosed diabetic, and I've really found that this new treatment can be very, very helpful. I encourage you to, do X, Y, and Z. But he wasn't receiving any remuneration for this. He really thought it was in the best interest of the patient. He's talking about the care, right? So in a way, it's marketing. It's not about their existing care, but it's like, hey, want to let you know about this. Sell a PHI, can't sell PHI unless obtain patient's written authorization. The authorization discloses whether covered entity will receive remuneration in exchange for PHI. To sell a PHI, what does that mean? That means the disclosure of PHI by covered entity or business associate if they receive directly or indirectly any remuneration, financial or otherwise, from or on behalf of the recipient of the PHI in exchange for the PHI. That may apply actually to charging excessive fees to copy or produce records. So just be careful that what you're charging people for that is actually like the reasonable cost of what it costs you. So yes, there are very specific rules around this, and there are a few different ways that this can be accomplished. Well, I was going to say, Kim can chime in here too, but actually when you're selling a practice, you don't get to just carte blanche. You're not selling these patients and the records. So there are a couple different ways that can be effectuated. But in the interim time, let's say before the patients decide whether or not they want to be a patient of the new practitioner or the new practitioners, as part of that sell, you can do something where the new practice is going to be the custodian of the records, but they don't own the PHI, and they have to protect the PHI as a business associate of the selling practitioner. Does that make sense? So they have to enter into a business associate agreement. They're the custodian of that PHI, those records, and they agree that they're going to abide by HIPAA and not disclose those and very carefully retain them. And then patients do have to, let's say if you're selling that practice and there's a new provider, and it depends on, there are different facts that could affect this, but I'm just giving you an example of how you could handle that. But then each patient would need to sign an authorization for disclosure of PHI saying, please, yes, my full medical records can now be transferred to the new practitioner. So that's one example of how that can be handled, but you have to actually handle the transfer of those records very carefully. You don't just get to say, I've sold my practice, so all this PHI, all these patient records get to go with it. Let's see. So parents and personal representatives. I get so many calls from my hospitals and practitioners, and there's some really fun case scenarios on this one. But under HIPAA, you treat the personal representative as if they were the patient. The personal representative may exercise the patient rights under HIPAA. So who is a personal representative? That is the person with the authority under state law to make healthcare decisions for the patient or make decisions for the deceased patient's estate. So I put this little asterisk down here because this is a question that I think you guys probably get most. Divorced parents, the non-custodial parent, is asking about information of the child. So some people get confused about this. Normally, when you get divorced, there's legal custody and there's physical custody. So let's say if I'm divorced, I may not have physical custody of my child, but as long as I still have legal custody, technically I'm still normally considered the personal representative and I should still be given access to the PHI, of my minor child. However, there are exceptions to that. One, keep in mind that if a court has terminated parental rights, you're no longer the personal guardian, right? You no longer have legal custody over your child. But there are always reasons, and under HIPAA, if you feel like, if a provider reasonably feels like disclosing that PHI to that personal representative would not be in the best interest, you don't have to do it. And I've gotten calls from hospitals saying, hey, I think it's the case, right? Like the non-custodial parent, as long as they're still, have legal custody, that they're entitled to access to records, right? I'm like, yeah, that's true. And then sometimes I'll get these via email, it's like a little snippet, and I'll say, but tell me more. And so much of the time, it's the determining factor is all on the details. And I can tell you one time I got an email back and said, oh, well, the father is in prison. He's been convicted of like sexually abusing this minor child. And for purposes of his defense, that trying to appeal, he wants the medical records of this minor child he's been convicted of abusing. And I'm like, no, no, this is one of those situations where, we can reasonably say this is not in the best interest of the minor. So there are always caveats and exceptions. Does anyone have any questions about that in general? Okay. Not required to treat personal representation. You don't have to disclose PHI to them. Minor has authority to consent to care. Under state law, there's certain reasons why a minor has the ability to consent for themselves. I don't know specifically about Wyoming law, I'm broad to stuff that out, but in Utah, there are very specific, you have to have statutory exceptions for when the minor can act and consent to care. Like there are certain immunizations and certain circumstances. If they're pregnant, getting care for, prenatal care for the baby, they have authorization to obviously authorize that care. And then obviously the PHI should be disclosed in that situation. So you've got to look to your state laws for reasons when a minor can access care on their own and consent to care. And then in that same situation, if a minor can consent to medical care, then also technically that PHI shouldn't be disclosed. If a parent agrees that the provider may have a confidential relationship, often that happens in a therapy setting where the child's getting mental health treatment. And oftentimes the counselor or the parent will say, I want my child to I want them to feel free to communicate whatever they need to communicate to you without fear that you're going to tell me. And so I'm consenting, for you having a confidential relationship. In that situation, again, that PHI, technically they don't have to disclose it to the parent. So any questions about that? Because I get questions about this all the time too. Okay, moving on. So again, we're going to point out to you resources. The government has lots of great resources. This is one of them to understanding how you can communicate with the patient's family, friends, etc., who are involved in the patient's care. I would utilize that as a first-line resource. Business associates. So you may disclose PHI to business associates if they have a valid business associate agreement in place. You've got to have written BAAs in place with your business associates. Failure to execute a business associate agreement is a HIPAA violation, and it may subject you to HIPAA fines. This is a recent settlement from a couple of years ago. It gave records to a storage company without a BAA, and it was a $31,000 penalty. Right? So if you've got a storage facility and they're storing records, but there was no BAA, not okay. So anybody that's a downward vendor that has access to your PHI, you've got to make sure you've got a BAA in place. Based on recent settlements, may expose you to liability for business associates misconduct. So a couple of examples: turned over X-rays to vendor, no BAA, $750,000. Theft of business associate's laptop, no BAA, over $1 million. And these are the acts of the business associate, not yours. So I'm saying if you're a covered entity, you can be liable for the bad acts of your business associates. So you need to make sure that not only are you executing these BAAs with your downward stream vendors, but as a matter of best practices, there should be, some vetting and due diligence to make those downward stream vendors assure you that they actually are taking the substantive steps to comply with that BAA. And I can tell you that oftentimes in the world that I'm in, I deal with a lot of business associates, companies that are business associates, and they want the business, right? They want to get the business of these covered entities, and they're signing these BAAs, all the time. And I'm like, guys, are you doing? Do you see what it says you have to do in here? Are you doing it? And so much of the time, I'm the one pushing, saying, have you done a HIPAA audit? Do you have these security measures in place? Do you have these processes in place? And a lot of times, they simply don't. So you guys need to kind of be aware of that and realize that if your BAAs are not substantively complying, regardless of what it says in the agreement, that you could be held liable. So business associates, again, we kind of talked about what they are, but even it keeps going downward, right? So I have business associates, let's say these tech companies that are in the healthcare world. Everybody that's downward from them is a BAA, right? That's holding on to that or transmitting that PHI for them. So this really goes down, far, and everybody needs to understand that. Business associate agreements, generally cannot be combined with other documents. They must contain required terms and statements. The government has a nice, they have a version that can be utilized. So if nothing else, again, go to the government and use their resources. If there were ever an issue, and you're able to say, I used your template. It's a pretty good defense there. So they've got a nice, at least, template that you can utilize. But also, I know that on our site, I think that we've got a few different versions of BAA templates that are more, let's say, BAA friendly, business associate friendly, and one that's more covered entity friendly. So utilize those resources as initial templates. So this just kind of goes back to what we were talking about, but again, that there can be liability if you know that a business associate or subcontractor is violating HIPAA and you fail to take action to end the violation or terminate the BAA. So that can really expose you to significant liability. So just make sure that you are, again, doing your kind of due diligence with these subcontractors. So talking about disclosing PHI. Before disclosing PHI, verify the identity and the authority of the person requesting the info if you don't know who they are. How can you do that? Maybe ask for social security number, birth date of patient, badge, credentials. Obtain documents, representation, statements required to make disclosure. You've got to get kind of written satisfactory assurances. This is talking about subpoena or representations from police that they need info for immediate identification purposes and only release what's required. So that's just kind of a little statement going on about like a subpoena or when the cop shows up and says, I need this. You can step back. It's not like there's going to be, the world's not going to burn down in those 5 minutes when you tell them to just hold on. Can you show me the written documentation if you have it? Can you tell me what you need this for? Going and talking to your risk manager, if they need to, they can quickly call legal counsel. We can usually figure it out in like 5 minutes or less. But there's no reason to not take some time and figure that out. But in terms of obtaining documentation, representation, I have had this situation too before, again, where maybe there's some kind of really nasty custody dispute or some weird things going on, and somebody's showing up wanting the records. And oftentimes, people just aren't asking, I think, in these offices, the right questions of saying, tell me who you are again, what's your relationship with the patient, are you and your spouse married? Asking those questions to get a feel for whether or not there is something you should be concerned about before you disclose. And if there is a question about their authority, to receive that, and I always, if push comes to shove and there's a concern, one, you can always ask for a copy of the divorce decree, right, that shows who has legal custody. But still then, don't forget there's that carve out that if your provider feels like in their discretion it's not in the child's best interest of a minor patient, they don't have to disclose, right? So there's always that backstop. So minimum necessary standard, but when you're disclosing information, unless you've got, let's say like this full authorization, unless you know that it's a personal representative, they get to have everything, or you've got an authorization for disclosure of PHI and it says this is what you can disclose, keep in mind that you should always try to disclose only what the minimally necessary PHI, right? So there's no reason to disclose more than is needed. But that standard doesn't apply, obviously, to the patient themselves. The provider, for treatment purposes, for the individual's authorization as required by law. You can rely on the judgment of another covered entity, professional within the covered entity, business associate for professional services, public official for permitted disclosure. So that's just kind of to give you guys again some kind of guardrails to think about. Minimum necessary standard. So outside of what we've talked about, where these minimum standards does not apply, you really need to be thinking about in terms of, because otherwise it does apply. You should only be disclosing the minimum standards, the minimal necessary PHI, unless one of those previous exceptions that I talked about apply. So in that case, you need to look at this and figure out how do we make sure that we're only allowing the disclosures as minimally necessary. So look at internally your uses of PHI in your organization. Identify the persons who need access. Draft policies to limit access accordingly. In terms of external disclosures of PHI, routine disclosure, establish policies. So you guys should have a policy, everybody should, in regard to when we get a request for the release of records or PHI, even if it's verbal, what's our policy? How do we handle this? And when you have those in place, it's so much easier, right? Because your employees can just pull out that policy and kind of go down it like a checklist. And then you're not constantly fielding those questions. So you should have a policy in place, and that's really required under HIPAA. And then non-routine disclosures, really it's like a case-by-case review. So what I was telling you, there are certain situations where there's kind of a bizarre situation, right? Or there's some kind of high conflict and people's fillers kind of go up instinctually, something doesn't seem right here. What do we do? Or let's say, a very emboldened cop shows up and seems to be overstepping their authority. Those are situations where you need to make sure that as part of your policies, you tell people that they need to get other people involved in assessing that before they disclose. So going into the security rule, this slide is a little bit old in terms of going back to 2017. It's not dealing with 2018 and 2019, but these are different OCR settlements in regard to various failures under HIPAA. So you guys can see that the highest one in 2017 was over $2 million, and that was for failing to implement safeguards to protect electronic protected health information, despite prior warnings that this information had been hacked. So the government obviously really doesn't like it when there's just this blatant, willful neglect. And when somebody new had warnings, we're told, and they just simply, no big deal. Things are going to get ugly, obviously. So going down to, the bottom, failure to timely report a breach. So If it's 6 months after the breach occurred and you finally get around to reporting, obviously that's not going to be acceptable to government. But there was, we just put out, I know that Kim just put out a client alert, I think yesterday. I don't know if most of you in this room may have gotten it if you're on our alert list, but where there was a big penalty for a group because they weren't encrypting their PHI, and that included, I think, their thumb drives. So there were some drives that weren't encrypted, and they got a nice big fine. So you've got to remember to encrypt, all your devices and data. So just going over, obviously, more of the things scare all of us, right? Those different fines and actions that have been taken. So on the HIPAA security rule, everyone that's a covered entity and business associates, you're required to do a risk assessment under the security rule. Following doing that risk assessment, you're required to implement safeguards, administrative, technical, including encryption, and physical safeguards. You're required to execute business associate agreements. The government has good resources to help you through those risk assessments and then figuring out how to implement some of those safeguards. I think it can be really overwhelming for smaller groups to decide how to go about doing this, but at least start, with the government's security risk assessment tool. If you are a group or a facility that doesn't have the means to, let's say, hire an outside, consultant to do that risk assessment for you. And then based upon that risk assessment, you're really, like I said at the beginning, you're not expected to be perfect because nobody in the healthcare space can be perfect. No one will ever be 100%, HIPAA compliant. But you are expected to go through that process, again, and put those guardrails in and implement the various policies. But after you do the security risk assessment, really, as you go through that risk assessment, you're looking at what are the highest areas of risk. So what, after I've done this risk assessment, what are the different areas that we showed up as a very high risk, for a breach? And what are the costs associated with going through this list with kind of these higher, areas? And according to your group's ability to start tackling those, you need to start with those high risks with the means that you have as an organization and start doing, your very best to implement procedures to secure that. The government doesn't expect that all of a sudden the next week, if you're a small organization, that you spent $100,000 and addressed everything, right, that showed up as a risk on that risk assessment, because these are very expensive assessments. But they do expect that you start immediately taking action according to the highest risk and according to the means that you have, and then keep working through the list. So just, giving you, again, a nice overview: administrative safeguards, physical safeguards, technical safeguards. You just got to go through those three things and really think about, how to implement it on each of those things. Pointing you again to some good resources on HHS's website. So again, go there. Encryption, that isn't a standard under HIPAA. Standard transmission security. Implement technical security measures to guard against unauthorized access to each ePHI that is being transmitted over electronic communications network. With the encryption, implement a mechanism to encrypt electronic protected health information whenever deemed appropriate. Right. So again, that's not kind of like this blanket that everything has to be encrypted, but you need to look at where would this be appropriate and where do we need to be using encryption to protect ePHI. Any PHI that is properly encrypted is considered to be secure PHI, and it's not subject to breach reporting. So if there's some kind of inadvertent communication that's sent to somebody that it shouldn't have been sent, but it was encrypted, that's not considered a breach because it was encrypted. Does that make sense? OCR does presume that the loss of an unencrypted laptop, USB, mobile device, that is a breach. But if those things were encrypted, it's not going to be considered a breach. So obviously, very helpful to encrypt as much as you can. In terms of mobile devices, just discussing, obviously everybody has a mobile phone at this point in time. That gets really tough. Things get stolen, so especially I'm assuming that most of our hospital systems have policies in place for any employees that have a mobile device in terms of encryption and how they can utilize that device. But you need to make sure that you have really good policies in place regarding that to try and ensure that if those mobile devices get stolen or lost, that will not be considered a breach. So this is interesting. So in the modern world, right, communicating via email or text. First of all, the general rule is must be secure, meaning encrypted. But the government has said, let's go to email, that you may communicate via unsecure email if you've warned the patient and they choose to receive that communication, even if it is unsecure. I don't think it's ideal. I would not recommend it as a matter of practice, but if you're at least, the patient said, yes, that's fine. Texting, there's kind of a lot of different things happening in this space right now, but between the provider and patient, if you warn the patient and they choose to receive, I know that Kim feels comfortable that, under HIPAA that would be okay. The reason that I hesitate a little bit is because in 2017, a couple of CMS surveyors in email communication with hospitals said that text communication, even if it's secure text, so you have kind of these applications where it's secure, it could not be utilized whatsoever. There's been all this pushback. Those were just surveyors. That wasn't official guidance. So there seems to be, some discomfort there, and I think we'll see over the next couple of years, at least, some more formal communication from the government about what that looks like. But with my providers, when we're talking about texting, I'm really not comfortable with that. If there's a secure application, if that makes sense, that they can utilize, like for example, with my insurance coverage, and I'm sure that a lot of you have a portal right on your phone where you download an app. I may get a text message that says you have new communication, in your health applications. There's no PHI there. I have to go into that app. I do like a two-factor authentication. And once I'm in that app, right, then I can see some communication from my doctor, some new lab report. But it's not coming directly via SMS texting. So the guidance that I generally give about with my physician clients who are asking about this is that if it's about like an appointment reminder where they're using some service, right, where it's reminding them about an appointment and confirming appointments, really about the operations, I'm comfortable with that. But when they start texting back and forth in terms of, sensitive PHI, hey, your lab results came back, just wanted to let you know that I'm being kind of facetious, but, your chlamydia is positive. I just think, we're running the serious risk of having some serious problems. So that's where I land on that. I'm really not a fan of that. But between healthcare team members, this is, you can text, this is where we're kind of coming out on this, if it's a secure platform. The SMS texting directly between phones, just SMS texting, that is not a secure platform. Having those applications I was talking about that allow within your organization, you guys to send emails, or text messages, but it's being saved in a secure platform, and there's two-factor authentication, that's what I'm talking about there. And part of the issue with that is your designated health record, your designated record set, right? That becomes part of a patient's health record. You're required to maintain that. If somebody's SMS texting back and forth about somebody's health, how does that get maintained into the health record? But those platforms that, the different tech companies have created, that is being saved, as part of that designated record set. Oh, I have 5 minutes. I'm going to hustle. Anyway, so interesting. But the one thing to mention is the government says that even like the secure texting platforms, you cannot use that for orders. So that's out. Can't do orders. Are there any questions about that? Mm-hmm. Okay, so first of all, as a billing company, you are a business associate, so you have to have a business associate agreement in place. If, let's say you're talking about paper records, or have a box, or you're saying like the accident, it goes strewn all over the place and is lost. Yeah, but it is, it's a breach, right? It's not an intended breach, no one intended that, but you still have to go through those procedures in terms of if this paper is strewn and there's no way to recover this, then it is a breach and you'd have to go through the process of deciding how that needs to be reported in terms of how many patients and following the guidelines for what has to happen according to how many patient records. And it's unencrypted. So it's what we talked about going back a few slides. So you can use unencrypted email if you've given notice. Oh, but they're both involved in the treatment. Yeah. Yes. Yeah, see, you can use unencrypted email. Between providers, it's not great, but if both of these people are involved in the care of the patient, then that falls under that treatment exception. No, no. Being unencrypted itself is not a violation of HIPAA. Okay, so just making sure, I think you guys are all keenly aware, patients' rights, notice of privacy practices. Every patient needs to get that, say that they've received a copy of it. They can request restrictions on use or disclosure of their PHI, receive communication by alternative means, access to their information, and the right to amend their information. Again, another guide to help you guys understand patients' rights in regard to their own information. So in terms of within your organization, you've got to make sure that you designate a HIPAA privacy and security officer within your organization. That has to happen under HIPAA. Implement policies and safeguards, train your workforce, respond to complaints, mitigate violations, and you've got to maintain your documents for 6 years. Breach notification. If there's a breach and there's an analysis for whether or not there's been a breach. So if you don't know, that's when attorneys like me, we get involved to determine if it qualifies as a breach under HIPAA. But if there is a breach of unsecured PHI, covered entity must notify each individual whose unsecured PHI has been or reasonably believed to have been accessed, acquired, used, or disclosed. You've got to report to HHS via their website, and local media if there's more than 500. And the business associate, if there's been a breach, they must notify the covered entity. So you're asking kind of about, what is a breach? A breach is the acquisition, access, use, or disclosure of PHI in violation of privacy rules is presumed to be a breach unless the covered entity or business associate demonstrates that there is a low probability that the info has been compromised based on a risk assessment of the following factors: nature and extent of PHI involved, unauthorized persons who used or received the PHI, whether PHI was actually acquired or viewed, and extent to which the risk to the PHI has been mitigated. So I'm almost out of time, but to illustrate your point, I was involved in a situation with one of my clients where they did send accidentally, how your email will autofill, maybe you've got 10 mics, and they thought that they were sending an email that included like some patient records to the right mic internally, ended up going outside, quickly contacted outside mic and said, Mike, you received an email. That was an accident that contains, protected health information. Can we get on the phone with you and make sure that this has been properly, did you view it? No, I didn't view it. Can you please delete that? Can you now, with our IT person going through, can we verify that that was deleted out of your deleted file, that it's gone? You can go through, there are different situations where initially there's a mistake that's made. That doesn't mean a mistake is always a breach. You can go through, and if you do this analysis, but you've got to do the analysis and document that you did the analysis and that there was this low risk, right? This shows an incredibly low risk, and in that situation, you know, you can show that it's not a breach, but you have to do the analysis and you have to document the analysis. So here are some of these exclusions to breach. So look those over because I want to make sure that you understand, again, that there are these exclusions to a breach. So just kind of get in your mind, a mistake of sharing a mistake doesn't automatically mean that there's been a breach. And you got to go through the analysis to see if a breach has actually happened. But if there is a breach, there's certain things that have to be done and certain elements. You've got to make sure that you follow those when a breach has occurred. And that's got to happen no more than 60 days of when you discovered this. You've got to notify HHS, and they have a website that you go in and you can do the report right on online. And again, 500 is more than, sorry, you've got to notify the media if it's more than 500. So here's, again, we're pointing you to the site to go ahead and do a breach notification. And this is what has to happen with the media. And then the notice by the business associate, when there's been a breach by a business associate, what do they have to do? This is outlining what that process looks like. And then just be aware that you have a separate Wyoming breach reporting statute that is applicable. But I think, Rich, you said that you look at this, and if you're meeting the requirements of HIPAA, that this automatically is met. Yeah, so as long as you're meeting the HIPAA requirements, those are more restrictive than the Wyoming statute. So if you follow HIPAA, you're going to be fine. But we have gone ahead and specifically kind of talked to you about what that looks like, because it's more than just PHI, right? It includes things like, you know, credit card information and different things. So just be aware of that. And then we just listed out for you some of these resources. And again, Kim Singer has so many resources out there for you. Use that as a first line. Utilize HHS's website where we pointed you to, and you should have just a really, really good foundation for most of these things. Thank you for your time.
All right. I've got one. There we go. We're going to pick up with a subtopic of what Christy just talked about, and talk about responding to law enforcement. This is an area where I think all of us get calls on a frequent basis from our hospital clients about what to do when the cops show up and start demanding stuff, or even just are asking for stuff in a very reasonable way. We're going to spend some time talking about authorizations, some mandatory disclosures. I'm not going to spend much time on court orders, warrants, and subpoenas. If you see a judge's signature on a document, and then that judge has jurisdiction over your facility, I mean, or they're in the state where your facility is, you probably ought to pay really close attention to that document, and there's probably a high probability you have a compliance obligation. Yes. That would be a civil subpoena, and that is not subject to the same rules. There's a process and stuff that has to be in that subpoena, in that discovery request under HIPAA in a civil case. So in a criminal case, you know, you get a document signed by a judge or an administrative hearing officer. Those are things that you can analyze, but probably have a good probability of being enforceable. You should analyze as well. We're not going to spend a lot of time on those. I'm going to focus mostly on disclosing PHI to law enforcement officers, both in the form of, in particular circumstances, but also as they request it and as they request access to your patients. Basic HIPAA, you all know, I mean, covered entity may not use or disclose PHI unless written authorization from the patient or personal representative, use or disclosure for treatment, payment, or healthcare operations, or another HIPAA exception applies. So those three basic categories of when you can use PHI are the guideposts, if you will, for this topic as well. The problem we have is that the person in your situation, when it's law enforcement, may not understand or care about HIPAA, right? They know their job is to get the bad guys and put them in jail. And your job is to take care of HIPAA, and they may not understand those restrictions and may not really care, and they may tell you things that aren't always accurate. you're still subject to HIPAA. There is no sort of broad, I did what the law enforcement officer told me to do, exception to HIPAA. That's not one of the exceptions, except in pretty limited cases. As a practical matter, patient consent always gets you the right to disclose PHI. So in every one of these circumstances that we're going to talk about in more detail, you can short circuit, if you will, the legal analysis, the HIPAA legal analysis, if you ask the patient, can I turn this over to law enforcement, and the patient agrees. That's sort of the patient has the right to make that decision. As long as you tell them fully what's being asked for, that'll work for you. Now, there may be times when the police come to you and say, we want this information, but we do not want you to tell the patient, right? Then patient authorization is off of the table, and you have to fit within one of the other exceptions that allow you to disclose without patient authorization. This is kind of a list of potentially relevant HIPAA exceptions. We're going to talk about each of these in more detail as we go along, but HIPAA has several pages of regulations that cover these. So the first one, and one that might come into play frequently for you, is disclosures to avert serious harm. If the provider believes in good faith that disclosure is necessary to prevent or lessen serious and imminent harm to the health and safety of a person or the public, you can make a disclosure to a person reasonably able to prevent or lessen the threat, not the treat, but the threat. Got a spelling error there. Reasonably able to prevent or lessen the treat. Anyway, Halloween's passed. The threat, including the target of the threat, and consistent with applicable law and ethical conduct. So, key parts here. I mean, you have to have a reasonable good faith belief that there is a serious and imminent threat that you can address by releasing PHI to the law enforcement officer who can do something about the threat, right? So it can't be just any law enforcement, and it can't be just any potential threat. You have to have it has to be serious and imminent, which are not well-defined terms, and you have to find the right law enforcement officer who can do something about it. When you exercise this exception, you presume to have acted in good faith. If it's based on something the provider has actual knowledge of, or credible representation by someone with apparent knowledge. So if you have a victim in your ER, and the victim says, well, I'm trying to think of a good example that actually involves PHI. The victim says, I've been exposed to this toxic substance that my boyfriend was using to cook meth or something. That's why I'm here. I'm sick. You may treat that as a serious and imminent threat. The boyfriend's cooking meth. The toxic substance, you can tell the PHI to the police officer that this was a toxic substance and had been exposed. That's evidence that the boyfriend was cooking meth in the garage, and so that may be an example of when you can use this example or this exception. Obviously, documentation is going to be critical here. You're going to want to make sure your chart includes all of the factors that go into the serious and imminent harm, as well as who you reported to, et cetera. Yes. Yep. Yeah, I've had clients ask that question. If they're intoxicated and they're leaving and they're yes, I think you can report. Some of this, there's a real practical balance here too, that I think all of you deal with every day. So for me to say there's a practical balance here is I don't have nearly the experience of making these decisions on the fly as you all do. But if a drunk person is coming out of their vehicle or going to get in their vehicle, that's a serious and imminent harm.
Say, you're welcome to leave AMA, but unless you have someone to drive you, we're calling the police and telling them that you're intoxicated because you could put yourself at harm. And I was going to say another weird example I have of this, Brad, is a patient was in the psych unit, and he told the physician how he had been driving his girlfriend out to the salt flats where he was going to murder her, and then they got a flat tire, and so it kind of thwarted his plan. And then something happened. He ended up in the psych unit, and they were like, we don't know. Is this girl, does this constitute imminent harm? All these different things, and kind of going through this analysis. It was like, well, I think it's, he said he just, yesterday was going to kill his girlfriend. That probably, this exception applies. And then we had to figure out who are the appropriate people to tell this to. How do we go about doing this? So there are all sorts of weird situations that come up. You have to decide if you're going to. Oh.
Yeah. Just keep the mic, Christy. Keep the mic. We got two. All right. Disclosures required by law. This is sort of a blanket HIPAA exception, and HIPAA goes into a few more of these areas that are covered by law in more detail, and we'll touch on those. But just think about the disclosures required by law exception as sort of a vehicle that you use when coupled with another legal requirement to authorize disclosure. Again, Christy mentioned this. This does not apply if the other law simply permits disclosure. It only applies. This exception only applies if the other law requires disclosure. So we've got some state laws that require PHI disclosure under certain circumstances: child abuse, adult abuse, suspicious deaths, and DUI, and add Title 25 to some extent here. But when we look at adult abuse, HIPAA has a implementing regulation for adult abuse statutes, and it's kind of an interesting one because it specifies the three sub-exceptions, if you will. If the patient agrees to disclosure, to the extent disclosure is required by law, or to the extent it is authorized by law. Now, in Wyoming, you're not going to have to slice and dice this very much because adult abuse under our statute, disclosure is required by law. Okay, but if you were in a different state and there was different levels of abuse, one that authorized disclosure and others that required disclosure, you would have to go through this more detailed HIPAA exception for the situations where disclosure was authorized but not required.
Right.
Yes.
Can I?
Yeah.
One that may come up for you guys a lot. I just think these are interesting if they're coming up for you, and I'll bet they are. But in Utah, for, let's say, domestic abuse, the woman is being abused, there's nothing under Utah law that allows you to disclose, right, that requires disclosure or allows you to disclose unless she qualifies as a vulnerable adult. And so I have to go through that analysis with my providers of, does she classify as a vulnerable adult? Let's go through it. Yep. Most of the time not. And so in that situation, unless anyway, you have to kind of respect what they want to do.
Yeah, and that's true in Wyoming as well. You have to be a vulnerable adult for the reporting stage. Yes. Okay.
So if he goes in and doesn't want to call,
well, that's a great question. But a victim of domestic violence comes in and refuses to authorize you to contact law enforcement, there is no Wyoming statute that requires you by law to report domestic violence to the authorities. Well, without a state law that authorizes you to, or that requires you to report, then you have to decide, does one of the other HIPAA exceptions apply? Now, is she a vulnerable adult? Well, any person over the age of 18 who is unable to manage and take care of herself or her money, assets, or property without assistance, or as a result of advanced age or physical or mental disability. So if this victim has a physical or mental disability, and you can make this definition of vulnerable adult fit, then you may have a way of reporting the abuse of a vulnerable adult. But short of that, you've got to, now, if there could be a lot of circumstances that you learn that might help us fit that into one of our other exceptions we're going to talk about in a few minutes. So there may be a way, but it's not going to be as simple as saying you're a victim of domestic violence, therefore we will release. So let's think about some of the other exceptions we'll talk about, and maybe we can find a way. Yeah. You might have imminent, sure. Could have. Yeah, if there's an ongoing threat of imminent harm to the victim, that might be a way too. I mean, if the victim says, no, I don't want you to tell, and I'm going to my mother's house, I mean, then you probably don't have an imminent threat. So you've got all the circumstances matter when you want to report and you're trying to find a way to do it. All those circumstances matter. Child neglect and abuse under the Wyoming statute. Again, the immediate report required if you know or have reasonable cause to believe or suspect. Now, under both the vulnerable adult statute and the child abuse statute, there is a long list of broad topics that the law requires you to provide to law enforcement or DFS when they call you to follow up. So the HIPAA restriction on the minimal amount of information you disclose is enlarged, if you will, by this requirement of state law on the breadth of the information that you're required to disclose. So once you report a vulnerable adult abuse or a child abuse situation, there's very little that doesn't fall within what you're required to give under the state statute. So you're kind of at that point providing pretty much all the PHI that's related at least to the current abuse or injuries. Coroner's cases. I love this statute. So HIPAA provides that you can notify a law enforcement of the death of a patient if required by state law. So Wyoming has this old statute that says if a person is, quote, found dead, unquote, under the following circumstances, it shall be reported to law enforcement. I just think that found dead is kind of an interesting way to put it. It's not like you're walking through the hospital and, oh, I found a dead person. But anyway, I think it applies equally well to people who die in your hospital, or they're brought here, transported here, and they're expired. When it fits into one of those categories, and at that time you have an obligation under law to report it to law enforcement. Again, you want to document why am I reporting this under this statute, so that there's no question about your conclusions of the various suspicious categories. Every Wyoming hospital's favorite chapter of the law, Title 25, the records of the examiner, the report of the examiner, those are all required to go, not the records, I should be more precise. The examiner report that's prepared for the 24-hour hold is obviously a record that goes to a variety of different individuals who have a role under the statute in deciding whether to involuntarily detain and then involuntarily hospitalize that individual. So that's a pretty broad exception to HIPAA that applies in those circumstances. Yes. Yeah. Yep. Yeah. Let me. That's great. So the sexual assault exams, SANE exams under Wyoming law, those are all consent driven. That's the reason I didn't include those, because they're all consent driven. Doing them requires consent, and then the patient has the right to decide whether to release the results of those. So there is no, unless you can fit it into another HIPAA exception. The statute itself about the sexual assault exam does not give the provider the right to release that to law enforcement without the consent of the patient. Unless it's a minor. Well, now if you've got a minor, then and the minor, the sexual assault statute is worded very poorly for minors. Now, because it says if a minor reports sexual assault and consents to the test, then you can do the test, right? So the minor has to report it. So I've had situations for clients where the minor is brought in by either the other parent or a guardian, and because the minor has said so-and-so did this to me, the minor gets to the hospital and the nurse examiner begins asking questions, and the minor says, "No, I don't want to talk about that." Well, this minor has now not made the report, right? So do you have consent to do the test? Do you have, so it's a very tricky situation with the minor when it comes to sexual assault, their exam anyway under the statute because of how the statute's worded. But I think if you give a minor who comes in and says, "I've been sexually assaulted," or I had sex with, my neighbor or whatever, the awful circumstances are, and it's a minor and the person involved in the sexual act is not a minor, then I think you've got abuse under the reporting statute, regardless of what the minor wants to do. So that's a little bit of a different scenario. So I didn't include the SANE exam simply because they're all consent driven, and law enforcement, you have to have consent to turn those over unless you fit into one of the other things. Yes, if there's a subpoena or a warrant issued by, it would be a warrant. It would be a criminal warrant issued by a judge. Yes, then you're obligated to. Right. If there's no consent, you're going to have a warrant. Okay. DUI testing. We probably all know that if you drive on a Wyoming highway, you have impliedly consented to DUI testing in the event that you're arrested, and that implied consent continues until the driver revokes it. The driver can be under arrest and can decide that they are withdrawing their consent unless there is death or serious bodily injury as resulted from this driver's operation of his motor vehicle, or there's a warrant, again, a warrant signed by a judge. So that you can have, even after the test is done, the driver can refuse to release the results of the test. If they do that, there's obviously penalties under Wyoming law, including the loss of their license for a specified period of time and things like that. But under those two circumstances at the bottom, the driver cannot withdraw consent, and you can release. Again, you're going to learn that information from the law enforcement officer, right? You need to document that information in your chart so that you can prove that you had a required by law disclosure in that situation. When the driver comes in and says, I want you to do a test of me because I'm not drunk and the officer's wrong, once that happens, then the law enforcement gets that test result as well under the same statute. So there are a variety of disclosures that Wyoming law does not require. So we got this, again, we're going back to this HIPAA authorized by law vehicle. And some states have a laundry list of things that you have to call law enforcement about. Wyoming hasn't done that. The legislature last year rejected, or I should say refused to pass or didn't pass a gunshot and stab wound requirement. I think a lot of hospitals want a gunshot and stab wound requirement because they want to report to law enforcement, but there's no state law requirement that you do that. So that's an example. I mean, traffic accidents, there's no requirement that somebody walks into your ER after a traffic accident. There's no requirement by law you disclose that to law enforcement. So there are a variety of areas where you're going to get difficult cases that don't have a requirement under Wyoming law. Then there's some HIPAA-approved disclosures that are not state law based, that are HIPAA-based. So you can, the disclosure to apprehend a material witness, a suspect, a fugitive, Those are, you can release PHI if you believe in good faith that the disclosure is necessary for law enforcement to identify or apprehend an individual because of a statement by the individual admitting participation in a violent crime that the covered entity reasonably believes may have caused serious physical harm to the victim. Now, this is not the victim, of course, is not your patient. Your patient is the person making the admission, right? So when that person comes in and they're all, they're in a mess, they're getting care, and they say, yeah, but I finished him off. Okay, there you go. It appears that the individual has escaped from a correctional institution or from lawful custody. Now, if somebody comes in and says, I'm a homicidal maniac and I need some counseling, you can't release that information. But you can if they admit in the course of other treatment that they've done something that reasonably believed caused serious physical harm. Facility directory. If the patient has been informed that you will include their name in the facility directory and the patient has had a chance to restrict disclosure, then you can, and the patient did not restrict disclosure, then you can tell law enforcement where the patient is in your facility, whether they're there, and where they are, and their general condition. You could tell any member of the general public that information about that patient. You can certainly tell law enforcement that. Now, there may not be a chance to give the patient a chance or an opportunity to give the patient a chance to object because they're incapacitated or they're in the middle of emergency treatment. And you can still go ahead and disclose if you know that for this particular patient, that would be consistent with what they've expressed in the past, or if you think it's in the individual's best interest in the exercise of the provider's professional judgment. That's a pretty malleable exception, that second one about it's in the person's best interest in the exercise of professional judgment, right? There's not a lot of guidance there. So if you're going to document that, you're going to have a doctor or a healthcare provider explain why I think it's in the best interest for the police to know where this person is in our facility. I wouldn't skip that. I'd make sure that ends up being documented before the police are notified about the location of a person who has not had a chance to object to being in the directory. Law enforcement orders. Now, I told you I wasn't going to spend a lot of time on these. Again, if you see a signature of a judge, magistrate judge, an administrative hearing officer, you should get an analysis of that. Make sure your lawyer looks at it to make sure it's proper and it looks like a legitimate document. But once that happens, you're probably in a position where you need to comply. Administrative requests and investigative demands are different. Those demands are law enforcement giving you a written request for PHI, not signed by a judge. It might be signed by the county attorney. It might be signed by the law enforcement officer. In the situations where the information they want is relevant material to their legitimate law enforcement inquiry, and the request is reasonably specific, limited to the purpose, and you can't satisfy it without providing PHI, in other words, de-identified information wouldn't work, you can comply with that written request. Obviously, the document you get from law enforcement better satisfy all of those subparts before you provide information in response to that. Request to identify or locate a suspect, fugitive, witness, or missing person. If the law enforcement comes in and says so-and-so is a suspect, or they don't even need to have a name, they can say, we believe a suspect in the crime came here, received treatment between this time and that time or something. They'll give you a variety of information. And if they meet these requirements, then you can use this HIPAA exception to provide that list of information to law enforcement if you believe that your patient is that information can be used to find the suspect, fugitive, witness, or missing person. Victims of crime, you can disclose limited information about a patient who is suspected to be a victim, if the patient agrees, of course, or if the patient is unable to agree because of the circumstances, and the law enforcement officer tells you that the information is needed to determine violation of law by somebody other than your patient, and they're not going to use the PHI or law enforcement against your patient, and it's needed immediately. And then the provider determines it's in the best interest of the patient to release that information. So this is sort of the broader victims of crime category that might apply to your domestic violence situation. If the patient's saying, I don't want to report, I'd be very cautious using this. I'd want to make sure that I've got everything documented well. I'd request a written statement supporting all that from the law enforcement officer, and I'd really test it. I'd be very critical of what they're telling me, not because I don't believe it necessarily, but it's got to meet all of those requirements. So this is not a sort of get out of HIPAA jail free card. It's very specific in what it requires. Crime on the premises. If a crime is committed on your premises, you can report that to law enforcement. Classic example, somebody brings drugs, controlled substances into your hospital. Possession of a controlled substance is a crime. It's occurring in your hospital. Hospitals go different ways with that. I know that some hospitals have different policies about how to deal with that. But that would fit within the HIPAA exclusion or exception here. Crime off premises that occurs while one of your employees is providing emergency care away from the hospital. It's got to be emergency care, and if so, then the employee of the hospital can provide these bits of information: commission and nature of the crime, the location of the crime, and the identity, description, and location of the perpetrator. Even if the victim or the perpetrator are your patient, you can provide that if you learn that information because of an off-premises crime that you observed while providing emergency services. Crimes against one of your workforce members. If one of your employees is a victim of a crime, they can disclose information to law enforcement about the perpetrator and within this limited list of information. Person in custody, obviously if an inmate or a person who's under arrest is brought in for treatment, you can provide this information to law enforcement to assist in that treatment or for the health and safety of others that the person will be around following their release from your hospital. Access to patients. General, let me just say that there's obviously a practical aspect to this. You all want to get along well with law enforcement. You need to get along well with law enforcement because there's always a time when you want that sheriff's deputy who just happens to be standing around in the ER to step into an exam room to calm somebody down, right? Or something like that. There's always times when having a law enforcement officer nearby can be helpful in a place like the ED. So you want to maintain those great relationships. The HIPAA doesn't really give us a relationship exception, so we have to figure out a way to work with law enforcement to make sure they get what they need to do their job while we comply with HIPAA. Police access to patients is one of those areas where I think law enforcement sometimes can't understand what the problem is here, right? I just don't get why I can't walk in and talk to that patient. I think that's one of those things you really need to discuss in advance with your law enforcement agencies that service your area so that they understand when they show up what the process is going to be. You always have sort of a provider trump card when it comes to patient access. If patient access is inappropriate for healthcare related reasons, either infection control or the patient's condition isn't stable, the anxiety of the police officer being questioned might be harmful to the patient's health. That's sort of a trump card. You can, if the provider says no, this is not the right time, or no, we're not going to do that right now. That's good enough. Tell the officer no, we're not going to give access. You can always ask the patient for consent as well. That opens a lot of doors. If the patient says, yes, I'm willing to talk to the police. The patient can revoke that consent at any time, obviously, but you need to document all of those actions if that happens. If the patient declines, you're going to have to talk to the police about the other options. If the police insist, with the guy with the gun says, I'm going to talk to that patient, you document that in your record and you step aside. And there's really no other good option for you. After the incident is over, you're going to have to escalate that and make sure there's communications between the law enforcement agency and the hospital administration about how that's not right and how to handle these situations in the future. ICE has policies. I don't know if I want to ask for a show of hands. I have not heard of ICE showing up at hospitals in Wyoming. But I think they have in the past, from time to time, shown up in hospitals around the nation. They have a policy that they will not conduct enforcement actions at sensitive locations, which includes hospitals and a variety of other healthcare treatment facilities. So that if ICE shows up and wants to do something with respect to a patient, I think you can take a somewhat stronger line than you might with your local law enforcement about ICE access. So we need to prepare in advance for these situations with law enforcement. Your privacy notices can address subpoenas and court orders and those kind of legal documents. You should have a policy, I think Christy talked about this, having a policy about responding to law enforcement requests so that your ED staff doesn't feel the pressure of that. They can call in somebody else. They can focus on patient care. Either the administrator in charge, or the administrator on call, or the charge nurse or the house supervisor. Somebody can step into that ED situation and help deal with the law enforcement request, whether they're expecting or even asking your frontline staff to do that. Obviously, talk to law enforcement in advance. Train everybody in your high public touch areas about what the process is. I would imagine that 7 out of 10 of these incidents are through the ED. Maybe a few come in through a different place, but your ED staff are the ones that are going to deal with law enforcement on a regular basis. Make sure you verify the authority of the person you're talking to. Now, for many of you, you'll see the same law enforcement officers over and over again. You know them, you've known them for years. That's great. Record their name in your chart, and you know their authority. You get somebody showing up who you don't recognize, somebody who says, I'm from the FBI agent office in Salt Lake City or something like that, spend more time with that. Get the credentials, make a photocopy of them, or jot down all the pertinent information. Somebody you don't know and haven't seen, make sure you do all that and you have that in your chart. Documentation, you can ask for written documentation. In fact, some of the HIPAA requirements, some of the HIPAA acceptance require a written request. Don't hesitate to ask law enforcement to put it in writing and make sure it covers all of the topics you need to take advantage of those exclusions. Some cases you can require a warrant. Only when there's really truly imminent and serious harm or a fugitive is going to leave the jurisdiction. Those are the times when law enforcement can make a reasonable case that we don't have time to get a warrant. Warrants in Wyoming can be obtained over the telephone from a judge these days. So we don't have time to get a warrant. Well, okay, put it in writing why you don't have time to get a warrant. Okay? Almost always they can find a way, they can get a warrant and come back and get the PHI they need. So I'd encourage you, whenever you get to the point where you're uncomfortable that any of these HIPAA exclusions apply, I think asking them to get a warrant for that information is a perfectly reasonable request. Now, you might want to talk about that with administration before you do it, because that relationship is really important with law enforcement. But at some point, they're just, the situation just doesn't warrant using a HIPAA exclusion, and you're going to have to follow the state law warrant process, or they'll have to follow the state law warrant process. Informal requests, again, you know, hey, just tell me this, and a little sidebar conversation at the desk in the ED. They need to provide authority that fits a HIPAA disclosure exception, a HIPAA release exception for that to work. And when it fits that, then fine. But then again, that all needs to be documented. You have a HIPAA disclosure log that needs to be filled out when you give information to law enforcement, and it's the hospital's obligation to include all of the information to satisfy the HIPAA exclusion that applies. It's not up to law enforcement to provide you that. You've got to ask for that and then document it in your disclosure, or you've got to document it and then make the right notation in your disclosure log. Okay. Minimum necessary standard applies, again, unless it's trumped by state law, like it is with child abuse and vulnerable adult abuse. Give them just what they need to satisfy the scope of their request. Log the disclosure. There's the things you need to include in the log for your HIPAA disclosure log. And then accounting of the disclosure. There are times when law enforcement will tell you, we're requesting this information. You've got a HIPAA exclusion or a HIPAA exception that applies, but we don't want you to put it in your log, or we don't want you to notify the patient that we've got this information. That can be done verbally initially, but if that request is going to be in place for more than 30 days, they have to follow it up with a written request to not allow disclosure of the log to the patient. Some other resources here, in addition to the Holland & Hart client alerts, OCR has a couple of documents out on release to law enforcement that are helpful.
All right, good afternoon, everybody. We're going to jump back into things. We got a little off track the last couple presentations, but I'm going to try to get back on track. We could have pulled Brad early, but I wasn't going to tell him no. You've seen him. My name's Rich Stolde. I'm a attorney from the Denver and Boulder offices of Holland & Hart. I practice in areas of information technology, transactions, telecommunications, and cybersecurity. So in that realm, I work in all kinds of verticals from healthcare, as well as banking, mining, all kinds of industries dealing with the purchase and sale of software, technology solutions, et cetera, as well as telecommunications. In healthcare, done a lot of work implementing EHR solutions, responding to data breaches, that sort of stuff, and I have a whole lot of experience as a healthcare recipient from my own misadventures. So with that, let's get started. In the cybersecurity world at Holland & Hart, I like to think about things as a life cycle when it comes to data protection. And you can enter this at any place in the life cycle, everywhere from data collection, data storage protection, security, destruction, data breach prevention, and readiness. We're going to talk about a subset of those, but they all interrelate. What you do from a data collection perspective influences your data breach risk and so forth. And it's a continual cycle and a continual evolution as we respond to the risk. Okay, so today I'm going to hone in on three primary things. One are the data breach threats. One is some of the guidance from HHS. And lastly, data breach incident response. Now, I've got a whole lot of content up here, approximately 60-some slides. I noticed that through the years that I went to healthcare providers, they always give me a big packet of paperwork every single time. So this is my way of giving back to the community. We're probably not going to get to it all, but there is a resource. And there could be a little bit of overlap on some of the things we talked about before, in particular when we talk about privacy. So I may rattle through some things quickly. If you have any questions, raise your hand, and we'll get to those as well. first, that doesn't present well. Every year there's a number of organizations that do data breach studies, and they compile all the data of public information about data breaches, data breach incidents, and they put a bunch of statistics together. One of those is Verizon. They put a big data breach study together, and they always have some interesting things that come out of it. One of those is some things that are not surprising, that the increase in data breaches that's happened over time, the fact that there's been a whole lot of social engineering and phishing that has been on the rise, and they're going after the high-level executives. Actually, not really the high-level executives, because they use tools like LinkedIn, which we all use to market ourselves, and they go out and go, oh, okay, here's somebody with a high-level position. They're probably connected to all sorts of other people in the organization, so they find somebody that works with them, and they can learn all sorts of things about them. And those become the targets of phishing. I've had a lot of experience with this lately, unfortunately, with clients where they found the assistant to the CFO, and they spoofed an email to them that said, hey, we got a payment we need to get out to a vendor. It needs to be done by the end of the day today. Will you please wire $1 million to this bank? And it looks and feels and it's everything like a normal email from the CFO, and so it happens. And we end up chasing it down and trying to get the stop. There's been a whole bunch of activity in misconfigured cloud platforms. We'll talk about this in a little bit, but the proliferation of SaaS solutions, where the providers, Amazon Web Services and others, put the onus on the buyer to do the configuration. They say, we've got the platform, but you need to set the settings that work for you. Leave a lot of open sets of data out there. If you don't check the right box, that data can be exposed to the whole world. There's a lot of information on that. Ransomware is viewed as the second biggest threat out of malware. My experience with ransomware in the last year or two has been, even though it's on the rise and happens more and more, it seems to be a quick hitter, to where you used to hear these stories about San Francisco, the BART system got hit by a ransomware attack a couple of years ago. They asked for millions of dollars. The ones I've seen lately are like, give me $1,000, give me something, because if they hit 100 people with that, they can make a lot more money than if they try to do the big ones. The big ones are going to attract attention. And if you're a victim of one of these things, they're banking on the fact that you need your data back. You might part with $1,000 or $5,000 to avoid getting shut down. A few other interesting tidbits coming out of the data breach study. Out of all the industry sectors, healthcare was the only one where the number of incidents caused by insiders was greater than those caused by outsiders. 59% in healthcare involved insiders compared to 42% involved external sources. 81% of all the incidents involved either, and I want to distinguish between incidents versus breaches. There's two different things. I'm going to dive into that later. Incident is just, could be just a rules violation. Data breach is where information actually gets out. So this is talking about incidents, but 81% involve things like the software misconfiguration that I was talking about with the cloud provider, privilege misuse, and web applications. Those all translate to mistakes. Those aren't bad actors, those are mistakes. Where do they fall in from a more specific perspective? These are the numbers, the raw numbers in healthcare based upon their data set. But 97 were miscellaneous errors, 85 were privilege misuse, 65 were web applications. You get down to the really bad stuff that we worry about, the bad guys being out there, they're still out there. The numbers are fewer, but really there's a whole lot of mistakes to be made. One of the biggest, you've probably heard in the news, discussion of GDPR in Europe, which if you're not operating in Europe, you don't have to, okay. If you're not operating in Europe, we don't have to worry about that today. But an example of privilege misuse or a privilege mistake is there was a hospital in Portugal that had I don't know how many employees, but about 300 doctors. And it's important. We talked earlier in some prior presentations about it's important to make sure that access to data is limited to the right people, right? If you only need to know this subset of data, your credentials should restrict you to that. Different care providers need access to a larger set of data. Well, this hospital had, even though they had only 300 doctors on site, over 900 people held the IT credential in their system that could access all information just like a doctor, even only 300 doctors. So that's a mistake in terms of authentication. That's a mistake in terms of giving access to data. They really only had one level of access. They were fined for it because that was kind of a basic IT systems requirement to say, no, let's limit access to only the people that need access. All right, so diving deeper into healthcare, the healthcare sector in 2018 saw 15 million patient records compromised and 503 breaches, which was 3 times the number seen in 2017. Healthcare and I'd say probably financial services and hospitality have been the industries I've seen most under attack, and the phone calls I get the most about. They've also been massive data breaches in some cases. Each of the 10 largest seeing more than 200,000 records breached at a time. And most of those incidents related to third-party vendors and phishing attacks. I saw a statistic coming out from another study from the Ponyman Institute that said on average, well actually I'll ask first. Do you have an idea of, within your organization, how many third-party entities, not counting patients, but just third-party service providers or entities you might deal with in your organization? Any guesses? The average from a Ponyman Institute study said that most organizations have about 583. That's a lot to keep track of. And a lot of times we think about the big ones. We think about the EHR systems vendor. That's got a lot of access. But the EHR systems vendor has 583 vendors behind them that we need to be mindful of. And we've also got everybody else. We've got people that might come in to collect paper for shredding. We've got people that clean facilities. We've got people that come and stock products. We have medical device reps that are walking the halls. Every one of those is a third party you might interact with. So third party risk is huge. I've got a listing here of some of the biggest data breaches of this year. Call it the healthcare top 10. At the top of the list is American Medical Collection Agency. 25 million patients affected so far, one of the largest of the year. An interesting number that comes out of this is the Ponyman Institute, as part of their data breach studies, what's the cost to respond to a data breach in different verticals. Healthcare is the highest. And they estimate that in healthcare, each record for every single one of those data breaches is something like, costs something about $400 in terms of response and risk and liability. So I should have done the math real quick, but $400 times 25 million, very big number, very expensive. What's also interesting about some of these listings is I've bolded in a few cases what exactly happened here. Dominion National had a 9-year hack on its servers. Unfortunately, that's not all that uncommon. Sometimes it takes a while to figure out where the problem is. 9 years from when it started until when they found it. There's another health group that had a misconfigured database. May not have been encrypted. Maybe access wasn't limited, but in another sense, people could get to it. The search engine function, that allowed the data to be pulled out so people could see it. University of Washington Medicine had almost 1 million because of a misconfigured server. The patient was able to search their own name, found the data. Encryption helps this kind of thing, but there's been no shortage of these. Wolverine Solutions got hit by a ransomware attack. Now, ransomware usually comes in through something like email. And once it's in, it's in. But ransomware is a problem. Oregon Department of Human Services, it's not just private sector. The government gets hit with these as well. They fell victim to a massive phishing campaign. 625 patients, 2.5 million emails. Some of the bigger data breaches of the year involved the FBI, as well as the U.S. Marine Corps. Now this one's interesting. We do this all the time. How many people have email that auto-populates names based upon memory? Handy. Go write an email to Steve, and it'll pop up every Steve, and I get to pick the right one. And it works great, as long as I pick the right Steve. The U.S. Marine Corps breach had exactly that happen. They sent the travel profile information for their internal kind of travel service for all of their military service members and family. They sent all these records to the wrong people based upon just pressing the wrong email button. A couple others that you can look through later: phishing attacks, hacking incident, server migration error. Some of it's basic blocking and tackling. So that's the scary stuff. Now I want to dive in for a little bit into guidance, because we've got, as you've heard before, we've got lots of resources out there. HHS.gov has put out a whole lot of cybersecurity guidance. Has anybody looked at this yet? There's a great pamphlet on there. I'm actually going to go through a bunch of it, and in all honesty, a whole bunch of the information I have on here is listed right from there, because it's got some great examples. They start by listing what it looks like. As part of their overview of it, this was a document put together with private industry, security professionals. In part, I think, because when we talk about HIPAA, I would say is really geared as a privacy statute. And Christy talked earlier a little bit about the privacy implications of it. It's got a safeguards rule underneath it, which is more security-minded. It's got a data breach rule. But in cybersecurity, we talk about two things. One's privacy and one's security. Privacy generally talks about, okay, here's the promises I'm making to you about what I am doing and I'm not doing with your information. That's what HIPAA says. I can only disclose it to these categories of people for these limited purposes. Can't sell it, and so on. Security gets into the nuts and bolts of how do we protect it? What rules do we follow to protect it? And even though HIPAA, under the safeguards rule, starts to talk about, hey, you need to use physical, administrative, and technical controls, they really don't go into detail about what are those? How do we define the right controls for you? Instead, they sort of say, well, you got to be reasonable and appropriate, which is what every other privacy and security statute essentially does. They don't want to get in the business of defining what technology you need to use, because technology is fleeting and it moves through time. So whatever you put in a statute today is already a year behind where the rest of the world is. So instead, we use this standard that says, okay, reasonable. Well, what's reasonable? Well, I spent about 3 years in law school talking about what reasonable is or is not. But in this context, it's what is reasonable security in relation to the sensitivity of the information that you're trying to protect. The more sensitive the information, such as protected health information, the more security you need to have in place. The less sensitive the information, the less security you need to have in place. So as part of the guidance, and this has been a common theme across industries, there's a statement in the guidance that says, hey, look, cybersecurity needs to become an integrated part of patient care. Important. You've also seen the SEC do this for public companies. They've said cybersecurity needs to have a regular part on the agenda and a regular part of financial disclosures. So it's become a big issue because it's a risk profile. It's a risk issue for everybody. And as part of that, they said, hey, look, the changes in security, the changes in the threats, they're not going away. They're going to continue to get worse. And the more technology we use, from which a few years ago was bringing iPads in to meet with a patient, and now we've got beds that have remote monitoring. All of those systems require hardening to protect them. And because of that, they're saying, okay, now's the time to start, and we're going to put rules in place and guidance in place to help you do that. So in their guidance, they've identified what they view as the 5 biggest risks, and these, again, are probably similar across all industries. Phishing, ransomware, loss or theft of equipment, data loss from various sources, and attacks against medical devices. So let's talk first about email phishing, because this is, like I said, I'm dealing with this every day. What's the scenario? Well, very often it comes in as some form of, it comes in as an email. Somebody's found you, you've become a target, and the hacker can send out hundreds of these emails. You only need one person to click on it. So the email looks like it comes from an IT person, maybe from your patient billing company, or somebody else who's familiar and trusted, and somebody clicks on it. And maybe it takes them to a login page, or maybe they ask for some information, like the example I cited before about, hey, can you send a check out? That's where it starts. What's the impact? Well, maybe a check gets sent to the wrong person, to a bad guy. Maybe, in this example from the HHS guidance, they say, hey, a pediatrician learned that an attacker stole patient data using a phishing attack and used an identity theft, sold it on the black market. So on average, each person receives about 80 emails a day. I think that might be a light day for some of us. So how do you define which ones are safe to open if you're not thinking about it? Do you know the sender? Sometimes there's tip-offs. They're getting better, but a lot of times there's tip-offs. The grammar seems off. Phrasing seems off. Before clicking on a link, do you take your cursor and hover over it so that it'll show up where it's going, where that link goes, and does it actually go where it says it's going to go? Do you have any suspicions at all? I follow a general rule not to click on attachments, and we even had situations where internally at my firm, where we even have a chief information security officer, where every now and then they say, yeah, you need to do this and click here. And I'm like, hang on a second. So I email the IT department, I say, is this for real or is this not? So always check. And then is there a process for reporting suspicious emails? So they say the best time to familiarize yourself with your organization's policies and procedures is when you begin employment. I think the biggest way to battle email phishing is through training and testing. You're seeing more and more of this. So it can't just be training on a one-time basis at hire. Got to be continual because the threats evolve. There's a lot of organizations that do testing that say, okay, every 6 months or at least once a year, there's a little 10-question training test or something. Takes you 10 minutes. You got to read through some things and answer some questions. You pass or you fail. You read through it again and pass it. There's also testing. The testing piece I hear mixed reviews on, but sometimes they will say, okay, we're going to send out an email that is actually phony and see how many people click on it. And the people that click on it, we're not going to be in trouble, but we know we've got a risk exposure, and we're going to try to make sure that they're trained on it. So how do we respond to this? How do we avoid it? Well, anything that's not familiar, request sensitive information, include a call to action that requires urgency, you should think about. Now, in a hospital, you probably get a lot of requests for things that require urgency. But when it comes through an email, if somebody really needs something, I think they usually know how to get a hold of you. If it's that urgent, are they going to send you an email? Train everybody to recognize suspicious emails and to know how to report them. Never open an attachment from an unknown sender or a link. Tag external emails, make them recognizable. So this is an IT function, but it's easy functionality that you can find out there that flags emails as whether they're coming from an external sender. Not that hard to implement. Put a yellow box on the email that says external email. So you already know that it's coming from somewhere outside, even if it looks like it's coming from inside. Make sure you have an incident response playbook to manage phishing attacks. Implement technologies to detect them. There's a lot of systems out there that can sort of screen email, to screen out spam and unrecognized sources and filter the email. And implement appropriate response procedures. So making sure employees know where to go with a problem. If they see an email, and more importantly, make sure they know who to call if, oops, I just clicked on that link, what do I do? Somebody's got to be able to sound the alarm bell and know how to do it. And you have to, the touchy part is you have to do it in a way to where they're not in trouble. You actually want to know that so you can compartmentalize it, right? And it also helps to be a part of information sharing groups. There's a number of these out there where IT professionals get together and talk about the challenges they have. We host a few in our Denver office and our Las Vegas office, include healthcare providers. And you get to have these frank discussions and say, okay, what solution have you used for email filtering? How does that work? Those are really helpful. Next thread, ransomware attacks. Real world scenario. Again, an email that appears to have come from the right place, directs you to download security updates. And maybe it's malware, maybe it's ransomware. Sometimes it's been, I've dealt with keystroke loggers. You didn't even know were there. A little piece of software sits there and captures every keystroke, including all the data. Like I said before, ransomware locks up your system. Doesn't let you touch it. Usually get a message that says, okay, we've locked up your data. We can't have it back until you pay us much money. Really scary. Impact, well, a practitioner can't view patient charts, which could be a real dire situation. Most of them, they all come through email. So you always need to stay alert, just like on the phishing campaign. The way to combat this is firewalls, email filtering, intrusion protected systems, and user awareness. Now, responding to ransomware attacks, you get different answers on. Sometimes your cyber insurance carrier wants to handle the entire situation. Very often they do. They say, if you get a ransomware attack, you need to call us and we're going to handle everything. Otherwise, you're not covered. As I said before, the growing trend has been not to ask for a large amount of money. It's been asked for the right amount of money, trying to guess how much you'll pay just to move past it. They've become very good at that. So the demands have been $5,000, $2,000, $10,000 because they can hit and move on. Oh, wow. 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 No, I hadn't heard that. Yep. Yeah, and so there are the big issue here is access to your data, right? So one of the protections that helps you there is if you've got regular backups, depending on what your backup frequency is. Hopefully you don't lose all that much, and if they haven't captured that data, if they just captured your production current system, you can go, can you reload a separate instance? Being configured to where you can do that helps. But it's scary stuff, and it can be paralyzing. Wow, I've chosen the wrong colors. Oh, it looks fantastic, doesn't it? I got a little. I admit, somebody showed me this cool little design feature on my PowerPoint, and I went a little wild with it here. But yeah, the color choices are a little off. So a lot of the same answers that we talk about with phishing, getting an email phishing, also applies to ransomware because it's coming through the same source. user awareness training. So if something doesn't feel right, just like in the phishing, it's important to have a reporting mechanism. Make sure that everybody knows to say something and that there's not going to be a penalty for saying something. Regular training, again, that's a common theme here. Regular user awareness training on all these topics to make sure that people understand that if something doesn't feel right, it probably is, and at a minimum to report it. And making sure that you bring in your IT people whenever there's any inkling of a risk. We already talked about this, training staff, implementing tools, using privileged access management tools. This is what I talked about before with the hospital in Portugal. Didn't have any form of access management tools, but making sure that all access is limited to only those who need to know it is critical. And last but not least, this is the new evolution. All of these cool tools. I heard of a hospital in Las Vegas that put in all of these magical beds that can be remotely monitored from the nurse's station. Every feature of it is there wirelessly. They can track everything, right? Those are a risk. Those are a risk for a ransomware attack, and can shut them down, can power them off. We've seen this happen. I haven't dealt with it in healthcare yet. I've seen it happening with building management systems, where security can be controlled remotely, where they lock down the building, nobody can get in, and they turn the heat on. Scary stuff, but it's a risk. There have been some legal requirements put in place in certain states. California is one that said any kind of IoT device now needs to be hardened with security. That's reasonable. So that's coming in other places, but it's one more risk. It's one more risk that your IT organization or security organization needs to put controls in place to address. So we've got a whole lot more detail here on going through the process of determining what you put in place with the vendors. So some of these devices, hospital beds, for example, implicates that third-party risk issue. Because very often they're providing the device, they're providing the monitoring tools, that might even be storing data in the cloud for you. So it all comes down to third-party risk management, doing your diligence on what kind of security they have in place, exercising reasonable oversight, and making sure only the right people have access. All right, so I've got a little bit here that I think I'm going to gloss through because Christy covered it on HIPAA rules. General requirements are ensuring confidential integrity and availability of protected health information, protect against reasonably anticipated threats, and unauthorized uses and disclosures. So, what kind of security measures do we need to put in place? Well, like I said before, reasonable and appropriate. What do we consider there? Well, I think we heard before about the standard of care. This is kind of a standard of care-like analysis, right? It's what is reasonable based upon your size, complexity, capabilities, what's reasonable in terms of technical infrastructure, hardware, and software, the cost of the measures, and the probability and criticality of potential risks. Those are all relevant, but generally, the more sensitive the data, the more it needs to be protected. So when we talk about what those security measures are, there's been a change in the law the last few years that's popping up in a number of jurisdictions. And it used to be, 10 years ago, you'd say, okay, you need to put security measures in place. Physical, administrative, technical. Done. Let's move on. Now it's added a feature where, it's not just that, not just those measures. We're going to talk about what those measures are. We're going to put requirements in place to say you're going to use some sort of oversight and testing. We want a right to audit you to make sure you're actually following that. And I like to look for any vendor that I buy from, they've got some sort of security methodology in place. Now, HIPAA and a lot of the other privacy and security laws don't tell you which one to use. You need to find the right methodology that works for the information you have. There are recommendations out there, but to me, it's important to know that they've got one, that they've built their infrastructure, with a privacy by design focus, they call it, where from the ground up they've said, okay, this needs to be secure, so we're going to build it to be secure. And knowing that they did that and knowing they have a set of rules they follow and then they test against them is part of the analysis. Here's some examples of some of the administrative safeguards. We talked before about physical, administrative, and technical safeguards. I'm not going to, in the interest of time, I'm not going to dive into all of these. Christy talked about them a little bit. Physical is generally locks on doors, limited access. In the case of our firm, we have Brad. He helps take care of that, physical security. Administrative security, if you don't have a Brad, we need to cover it with locks. Administrative security is processes and procedures, limiting access to the right information, user training, et cetera. And technical security is the fun stuff. It's the IT measures. It's the encryption, the firewalls, it's password management, it's login information. I heard this statistic a while back that talked about password complexity. And this is an organizational problem sometimes that you run into where the difference in a hacker's ability to hack a password at 8 characters versus 12 is a difference between like 1 year's work versus like 12,000 years of work. That like, and I don't remember exactly what the breakpoints are, but I remember once you get to 12, which a lot of people push back on, but it gets longer and longer. But once you get to 12, you're talking about a hacker using their computer for a long time to try to get that, and generally they move on. But 8 characters isn't all that hard. Some more specific references in the actual CFR about physical, administrative, and technical safeguards, including things like encryption, authentication, all the things that you need to put in place to make sure a user is who they purport to be. Also, on the website for HHS is a security risk assessment tool. So part of all of this, when we talk about security, is having an overall, call it a comprehensive information security program. That includes risk assessments. This isn't a one-time thing. It's a continual thing every year, right? Risk assessment helps to guide what you need to fix, which every year is going to be different. There's a lot of work because you're moving through different threats all the time. So you might do your risk assessment this year and say, hey, look, we think we're vulnerable to phishing. We took on a new vendor. We haven't fully vetted them yet. We've got certain risks today. We've got some other things we feel pretty good about. So we've got a couple of things we mark as yellow. Next year, we might go through those threats and we say, okay, we might have done a bunch of user education training and testing it for phishing. So now we've switched over and now we have some other IT systems hardening we need to do. We need to implement encryption where we haven't before. The risk assessment tool has a few different versions of it on site. We're on the website, paper and iPad and Windows and everything else. It's a starting point. And I usually recommend, look at the experts. You usually got IT experts in your organizations, and if you don't, you can find them out there who can help you with this risk assessment. The one thing I would say is when you do bring in those experts, I think it's helpful to separate often the experts doing the assessment from the people doing the stuff. Because if you got them in the same house, they might be incentivized to color their assessment. I haven't seen anybody do this, but there's kind of a lack of harmony there between the people doing the audit versus the people doing the technical stuff. And that's something that's always scared me. Plus, I think it's got legitimacy when the testers come in from the outside. The same goes through even for in-house IT staff. I run into that question a lot from a data breach perspective, and I've worked with some great in-house IT staffs. Is anybody in here from the IT group? All right, so they're all online listening in. We love the IT staff, but when I've worked with entities in a data breach, they know their systems really well, and you kind of need the outsider perspective. And then if you ever get in that situation where you got to defend your actions, you've got so much more legitimacy when you can say, we hired so-and-so to do the audit, and they validated what our IT system said. That ends up looking really good. When it's you evaluating yourself, your IT people are just as smart. They can do the job, but it really helps to defend things later if you can say we brought the outside expert. There's other frameworks for risk assessments. This is the NIST overall risk assessment process. Kind of an overview of how it works. I think the one thing that probably isn't captured in there is you kind of start with what's your data, what's your environment look like, and then you go, okay, what are your primary risk sources? What are your vulnerabilities? What's the likelihood? What's the magnitude of impact? And that all forms your overall risk. And once you know that, you can talk about tackling what's your low-hanging fruit, what's your big risks that you need to hit first, what are the risks you can manage later. You're never going to get to perfect, but what we've seen in all the litigation, including the biggest data breach litigation, is if you're moving towards the target and you show, we heard from Brad and everyone else, document. If you can show you're building towards better, and that what you're doing is reasonable based upon your circumstances, that can help. Some of the major data breaches, and the best examples I can think of aren't healthcare, but it's places like Home Depot, which had one of the largest data breaches around a few years ago. Target had another one. There were a whole bunch of lawsuits alleging that the company didn't act reasonably because they weren't compliant with certain requirements. And they said, well, yeah, we weren't compliant, but we had a plan to address it, and we were implementing that plan. And as we went through time, we were implementing more and more measures to get there. That was reasonable, and that was enough, and the lawsuits were dismissed. Now, it's not to say we let it rest on our laurels, but if you're moving through time and building on it and making your security better as you go and can show it, that helps. Just an example of a page showing the risk assessment tool on healthit.gov. You can download it right there, and on the left side, all sorts of resources about privacy and security and tools. All right, so in order to understand what your risk is, and this is my take on a lot of this, these are the basic questions. If you walk away with just a few things from the next 3 hours I'm going to be presenting, these are them. These are the important questions for everybody who makes decisions in your organization needs to know. So you can go home tonight over dinner with your family and you can talk about what data do you have and where's it located? Where does it originate, get stored? When do you delete it? To whom do you share it? What are your access control points? Who can access it? How can they access it? Why do they need to access it, and do they? What are your policies, procedures, and rules? And do they actually map to what you're doing? We talk a lot about putting policies in place. You can actually create liability if you put policies in place and then don't follow them. Right? So if you got a whole set of rules, and then you do a whole bunch of other things, that policy and that action is Exhibit A in a lawsuit. Because it says you had a policy, you knew the right thing to do, you told everybody about it, and you just didn't do any of it. What do you need to be compliant with? And are you? HIPAA, anything else? And what security methodology and standards do you follow? In order to answer those questions, it's important to make sure you got all the right people at the table. There's been a tendency that's getting better over time to say, oh, it's IT's problem. But really, it involves everybody in the company. It involves the leadership, it involves the legal department, IT, security, risk management, HR. Human resources departments have a lot of cool tools for managing people. Those tools have a lot of data in them. So a lot of times we can get tunnel vision on, even in a hospital, healthcare data, protected health information. We still got to remember we got to protect the FOIA data. The effort that you put into risk analysis should be tied to the risk that the data exposes you to. Now, this is something I think about a lot, and I've seen plenty of examples of where a lot of business school types think about risk in terms of, especially when we're dealing with a third-party contract. They're going to say, okay, that contract is $100,000 for this company to do X for us. So our risk is $100,000. Nope. We heard that example before, right? 25 million records exposed at $400 a pop. That could have been a $100,000 contract and exposed you to risk that was this big. My best example of this was there was a bank called Mellon Bank a few years ago had a data breach. The data breach involved an off-site document storage provider, a data storage provider. These are people that come up and pick up backup tapes and sometimes shred information. That contract, I've negotiated these contracts before from a security perspective, and sometimes they're $2,000 a month depending on the facility. That data breach affected over 12 million people, all over one pickup where a box disappeared off the back of a truck and exposed the data of 12 million people. So in order to understand how much effort you put into it, you got to understand what the truth is. Now, I'm running short of time, so I'm going to buzz through some things pretty quick. Here's a list of some key elements for when you're dealing with third-party providers. Some of them are standard when you think about what a contract would look like, what you care about. Risk allocation, audit and verification rights, compliance with their security methodology. One of the most important ones that sometimes we forget about on the front end, because all the relationships are great, they're never going to end, is what do we do when it does end? Because it will. What security methodology do they follow? Follow NIST? Do they follow ISO? Do they do SOC audits? How frequently do they audit? And what's the scope? This is probably the biggest gap I see sometimes if somebody says, oh, I got a cloud hosting provider that said they're going to give us a SOC 2 audit. We're good. Check the box. We're done. What does that audit cover? I've had plenty of situations where I look at the audit and say, have you read it? And the audit says, we have 7 data centers, and this audit covers this one. Well, you're using all 7 of them. So does that audit cover the risk everywhere? No. And last, I got a few items on data breaches and how they hurt. They hurt in terms of business disruption, reputational harm, and potential litigation. So conveniently, HHS has this very nice quick checklist. As my entity just described, cyber attack, what do I do? So it's got a quick response checklist. Execute response and mitigation procedures, report the crime, report the indicators to the information sharing analysis organizations. Got a requirement to report the breach, you got to report the breach. So that's from a reporting perspective. We got a nice graphic here too about quick response. I'm going to skip through this as a distinction of incidents versus breaches, but I want to point to a few key items here. One is, it's important to have a game plan for how to respond to a data breach. That game plan includes having a team that can assess the issue, which includes your IT and technical people. And most importantly, this is the lawyer's full employment recommendation. You've got to have your lawyer involved. And one of the primary reasons it helps have your lawyer involved is if you have a data breach incident, the lawyer can help, in some cases, protect the investigation from discovery in a lawsuit through the attorney-client privilege. If you go, the organization goes and says, we need a cyber investigator right now, and they hire them, and they pull a report, and they do an analysis, and they say, yep, you had a data breach, and here's why you screwed up this, and you screwed up this, and you screwed up this. Well, if the IT department hires that person, it's discoverable, it's a business document, it's a report, and it's relevant. If the lawyers come in and say, we're going to do our own assessment because we think there's a threat of litigation and it relates to our representation, that can become attorney-client work product. If that expert is hired by the attorney, and it can be protected in a lot of cases. And so sometimes that bad news is a little harder to get out, so it's important. It's important to understand right away what systems are involved, what data is at risk, who's all involved. Those are all the initial triage requirements. As part of the legal analysis, you determine the scope of notification. Do we need to tell anybody? Which is not always an easy question. It's also important to when we're investigating this, sometimes your IT people can be very quick to sort of go, yep, we need to compartmentalize it, which is true, and we need to eradicate it. But you got to be careful that when you eradicate it, you don't blow up all the evidence that might find the actor. I've seen that happen before. The FBI shows up and says, yep, we're going to take the server and go investigate. They said, oh, about that server. We went and deleted everything because we were certain of the risk. So I think the other person that's important to think about notifying is your insurance carrier. Very often the insurance carriers have a requirement that if you need to notify them immediately. They might have panel counsel resources for you. They might have third-party resources to do investigations. And sometimes if you don't use them, they go, well, you didn't use us, so we're not covering that cost. So it's important to understand what role they play. Sometimes you got to tell everybody. You got to go public. And it's important to know all the facts before you go public. There's a danger in not being sure, and sometimes there's a balance to strike there. I have had circumstances where investigations were opened in various states that were difficult to go through, in part because a client went through, they did their investigation, they thought they had it figured out. We did notification, and then they said, oh, you know what? We just figured out, you know, notification we sent out 3 days ago? We forgot this. We just discovered that we also exposed a whole bunch of passport numbers. So now we need to re-notify. And suddenly the fact that you notified all the state attorney generals in 48 states, they suddenly go, you just gave me a notification last week. Now you're giving me another one. Do you guys even know what you're doing? We're going to figure it out. We're going to open an investigation. That's exactly what happened. So it's important to understand all the aspects about the breach. I'm said I'd get us back on track. We're about out of time. So there's a lot of other information here that you can look through about containment, about validation of the incident, about classification, about who needs to be involved, from the CISO, the general counsel, everybody else. Yes. Okay. Well, Kim says so. All right. So I've kind of outlined here what I think are kind of the 5 key steps of handling an incident. Preparation is the first one. Hopefully we have a plan in place before we even start. The next 2 talk about the first 24 hours. Identifying the incident, which sometimes the incident's been going on, we saw that example, 9 years. Sometimes it's been going on 2 years. Sometimes it just happened last week. But getting your arms around what happened is helpful. Containing it, figuring out how to compartmentalize it and shut it down. That's the first 24 hours exercise. Eradication can take time because sometimes you don't even know what you're dealing with. And I will say sometimes identification doesn't even come through your own people. Sometimes you've got a great tool that says we got a red light issue, we need to flag it. I've also had instances where the FBI shows up at somebody's doorstep and says, you've got a problem. Somebody's hacked your server and is sending and collecting information to a hijacked server, you didn't even know it. So it could come from a variety of sources. Eradication is actually really trying to clean up the problem or the gap. So after you've contained it and said, okay, the information's not getting out anymore, it's not accessed anymore, eradication is let's close the hole. And sometimes that's easy and sometimes it takes time because you need to change systems. And last but not least, here is recovery. Restore the system, get back up to normal. So there's some information here on internal communications. As important as it is to consider what your external communications are, you also got to be careful about internal communications because internal can lead to people telling people on the outside before you're ready. So as part of your plan, you usually got your IT department that has an escalation where they take an incident which is what something is when it's just a something. We don't know what it is yet, all the way up to where it's a breach. And once they determine that it is an issue, then you've got your core team, which is your general counsel, your head of IT, maybe your CEO, all the folks that are going to make the decisions about what to do. As part of the messaging about it, it's important to talk about, okay, do we need to tell people? Is this compartmentalized in the organization, or do we need to share it with everybody so that they know not to be telling the rest of the world we're not ready yet? Conveniently, just in case we didn't make it clear on the first time, I put a second slide in here on making sure you involve your lawyer early. There's other benefits to that, though, in part because we talked about attorney-client privilege. It also includes making sure that in those service contracts for security and consulting and forensics, that is what offers that protection. Usually we do them in three-party contracts where together we'd be hiring that consultant, and I can say it's my investigation. That's how we structure that. So who all needs to be on the team and in the contact list? Your corporate security officer, general counsel, or assigned legal officer. If you have outside privacy counsel, they should be involved. Should have a connection to the insurance team. At some point, corporate communications for when you're going outside. And on your punch list, I recommend having your people there that you update every year on who you need to call, like the call list, your triage list, your insurance people, local FBI office, any key vendor contacts so that you can pick up the phone and talk to the data center person or whoever else, as well as a local computer forensics contractor. It usually helps to already have a couple names in the Rolodex so that you're not trying to figure that out on the fly. So, I mentioned before, don't go public prematurely. You don't want to have to change your message midstream. Make sure your internal investigation can move swiftly and they have the tools they need to do that. I mentioned before the example of multiple notification dispatch arrives. Sometimes you're better, rather than speeding to a notification, you're better making sure you have it right. But even when you do so, there is a delay that needs to be justified. Those windows, so under HIPAA, we've got our rule under HIPAA, and as we talked about in Wyoming on notification, Wyoming statute has a carve out that says, hey, look, if you're subject to HIPAA or some other specific regulatory regime that has its own notification requirement, that's okay. Not every state has that requirement. And if you have patients in multiple jurisdictions, you might have to notify based upon the rules of a number of different jurisdictions. Those rules are changing all the time. This past year, I think I jotted down my statistics. In 43 states, there were over 300 bills dealing with cybersecurity. 2 years ago, 39 states changed their breach notification law. And the final 2 states that hadn't had one yet finally passed one. You know what states those were? I think they were the last 2 states to get the internet. I think it was Arkansas, maybe South Dakota. So I think they got the internet last year and then they added the breach notification. So from an eradication perspective, it's very important to preserve the evidence chain. Capture evidence of wrongdoing, forensically image anything impacted. The FBI or the IT experts can do that. Maintain chain of custody. It's important to make sure you know who is accessing what and when. There's ways of doing it. I can't tell you exactly how to do it. The smart IT people can do it, but there's actually ways to image the server and create a separate duplicate copy and still run what you need to run. Keep the real effective one over here and compartmentalize. Close the outbound channels so data can't get out. Close and patch all vulnerabilities. So from a process standpoint, this is a process that should be in place, including all the stakeholders. Make sure your insurance providers are in there, your service providers are in there. Understanding who your regulators are. And this is a plan that you should be looking at every single year that needs change. Because the service providers you had this year by next year, who knows? They might be bought by somebody else. They might be gone. The contacts move around. It's important to stay up to date on that. So your action plan from today. When you go home and you start talking about this at dinner, these are things to talk about. Inquire about your incident response plan. Review it. If you haven't done it already, follow a stakeholder plan to make sure we talk about what we need to do from a breach readiness perspective. In the first 30 days, update your incident response plan. Make sure your contacts are updated. Make sure you understand the breach notification requirements that might apply to you. Within 90 days, source your external service providers. Make sure you understand everybody's roles. And if you need templates, put those in place. And end of year, this really isn't fair because it's November. That's technically inside of 90 days. But tabletop exercises are common. There's organizations that come in and help do it. It's sort of like the Dungeons and Dragons of cybersecurity. You sit down and you model your incident response plan. You make sure you understand how it works and everybody knows what their role is. Risk assessments at the same framework. When you get back, identify when your next assessment is due, review your last one, look at their shortcomings. Make sure that we've got an accountable party to deal with the next one, and make sure you're making progress on what your vulnerabilities were last time. I talked before about how there's protection in making sure you're moving towards the target. Where there's not protections, if you had a big vulnerability last year and you haven't addressed it, well, now you knew about it. Now you're negligent if you didn't do anything about it. Make sure you have inventory of your data, where it is, how it gets there, access points, endpoints. That's part of the risk assessment. And then conduct your next one. I do a lot of advising of board of directors and leadership on these issues. So I like to include a little bit of just a few key items that I like to throw at them, because management needs to know what we're talking, at everybody who's living and breathing this. I mentioned before that IT and security is very often just viewed as it's IT's problem, and that needs to change, and it has been changed. It's got to be something that is understood by leadership as a risk to the company. It means they have to make regular time in meetings to talk about the risks to the company. It means the security person needs to have an access point to the decision makers. It means that as part of budget discussions, we need to be talking about cybersecurity risks, what the risks are and what the costs are to mitigate those risks, as well as those risks that we can transfer, accept, mitigate, etc. And I like to say that board members should be able to have access to, and the decision makers, cybersecurity expertise, whether it's internal or external. It's got to have regular time on their agenda. So one more set of action items for leadership, which I think applies to everybody. Facilitating a culture that views cybersecurity as a business issue that everybody needs to understand. Everybody needs to own it, because it could be anybody who sends out that email. It could be anybody who gets the email that's a phishing campaign. So everybody needs to be invested in that. Recommend having cybersecurity expertise available to the company if it's not in the company. Have a plan to address attacks and what you should respond. Make sure that we've got insurance to cover risk, both third-party risk and first-party risk. And there's a whole lot of guidance out there, especially by NIST. There's also the National Association of Corporate Directors, which applies generally. It talks about a lot of this stuff. They're great resources for talking about how to implement these kind of plans. And to take home with you a contact information, email. If you have any questions, feel free to let me know. Questions? Yes?
On the ransomware attacks, are those breaches, or are those, if they log it down and they have access, they're portable, or is it?
So the question was, for in case anybody can hear me out on the webinar, now that we have microphones. Yeah. The question was, in a ransomware attack, is that considered a breach? The technical legal.
Are you talking about a HIPAA breach for purposes of HIPAA?
So I would say the technical legal answer is it depends. Because, and they're one of the most difficult things to get your hands around because sometimes they're phony and they don't actually do anything with the information. Sometimes you can't tell if they exfiltrated it or not. So you've got a technical question about, did they actually access the data or were they just able to put a fence around it? I've run into that problem a lot where they say, we can see that somebody tunneled in. We can't see anything going out, but can we show whether they actually saw it? Yeah,
I'll respond briefly. As you know, the OCR put out a publication on responding to, you can get it from the OCR. Go to the OCR website, OCR HIPAA ransomware. And I don't agree with their conclusion, but they said that it was presumptively a breach. Anytime you've got ransomware. Okay. Yeah, they say it's presumptively a breach because their theory is that even though, you know, my argument was they locked it up and there's no evidence that everybody saw it. Yeah, exactly. But the OCR said, yeah, but they had access to it. They used it by locking it up. And so they said, unless you can go in there and do a forensic analysis that shows that they weren't able to exfiltrate any of the information, then it's presumptively a breach. Now, it does leave open the door that if you go in there and do an appropriate audit, that you may be able to rebut it. But their presumption is, you start with the presumption that it's a reportable breach, which is a real hassle. Is anybody from Campbell County here?
Yeah, there's, it's interesting. I haven't dealt with that specifically with ransomware. I've dealt with it in a whole lot of other circumstances where we've had to kind of chew on that problem. And sometimes it's been a problem that is state by state dependent because a lot of the situations I've dealt with haven't been confined to health information. It's been credit cards or it's been social security numbers or it's been travel information. And in that case, you're dealing with 50 different state notification laws which have different triggers. And some of them, it's not a breach at all, very clearly. And in others, you wind up with that question where you go, well, which side of it do we want to err on and what's the risk? And I've used that analogy before that says, hey, look, if you're in the room and I got papers on the desk that you're not supposed to see, if I can't show whether you looked at them or not, where do I lean? Do I need to err on the side of disclosure or not? That ultimately becomes a really fact-determinative analysis, but as Kim said, it's a presumption that if you got in.
Yeah, you can just, I go in there and do it. It's specific to ransomware. Yeah, I go in there and look down. Part of the problem, too, is when you look at, for a reportable breach, you got the four factors. One of those factors is whether or not they access. You would think that that automatically, if they didn't access it, there's no breach. But that's just one of the factors, right? So you could have a breach even if they didn't access it, or at least they didn't actually view it. I think it's the way it's so it's problem.
No such thing.
So it seems to me that, well, I think that way, but let's say you're looking at working here on your phone, and it's an exam. If you open it on your phone, that's the same as looking at the factory disk.
It's not the same. You're in a different system. You're in a different device. It can. It depends on what the malware is. Usually it gets into the email system and it can replicate from there. And if your phone's connected to the email system, it's possible.
So you're looking at working on the phone.
It could.
You respond to it. Or it could.
It's easier through a home-based IT system, but on the phone it can still happen. Phones have become a target lately. You're getting more and more stuff trying to spread through phones. It's a little harder, but it can still happen.
You open the email that don't display.
It depends. Legal answer, it depends.
Ask Kevin. Kevin can tell.
Don't click the link. Yeah. Clicking the link is usually the big problem, so that's what starts the download of all the bad stuff.
I get all the same Apple stuff from my account and I open it.
Yeah. If you're not clicking the link, you're doing all right.
But even if you put the big equipment from the phone.
Yeah, I think it can.
It's small risk, but
yeah, but it's still. I don't want to say it. I mean,
they're getting so much smarter. That's why they can.
Yep. I'm going to turn the helm over to Kim.
All right.
To finish us off.
Kevin, any additional thoughts from an IT perspective on this stuff? You got kind of the legal perspective. Do you have any IT guidance on that?
You guys are right on it. I think our organization was doing a lot of the things We talked earlier, I think the most vulnerable part of this is the people, because we're the ones that can make the mistake easily, unexpectedly, and do a lot of damage with no intent. So, just have to be careful with what you open.
Yeah, it's scary, and those are awfully convincing these days. I got one earlier this week that I was lucky I didn't open it, but it sure looked like it.
Work for senior consultation, security, resources for any hospitals and senior consultation. To help with
So, yeah, so for those who are on the internet or in the webinar land, Christy mentioned that there's a resource in AHA that they can help respond to these cybersecurity issues. All right. There you go. So we are connected to the people on the webinar,
We
right?
are, so this line is picking up when broadcasting out, it just doesn't go.
Okay. See, I was hoping to take a vote and see whether you guys just wanted to go home, but I guess that the people here, but you can vote with your feet. You can still leave if you want, if anybody wants. I would not be offended in the least, because quite frankly, if you all left, then I could get to Denver and catch my flight a little bit earlier. But I'll tell you what, I'll go fast for 20 minutes. I'll cover, I think we're supposed to end at 4:30, so I'll go relatively fast. I wanted to cover a little bit about collection issues, because in dealing with my clients, I think that there's a lot of kind of misconception out there. So I wanted to kind of go back to the basics on what you can do when it comes to collection. The general rule is, hey, patients are responsible if they get care, either because they've agreed to it, they've got a contract with you, either written or not written, to provide the care, or you provided a benefit to them, and you can, under the law, recover the benefit conferred. Now, you've got to make sure that, you really do have that agreement that you've got consent for it, because you can't provide care without their consent and just send them a bill. But generally, the patient, if you provide the care, they're responsible for the care. What about minors? Well, if you provide care for the minors in Wyoming, as in most states, minors who are, minors by definition, are under the age of 18, right? If they're emancipated, they have the legal right to discipline the contracts. You can't make a minor pay for their care if they don't want to, even though they come in. Now, if the parents may still have a responsibility to pay for the care, even though they didn't agree. Under the Wyoming statute, it generally says the parents are liable for the necessary care rendered to their child. But it's better, rather than having to sue the parents under this particular statute, just make sure that you get parental consent and you get an agreement that they're going to pay for the care. What about other third parties? Well, for other third parties, they're not responsible for the care unless they agree. Either you have somebody else bring the patient in and they agree as the guarantor, or you've got an insurance company that signs up to agree, or you've got a government payer that signs up to agree. Generally, though, these third parties, they're not responsible unless you get some kind of a contract that requires them to pay for the care. I get this question sometimes. Somebody came in and they're not paying. Can we go talk to their parents, or can we talk to third parties in order to try to get payment from this particular patient? And somebody will say, no, minor came in, we can't contact the parents to get payment. That's not the case. Under HIPAA, you're allowed to use or disclose information for payment purposes, as long as you haven't agreed otherwise with the patient. So never agree otherwise with the patient. As long as you haven't agreed otherwise with the patient, you can use or disclose their protected health information for payment purposes. And the FAQ that was published by the Office for Civil Rights, they specifically said, yeah, you can use the information to, say, contact a spouse, contact parents or guardians in order to get payment for the care that you rendered. You can use it to contact the collection agency. You just got to use the minimum necessary. So don't get caught up in that you can't disclose the information just because it's HIPAA. When it comes to collection, actually going after the patient, you got your informal collection processes, right? And you got your formal. The informal are basically the patient agrees. If the patient refuses, then they don't pay, then you may have to sue them and go through the formal process. The best thing to do when it comes to your collection process is make sure that you've got good collection payment policies in place. And make sure that you're giving that out as part of the registration process, the form that they sign, that explains your payment processes. Because if you've done that, it helps you for two reasons. One, it can establish a contract where they're obligated to pay you according to those terms. Two, it handles kind of the expectations. Patients get frustrated when, there was a quote I heard sometime that expectation minus reality equals frustration. Well, if you get that expectation up in front, they know what the rules are up in front, and then you follow up with it. Okay, they may not like it, but it's kind of hard for them to dispute it, okay? So make sure that you've got appropriate payment policies, including things like the payment is due, including copay for the time of service, unless alternative agreements are made. The practice will file the insurance claims as an accommodation to the patient, but the patient or guarantor remains responsible for the payment, even though that may or may not be okay in the balance billing. The statements are mailed out every 30 days, and the balance is sent to collections after, 90 to 120 days. Make sure that in your payment policies you specify if you're going to charge additional fees. In doing that, though, make sure that it's consistent with any government or payer requirements. They may limit your ability to charge additional fees. Because, for example, if you're contracting with the Blues or a carrier, they're saying generally that you've agreed that you're going to collect X dollars for this service. And if you start adding on these other fees, they'll say, no, you can't do that because that's additional stuff. So make sure you're looking at that when you're negotiating with the payer up front, and also when it comes time to doing the collections. There are certain laws that may limit your ability to charge additional fees, like for Medicare and Medicaid. And the Medicare and Medicaid, you generally are able to charge like late fees or those types of things. Medicare will allow you to charge a no-show fee, but you've got to make sure that that bill is going to the patient, not to Medicare. There's certain requirements on that. Can you condition services on payment? Sure, you guys aren't slaves. You're not required to provide care, subject to certain limitations. Obviously, if you're a hospital, then you've got the EMTALA requirements. You've got to take all comers if it's an emergency service. But that doesn't mean you can't bill for it. Even if it's an EMTALA patient, you can still bill for it. You may not be able to get any money, because you can't get blood from a turnip, but that doesn't prevent you from trying to collect from the patient. If you've got a contract obligation, you may have, for example, contracted away your right to collect from the patient for like balance billing. Maybe your contract says that you'll accept it as payment in full and you won't balance bill the payment. So if you contracted away your right to collect for that from the patient, you may be limiting yourself. Certain organizations have charity care obligations like public hospitals, 501c3s, but even then, it's usually you only have to provide a certain limited amount of charity care. So you just have to be aware of that. Generally, you can refuse to provide care to the patient, aside from those exceptions, but you can't abandon the patient. So, for example, if you've got a patient who's right in the middle of a course of care, but they stop making payments, you've got to be really careful about just terminating them cold turkey. There's a theory out there that's called patient abandonment, which says, hey, once you assume the care of the patient, you assume duties towards that patient. And if you suddenly refuse to provide care and that patient is damaged, that patient may be able to come back and sue you on that. I couldn't find any cases in Wyoming dealing with patient abandonment, but it's pretty common in other states. And in the Wyoming Medical Practices Act, it actually says it's unprofessional conduct for a physician to improperly terminate a physician-patient relationship. So in order to avoid patient abandonment claims, you generally have to give the patient advance notice an opportunity to transfer their care to somebody else and provide necessary care in the meantime so that they're not injured. Now, if this is, you're running a primary care clinic, the person comes in for one day a year for a common cold, there's not much damage if you refuse to provide care or cut them off from the practice. On the other hand, if you've got a woman who's 8.5 months pregnant, she's going to deliver, you may not be able to cut her off because she can't go to anybody else. If you've got somebody who's in the middle of getting a cancer regimen and, they stop paying, but there's really no place else for them to go, you may be limited in your ability to cut them off unless you give them adequate time to transfer their care and provide necessary care in the meantime. Sometimes the practice will say, well, we're going to hold up your records. We're going to hold your records hostage until you pay your bills. You cannot do that. That's a HIPAA violation. The OCR is very specific about that. Patient has a right to access their information. You can't hold their records hostage for them. You should have financial hardship policies. If you're a hospital, you probably need to in order to comply with, if it's a 501c3, you must in order to comply with 501R. For just regular patients, practices, physician practices, you'd ought to have a financial hardship policy. If nothing else, it will help you satisfy those requirements that we talked about earlier about waiving co-pays and deductibles if you can show that you complied with your financial hardship policies. When it comes to calling a patient to collect against them, make sure that you're always professional. You don't want to be accused of harassment. I mean, there's kind of the practical public relations stuff, but there could also be certain legal aspects of it. For example, under the Telephone Consumer Protection Act, it limits your ability to use robocalls in order to, have collection messages and things like that. Generally, you can't use robocalls for certain pre-recorded calls to residents or wireless numbers unless you've got the patient's consent. Now, there is a HIPAA exception that allows you to use pre-recorded calls for healthcare purposes, but that's things like appointment setting and things like that. You can't use that. It most likely will, almost certainly will not apply to like collection and those types of things. So generally, the TCPA would generally prohibit those types of uses unless you get the patient's consent. And I doubt that the patient's going to give you consent to deal with those situations. Remember that when you're dealing with government payers, if you're dealing with private payers, it's a matter of contract generally. Once you go get in bed with the government, whenever you accept government payments, there's always strings attached to that government money. So once you're dealing with the government, you got to make sure that you're complying with all the government regulations, including those dealing with coverage, balance billing, payments, repayments, and all of those types of things. On the other hand, if you're just dealing with private payers, your blues, it's all a matter of contract. I get calls all the time that say, well, this private payer says this or that or the other. They're telling me this. It's a matter of contract. What does your contract say? If you can negotiate with them, you can negotiate those terms. But ultimately, you have to go back to the contract and see what you agreed to. You can place terms and conditions in there. When it comes to balance, everybody knows what balance billing is, right? When it comes to balance billing, Wyoming doesn't have a balance billing law, right? I looked for it and I couldn't find it. So generally, when it comes to the government, the regulations, if you agree to deal with the government, you've got to comply with that. And you generally tell the government that you can collect co-pays and deductibles, but otherwise you can't do balance billing against the patient. There are certain circumstances, if it's non-covered services, as long as you give the advance notice, then you can go against the patient, but you got to comply with those government rules. If you're dealing with a private payer, all a matter of contracts. Got to look at the contract. Normally, the contract will say that you'll agree to accept the payment in full if you are in network, if you've agreed with them. If you're out of network, you've never entered into an agreement with that particular payer, then you're not bound by those payment terms. You didn't agree to it. You're not in network. Now, there can be situations where you have unintended acceptance of the insurer's terms. This is something that's kind of becoming a hot issue, and I've seen it several times. General rule is it's a matter of contract, right? If you're out of network and you didn't agree with the payer on this thing, you can do whatever you want. You can balance bill or whatever. But sometimes now what we're seeing is the slippery payers, they are sending you like notices that'll say something like, by accepting payment, you agree to these terms. And then by accepting the payment, you've agreed to those terms. If they've made this offer to you, you've accepted by accepting the payment. And sometimes it'll be on the back of insurance cards. Sometimes it'll be in some kind of a letter that you might get back from the payer. And you've got to watch out for that. You've got to train your payment staff, your registration people, so that they're checking that stuff so that you are not unwittingly limiting yourself by accepting those terms. You don't have to accept those terms, but if you do, according to the terms that are set on that, then you may be bound by that. So make sure that you're watching out. Have any of you seen that come up lately? Yeah, it's a real hassle, isn't it? Maybe it's a real struggle dealing with them back and forth on whether or not that occurs. Under the law, there's something else called accord and satisfaction. This is actually in the Wyoming Code. It's part of the UCC. This basically says that under certain circumstances, if there's like a disputed claim or the debt is challenged, then if somebody sends you a check, and on the bottom of that they say payment in full, and you accept that, you negotiate that check, you cash that check, then under the statute, you are deemed to have accepted that disputed amount as the amount of the bill that's owed. And so by doing that, you got to watch out for those checks because you may be cutting yourself off from additional money you're entitled to. Now, the accord and satisfaction under the statute only applies if the debt was the debt was undisputed. It doesn't apply if the debt is undisputed, so it's amount certain. It doesn't apply in certain other circumstances. For example, if you get that kind of check, as long as you reject that payment within 90 days, or if you gave prior notice to the debtor that you can only accomplish an accord of satisfaction if you send this notice to a certain person at your particular facility, you can avoid those situations. But otherwise, you've got to be aware of this. Have any of you faced this situation in the organizations? Okay, there you are. You've got to be aware of assignment. You know, you guys always take assignment, right? Well, what does assignment mean? Assignment means you step into the shoes of the patient. And so you have now a right to pursue the payer for the rights of the patient. But the other side of the assignment is, okay, you step into the shoes of the patient, that means you're subject to any of the limitations that apply to the patient. So if you're going to accept assignment, that means you're also going to accept those limits that are on the patient. Now, that means that if there are certain terms or conditions in that insurance contract that say that the patient must submit the claim within a certain period of time, or this is the only amount that we'll pay, or those types of things, or you'll accept our payment as payment in full, by stepping into the assignment, you may be limiting yourself to those terms. So be careful about accepting assignment from the patient because you may be limiting those terms. Something that we're seeing quite a bit more of is ERISA issues. If you're contracting with an ERISA plan, an employee benefit plan that's governed by ERISA, there's a couple of groups that are going around nationwide and they're negotiating these payments with payers or with providers on behalf of these ERISA plans, and they will send you, and they said, we've looked at this and we think that the only reasonable charge is Y dollars. And that's the only amount we're going to pay. And by the way, you know, because you accepted assignment, if you want the assignment from the plan, in order to appeal that, you should have filed an appeal within a certain period of time, and by then it's usually long past the appeal time, and so they're trying to screw you guys out of a bunch of money. Have you guys received those kinds of notices? If you are, be careful about that. Now, that's particularly problematic because generally those types of limitations are enforceable under the ERISA law. It's a federal law, and it trumps contrary state law. Now, what you can do around that, to get around that, is refuse to tender the claim directly to the payer on behalf of the patient. Instead, you tell the patient, no, you pay us, and then you get reimbursed from the payer so that we don't have, you know, step into those shoes. Or alternatively, if you've got enough market power like, you know, CRNC or something else in the area, you can go back to those employers and say, look at your third-party benefit administrator, your administrator is screwing us out of money. We're not going to continue to provide care for your particular patients unless you get this straightened out. And I've had some success where the payers go back and they don't like that. The employers go back to their plans and say, no, we're not going to you know, we don't want you doing this type of stuff. So watch out for that. That's something else that's out there on the horizon. Generally, if you've got a patient that comes in, you can always require a guarantor that a third party agrees to be responsible for that payment. If you are going to do that, that's fine. Just make sure that the guarantor agrees that they're going to be responsible. Hopefully, make sure that they agree that they don't have to go against the patient first, but you can go against either the patient or the guarantor. You can allow your patients to do payment plans. You're not obligated to. Be careful. If you are going to do a payment plan, make sure that it's written out. Make sure that you cover the relevant terms. But you've got to be careful about having a regular practice of entering into these payment plans, because if you do it on a regular basis, you may become basically a provider of consumer credit, and you may then become subject to a lot of the laws that apply to like credit card companies and those other companies, like the Truth in Lending Act, the Equal Credit Opportunity Act, Wyoming consumer credit laws that have limits on the amount of interest that you can charge, about the notices you have to provide, and things like that. It's usually not a problem unless you're going out and offering these types of payment plans in advance instead of just trying to collect your own debt afterwards. Discounts, we talked about that earlier today. Beware of the anti-kickback statute and the civil monetary penalties laws when you're offering discounts, whether that's writing off co-pays or deductibles. Generally, you need to have a showing of financial need. Prompt pay discounts, we talked about that. Self-pay discounts. Professional courtesies. We'll talk about professional courtesies here real quickly. A lot of times the practices will offer professional courtesies to other providers in the area, or the hospital will offer professional courtesies to its medical staff members. Does that raise any red flags for you? When they're not charging those other people because it's a professional courtesy. For those of you who were here this morning, the rest, the bells and the whistles ought to be going on. You give remuneration to patients or to other providers, and that means that you've got to be concerned about the anti-kickback statute. If it's another position, you've got to be concerned about STARF. STARF actually does contain a professional courtesy safe harbor, but if you're going to do that, you've got to comply with these requirements. It can't be done by an individual physician practice. You've got to have a group practice. You've got to have a written policy in advance. You've got to make it available to everybody in the area, not just to those good referral sources. So don't be offering professional courtesy unless you've got this policy in place. Be careful along those lines. Be careful of, do you even do this, that for your employees, we'll, as an additional employee benefit, we'll allow you to come and we won't provide you, we won't bill you for certain services. Do we need to do something like that or allow them to get certain services at your facility for free or discount? Well, if you're doing that for your employees, that is an additional benefit, and that is usually going to be taxable. And you will need to tax them on that benefit unless you're running that benefit through a qualified employee benefit plan that's not going to be taxed. So just be aware of that, especially for the physician practices. I see them doing that all the time, just being good people and don't realize, hey, that's taxable. You're supposed to be paying taxes on that stuff. Paying patients premiums, this is kind of a hot issue, especially in this age of high patient deductibles and that type of stuff, and in the age of the Affordable Care Act and insurance exchange. You've got a patient who needs a very expensive surgery, the hospital will make $100,000 on this. Well, but the patient, they lost their job. But what about if the hospital makes their COBRA payment, right? They pay the $5,000 for the COBRA payment, so we pay $5,000, but we get $100,000 from this surgery. Can you do that? Well, maybe. Are you offering a benefit to that patient? Absolutely. That means you have to be concerned about if they're a Medicare beneficiary. You have to be concerned about the anti-kickback statute. It's called the Civil Monetary Penalties Law. The government in an advisory opinion did okay it in certain circumstances, which you would want to check. What about if they're not a Medicare or Medicaid? What about if they're private? Or what about if they went out and just purchased insurance on the exchange? Does that implicate the anti-kickback statute? Well, that question actually went to Secretary Sebelius, and she said, no, it's the anti-kickback statute. It's actually kind of hilarious. So she said, no, the anti-kickback statute doesn't apply. You can go ahead and do that. And like within 2 days afterwards, her underwriters must have found out, and they were like, oh, good heavens, what did she say? So they sent out this other letter after this and said, no, we don't like that practice. It carries a lot of problems. It may not technically violate the anti-kickback statute, but it screws up the whole actuarial process, and it'll make Obamacare fall. And therefore, although we're not necessarily telling you can't do it, we don't like you to do it. But you insurance companies ought to put in provisions in your policies that say that third parties can't pay the insurance premiums. So as a result of that, a lot of those insurers on the exchange have provisions now that will not allow third parties like hospitals or other people to pay the insurance premiums. Can you pay COBRA premiums? Well, actually, it suggests that the regulations of the commentary of the company seem to say that you can. They seem to say that they contemplate a third party paying the COBRA benefits, so you might actually be able to do that. Bottom line is just stay tuned to these types of things. We're out of time. When it comes to collection agencies, just be careful. Generally, you're not liable for what they do, but if you hold them out as your agent, you may be liable. Make sure that you've got good contracts with the collection agencies. Make sure that they are complying with the laws applicable to collection agencies. Those laws applicable to collection agencies normally don't apply to you guys in collecting your own debts most of the time. There are some limited situations where they may come over and apply to you, but just be careful. Make sure they're a collection agency and they're doing it on your behalf. You've got to get a business associated with it. Or that is all that we've got time, or I've got the stamina to cover. So thank you all very much. You guys are terrific for sticking around. It's a long day.
And I'll just join Kim in thanking you all for being here, thanking Cheyenne Regional, Kevin, who ran our tech stuff all day with Greg, and I hope you had a great day. I hope it was worthwhile to you. And please follow up with any of us if you have questions. We'd be happy to help you out. Thank you all.